have my laptop so I can.
Oh,
Karen,
This is a different hearing.
no, I thought this was you.
the applicant
That's,
has a
oh,
PowerPoint
that's,
I think
that they
that's
would like, I
Kelly.
can either forward it to you in email, or they,
where?
On her Starbucks cup.
oh, okay, so that's a Chris,
Bring me a
would you
Starbucks.
rather have the email, or do you want the junk drive? Okay, all right, sounds good.
Go get some creamer, or we start?
We're trying to get this,
Okay.
um,
Good morning. I apologize for the delay in getting started. We were having an issue with the Zoom, and we're going to resolve that before we get started. Thank you.
So if, I have no idea. She just said she was gonna go find somebody to help her. Okay, no, it's fine. It's good. Over. I got the coffee, I got the soft drink, I got the protein drink.
Craziest thing I've ever seen. Sorry for your loss. Proud leader. That's if I had bet my. I mean, he said. Idol tells you once you become coach.
So, I need to tell these people. It looks like there are 16 people in the,
Okay, let's get started. The clerk's office, let me know when you're ready. Thank you. All right, let's go on the record. Today is November 20th, 2025. We are here in Freeport, Florida for the quasi-judicial hearings for Walton County on major development orders. I am Suzanne Van Wyck, the administrative law judge presiding today for these quasi-judicial hearings, including the public hearings. The process we're going to be following today is set forth in Walton County Ordinance 25-07. We will begin with each project, a presentation by the county, followed by the applicant. If there is opposition, if there is another party, we will take their presentation following the applicant's presentation. All testimony will be sworn and subject to cross-examination. Following the presentations, I will open up the public hearing for each project. Speakers will be limited to 3 minutes pursuant to the county's procedures. If there is a representative of an organization that wants to speak on behalf of all of its members, that representative will be granted 10 minutes to speak. They can ask for longer, and I'll rule on that on a case-by-case basis. I do not make any rulings today on any of the particular applications. My recommendations will be made to the Board of County Commissioners in a written recommendation within 20 days. If the parties wish to file proposed orders, that gets extended to 30 days. There was some confusion, it sounds like, at the end of the meeting last month with regard to the Echelon project, which we're going to take up first. Since I granted a continuance in that case, there had been a request for members of the public, I guess, as well as some of the expert witnesses who had definitely traveled from out of town to appear by Zoom today. I did grant that request for the expert witnesses to appear via Zoom. There was discussion of the public being able to appear via Zoom. We have looked back at the video this morning. That's what the delay is. Apparently, I did not grant that request. And I have been informed that the Walton County Commissioners' procedures do not allow the public to participate via Zoom. They do live stream the meetings, and there's also, I think, perhaps on YouTube, the meetings could be viewed. But if members of the public wish to appear at the public hearing portion on any project today, they do need to be present. So I just want to clarify all that for the record. All right, let's get started with first one on the agenda, 25-1503, the Echelon project. This is MAJ 25-000034. If council would please make your appearances for the record.
Brooke Davis on behalf of the county, Your Honor.
Thank you, Ms. Davis.
Stephen Tatum on behalf of the applicant, H&S LLC.
Thank you.
Morning, Your Honor. Kent Seyfried and Jared Young on behalf of some of the adverse affected parties.
Okay, Mr. Seyfried, would you give me your address for the record, please?
Yes, it'd be 119 South Monroe Street, Tallahassee, Suite 500.
All right, thank you. All right, if there's nothing else preliminarily on this one, then the county can begin with your presentation.
Brooke Davis again on behalf of the county. I just want to take a second and kind of do a bit of a opening statement just to sort of set the scene of what this is.
Okay.
So at this point, this is a project that's being proposed on a parcel within an overall DRI. There's the issue of potential entitlements for this condo building coming in. You're looking at potential up to 250 units of, that's what the county's perspective of the entitlements. There's probably going to be some discussions about setbacks is another issue that we've seen moving forward through the project. So there's also going to probably be some discussion of whether traffic need to be taken into account and things. So there's the overarching DRI, and there's some history with that DRI that you may hear about as well. But overall, the project is for a building with an attached parking garage that should accommodate close to 250 units. So,
Okay, thank you.
I can call Ms. Kelly Schultz to the stand.
Ms. Schultz, if you would please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, and please state and spell your name for the record.
It's Kelly, Kelly, Schultz, Schultz.
Thank you. You may proceed, Ms. Davis.
Ms. Schultz, where do you work currently?
For the Walton County Board of County Commissioners in the Department of Planning and Development Services,
And what's your current job title there?
current planning manager
And how long have you worked for Walton County?
for over 4.5 years.
Do you have any prior history of working in planning?
I do.
And approximately how long?
Almost 30 years.
And have you taken any kind of classes, any kind of certifications regarding your work with planning?
Yes, I have. I'm actually a member of the American Institute of Certified Planners, also known as AICP. And I have taken a number of just general planning courses. It was in North Carolina through the University of North Carolina Institute of Government, and for things like subdivision, zoning, and then I also have certification as a certified public manager, and then just various trainings through the years since I became AICP, because we do require continuing education to maintain our certification.
How often do you work with the Walton County Comprehensive Plan and Land Development Code?
5 days a week.
Not weekends?
Sometimes.
How often are you asked to interpret the comprehensive plan or the LDC?
Well, as my position, I don't do official interpretations, If something official's needed, then that goes through the director, but I do, in essence, interpret the code when I read it and when I apply it.
Have you previously testified regarding the comprehensive plan, the LDC, or planning in general?
No.
You've never testified in
Oh,
any,
I'm sorry, I thought you meant it at this venue. Yes, I have.
approximately how many times?
Oh, gosh, over the years, 10 maybe.
Have you participated in any updates to the comprehensive plan or the land development code?
Only from a review perspective. Provide an input to amendments.
And approximately how many times have you done that?
At Walton County?
Right.
4 or 5 maybe.
Judge, I will say at this point, Mr. Tatum has stipulated that Ms. Schultz is an expert in the Walton County Land Development Code and Comprehensive Plan, as well as within planning.
That's correct, Your Honor.
All right, so she's being tendered as an expert in the Walton County Plan and Land Development Code, as well as in the field of urban planning.
In the field of planning, so in the land development code and the comprehensive plan,
All right, so accepted.
unless Mr. Seifert, I think
Oh.
he's demonstrated enough party
No
status.
objection, Your Honor.
Okay, thank you. You may proceed.
Ms. Schultz, if you can take a moment and read into the record for us the introduction to your staff report.
And just bear in mind that we usually read more quickly than we speak, so make sure the court reporter can keep up with you. If you'll let us know if you're having any difficulty. Thank you.
So this is a request to approve by final order. The project number is MAJ 25000034. I reviewed the project. It is a major development order application submitted by Jenkins Engineering Incorporated on behalf of H&S LLC, requesting to develop 246 units. It's a condominium building with associated amenities and infrastructure as part of the approved Seascape DRI on 5.62 acres. The project site has a future land use designation of mixed use and a zoning category of coastal center. The project area is within the Seascape DRI, which is in District 4. It's located at 100 Seascape Drive. It's identified by the parcel number in the staff report. And we would like to enter that staff report into the record if that's okay.
We'll get there.
Oh,
Okay.
okay.
Thank you.
We'll wait and let your attorney move it.
Okay, thank you. Of course, I have it.
Ms. Schultz, can you explain the process for how this particular project has actually arrived to this moment in time in front of the magistrate?
You want me to go way back to the?
We don't have to go through the whole DRI process, and all, but as far as where we are with the application for Echelon itself.
Yes, let me grab my notes real quick. So as with all development applications, we had a pre-application meeting last July. And during that time, we ask questions, we provide some feedback, we provide the applicant with an actual application and submittal checklist. And it does have some general notes in the pre-application section of the application. They did not submit the actual application until February of this year. It went to the technical review committee, which is the staff, is derived of staff members.
Let me interrupt you at that point. So the technical review committee, that's comprised of who?
The project is sent out to, I don't even know how many, 30, 40 people and a lot of those folks, it's not just internal staff, there are external reviewers too. But there's a core group that traditionally provides feedback. That is, of course, the planner, which would have been me, and there is engineering, environmental staff, surveying, our right-of-way. There's an actual engineer review and a traffic review, which is done by a consulting engineer, or at least it was at that point in our review process. We get comments back from the health department, floodplain. Don't know if I've missed anyone, but there's a wide array of expert people who are subject matter experts who provide the feedback. So the planner's not the only one that's looking at this application.
And
Let me
Ms.
just-
Davis, the composition of your
Staff report.
TRC is probably in your code, correct?
That's correct.
Okay, thank
That's
you.
correct.
I did miss mosquito control, fire department, Eglin Air Force Base, the school board, code enforcement, GIS. But all of those different departments, they either provide feedback in the form of comments, which are things that need to be addressed, or they provide us something in writing saying there are no outstanding comments for their area of expertise.
And your staff report would reflect those different areas of review that have been done.
Yes.
Did these reviewers, did they provide you comments regarding a project?
Yes, and they also provide, if they might provide comments of things that need to be addressed. They might also provide conditions of approval. And it gets a little confusing when you're talking to folks that don't work in our department because they sound similar. A comment, again, is something that's a deficiency, if you will, or a question, something that needs to be talked about a little bit more, or possibly some changes to the plan. Conditions of approval won't keep the project from moving forward, but before the final closeout of that project, those conditions have to be met. And in this case, all of the comments were resolved, but there are 21, let's see here, 27 conditions of approval from the various areas of expertise.
And those conditions or approval are also reflected within your staff report, is that correct?
They are,
And they've been provided in a proposed final order.
yes.
Okay. All right, so after we go through the TRC process, what happened next with this project?
So after that, the project went to the Planning Commission. Now, this was one of the first projects that went through the QJ process. So this one, and there were several others that it got a little confusing. So if you look at the timeline in my staff report, which is on page 6 of the staff report, you'll see that it went to the Planning Commission in July. And then there were some concerns expressed at that meeting about notice. So the chairman asked to continue the project. In the meantime, it was already scheduled to go to the Board of County Commissioners. So we had to continue that because the Planning Commission had continued it, and we needed their recommendation to move forward to the Board of County Commissioners. So then in July, we go back to the Planning Commission, and they actually recommended denial. The vote, there were, let's see, 4 Planning Commissioners who recommended denial, and then 3 voted against that motion to deny the project. So it was a split vote of 4-3, but again, that motion was to deny the project. So then we go back to the Board of County Commissioners, but at that point in time, there was some confusion or some concern about whether or not a quasi-judicial project could automatically come to the Special Magistrate, or if the Board of County Commissioners had to authorize the project to come before our administrative law judge. There was a continuance because a meeting was canceled. And then finally in September, the project was authorized by the Board of County Commissioners to come to this forum. And then we anticipated, because we thought we were going to go come to this meeting earlier. We had already anticipated a Board of County Commissioners meeting date, so we had to continue with that again. We finally made it to this forum, the administrative law judge, on October 23rd. And if those of you that were here will recall, the project was continued to this November 20th meeting.
And what was the date of the application again? I know you stated it and I didn't catch it.
The application was deemed complete on February the 6th of 2025. I say that there may be a different date in the system, but we don't deem it complete until all documents are provided. So there may be a discrepancy between what you see in Intergov and what's in my staff report, but the February the 6th was a date that it was sent out to the reviewers that are part of the technical review committee.
Thank you.
You're welcome.
So I want to be clear, this particular parcel that this proposal is for, this is within a DRI, is that correct?
That's correct.
Okay. What DRI is that?
Seascape Resort.
And approximately when did that DRI come into existence?
So the project has a history prior to becoming a DRI. There are certain things that I don't have a record of, but I know that even back in the 70s, 1973, actually it was September 7th of 73, the owner at the time filed a request, an application with DCA to request that it be vested.
And to be clear, what's DCA?
Department, actually, what was it called at that point in time? It was called the State Planning Agency, State of Florida Department of Veteran and Community Affairs, Division of Local Resource Management, Bureau of Land and Water Management. And so the department's name has changed over the time, but basically it was the State Planning Agency. And so they were.
With filing with that state planning agency, what did that allow?
Well, there was some review back and forth, and finally in 1981, the state issued, or they acknowledged the vesting of the project, and at that point, they authorized them to have 760 dwelling units on, at that point in time, it was a 235-acre property. They got a little bit more specific, and they said, there was a map that said Section A is allowed to have no more than 418 units. Section B is allowed to have 342 units. And then it wasn't until February the 14th of 84 that Walton County Board of County Commissioners adopted an ordinance. It was Ordinance 84-1, where they approved the Seascape Resort DRI. However, about a month later, it was March the 30th of 84, DCA appealed Walton County's approval. They appealed Ordinance 84-1. Later that year, on October the 30th, that again was 1984, Walton County responded to the appeal and adopted, let's see if I have that ordinance number.
It's safe to say
I
they
do have it, but I just don't
they
have it written
adopted
down.
a new ordinance with a section specifically addressing this DRI.
Yeah, they addressed, it was actually in the ordinance, it was section 3J, and it was to address the concerns that the state planning agency had expressed in their appeal. And so then that ordinance, once the revised ordinance was not appealed again, so they satisfied the state planning agency's concerns with that revised ordinance.
And what was the year of the revised ordinance adoption?
It was October 30th of 84, and if you want the ordinance number, I do have it. I just need to pull the
Thank you.
notebook. Okay. All right.
So as of 1984, the parcel that Echelon is proposing to encompass, what were the entitlements that were given to that parcel?
So they approved basically 2,500 residential units.
2,500?
2,500, yes. And there was also some other approvals. You know, there was some commercial approvals, but it talked about condominium units in that 2,500 entitlement, if you will.
So at what point were there specific entitlements for only this parcel?
So in 2000, August the 8th of 2000, the county adopted Walton County Ordinance 2000-24. And that particular ordinance had a map, and that map on this parcel showed a 24-story, 250-unit condominium building. And then at the southeast corner, there was almost a, it was like the corner of it was for 48 single-family units. And then in 2008, there was another DRI amendment. And just to be specific, that was ordinance, let's see here. Sure that I have that in, I do have it again, I can pull it if you need it, but it was adopted October 14th of 2008, and I believe it was 2008-24, I think is that number. But at that point, they removed the single family from the southeast corner, and it was only allowed to be a 24-story, 250-unit condominium building. And again, that is depicted on a map that was an exhibit to that ordinance.
So in your research and knowledge of the county, have you found anything that has disturbed that entitlement to 250 units and 24-story building to that parcel?
No, I have not. As a matter of fact, just randomly, I found a letter from the Northwest Florida Regional Planning Council where there was a question about the entitlements, and at that point in time, they referenced a project that was called, let me look at it real quick, make sure I give the right name. Let's see here. They referenced a project called Sterling Shores Condominiums. And the letter said that the entitlements were basically used by Sterling Shores. Here's the thing with Sterling Shores. There was a development order approved. It was approved on September 2nd of 2005. It was DO number 05-0010140. It was for a 24-story, 250-unit condominium building. And the project was approved. The DO was issued, but the owner never came and executed the development order. So essentially that development order became null and void because without the owner's signature, it was never fully executed. So therefore, those entitlements were given back to the property because they weren't used. If that project had been built, then they would have, obviously there would not be any. If there were any entitlements left, like in this case, they're entitled to 250 units. They're proposing 246. So those 4 units, based on a 2022 amendment, are allowed to be absorbed somewhere else in the development. I mean, the number of units do not go away.
So, Ms. Davis, and under your code, has that development order expired at this point?
That's correct. Well, it was that development order was invalidated because it was never fully executed.
Okay.
So it's not even that it expired, it just never came to full fruition.
Okay, thank you.
So with this development, are we talking about only residential use?
There are some ancillary uses in the proposal, and those uses are only for the occupants of the Echelon project. The 2022 DRI amendment does on some of the parcels, it allows the amenities to be used by all residents and guests of Seascape.
I'm gonna interrupt because you've confused me now. So the last DRI amendment you discussed was 2008. So now you're saying there was a 2022 one?
There have been a number of amendments to this,
okay.
which I mean, I can go through each one if you need me to do that.
Depends on what Ms. Davis wants you to do. I'll let her direct that.
Yes. Okay.
Okay, so there was a 2022 DRI amendment, is that correct?
Yes.
Okay. And in that, was there any commercial opportunity assigned to this particular parcel?
No.
So at this point, what is vested is a residential unit of 24 stories and up to 250 units. Is that correct?
Yes.
Now, with the DRI, I know obviously there's some things about a DRI that are special circumstances that go outside of the Walton County Land Development Code. Is that really what the use is for a DRI?
It was. I mean, there's been a lot of changes over the years to the DRI laws. I mean, I believe it was 2018. 2018. Just kind of my read of the statute is that the state basically turned DRIs back over to the jurisdictions in which they're located, and where they used to be highly regulated by the state of Florida.
Sure, but nothing's disturbed as far as that formation document of the DRI has specific things that they're allowed to do that maybe other places in the county wouldn't be allowed to under the current land development code.
Absolutely.
Okay. Can you give us just a brief as far as those DRI allowances that would be specific for this project?
Yes, I mean, the exceptions to the land development code are density and height, building height.
Now, that takes me, so I know in the staff report, you reference what's called ISR and FAR. Can you explain exactly what those are?
Yes, so there are requirements under the land development code that limit development, if you will. For residential properties, you have a controlling rule that's called density. And then for non-residential uses, you have floor area ratio, which is FAR, and you have impervious surface ratio, which is ISR. And that the floor area ratio is, in layman's terms, it's how much building you're allowed to have based on your lot size. Impervious surface ratio, in layman's terms, is how much of the natural ground you can cover with a surface that doesn't absorb water. So in my staff report, in hindsight, maybe I shouldn't have done it this way, but when I was putting it in the staff report, I put what the maximum requirements, and I put what they had in the site plan, but those ISR and FAR requirements do not apply because this is controlled by density as opposed to ISR and FAR.
And with this project, the density is that entitlement that you were talking about with the 250 units?
Yes.
Okay.
Yes.
So it's not controlled by the Walton County Land Development Code. It's controlled by the entitlement to that parcel. Would that be a fair statement?
Absolutely, through the DRI, the Development of Regional Impact.
Now, also with the DRI, let's talk about traffic for a second.
Okay.
Are there certain things about the DRI that address traffic for this parcel?
So the DRI, yes. So the
I'm going to interrupt. I'm
Yes.
sorry
No,
to
please.
keep interrupting. So you've testified that the FAR and the ISR in the Land Development Code don't apply to this project because this project proposes residential only.
yes.
And then we kind of skipped over density. So what density standard would apply under the code? I think what I'm hearing is you saying that there's an exception from the density requirement under the code for this project because it's governed by the DRI development order. So can you
That's
tell
right.
me what the density requirement under the code is?
Let me see if I put that in the staff report. I don't recall if I did. And I may have to pull the code for what the density is for coastal
Okay,
center.
well then I don't want to slow
Yes,
you
I
down
did. I
then.
did. I did not put that in there. I apologize. I don't know what coastal center is off the top of my head.
Thank you. You may proceed.
so we were talking about traffic as far as the DRI goes.
Okay, so traffic is addressed at the time, at least with this project, it was addressed at the time that it was approved. So, so with Echelon, we call it vested. The traffic was vested because of previous DRI approvals.
What exactly is vested about it?
All aspects, the number of trips, the road system. I mean, it's any type of traffic related improvements are addressed at the time the DRI is approved, and
that entitlement is granted for the 250 units?
yes.
Okay. What about compatibility? Is this something that we need to look at, the compatibility with neighboring parcels?
The Board of County Commissioners, when they approved the DRI amendments to grant this entitlement, if you will, they deemed it compatible, because they basically gave approval, without specifics, for a 24-story, 250-unit condominium building on this project.
What about setbacks?
So setbacks, so it gets a little complicated. So some DRIs, they do have some allowances for reduced or even greater setbacks. Some allow themselves to do their own variances. They basically get to determine their setbacks. In this case, I've not found any evidence that the original DRI nor any of the amendments to the DRI addressed setbacks. So we have applied the current day setbacks to this project. If there was an issue with our setbacks that caused this project to not be built, then then we would have an issue. But that's not the case with this particular project.
So in all of these aspects that we've been talking about, the entitlements for the 24 stories, the 250 units, the setbacks, is there anything in your review and your compilation of all the reviewers, is there anything about this project that doesn't meet the standards that you've recognized?
No.
So at this point, is this project consistent with the DRI?
Yes.
Is this project consistent with the Walton County Comprehensive Plan?
Yes.
And is the project consistent with the Walton County Land Development Code that apply?
Yes, and the latter two are because of the DRI. I mean, I think it's worth saying so that the public understands that if this DRI wasn't approved, then we would be having a completely different conversation right now. But it is consistent because of the entitlements within that DRI approval.
Have you prepared a proposed final order for this project?
I have.
And you've included conditions for approval on the project?
I have all 27, I believe it is, conditions that are listed in the staff report are included in the recommended final order that's been presented to our administrative law judge.
And those are conditions that you gleaned from compiling the staff report, is that clear?
That's correct.
Judge, at this time, I would ask to move Ms. Schultz's staff report and the what we call inserts or attachments that be moved into the record as County Exhibit 1.
Any objection? Thank you. All right. County's Exhibit 1, the staff report with inserts is admitted.
Judge, at this point, I have nothing else to add.
Thank you. Any cross-examination?
Thank you, Your Honor. Stephen Tatum again for the record. Ms. Schultz, just one question. This is really just to kind of clean up the traffic discussion. By saying the traffic is vested, do you mean that once the county approved 2,500 total units for the DRI back in 1984, that traffic created by those units is vested from transportation concurrency purposes?
I'm not the traffic engineer, so I don't know that I'm the best one to answer that. But I do know that based on the report from our traffic engineer, he stated very clearly that, and let me just pull it real quick to make sure. He states that all trips generated by the proposed project are vested under the previously approved Seascape DRI per the, and this is the project number of the latest amendment, which was the 2022 DRI amendment. He says, per the MAJ 22-000006 development order, the Seascape DRI has vested a total of 1,093 condo units, which includes 250 24-story condo units, 200 12-story condo units, and a 643 four-story condo unit. The Echelon condominiums development will utilize 246 units of the vested 250 24-story condo units. The proposed project would reduce the total available units to 847.
Okay.
And that's within the total, within the total boundary of Seascape.
Thank you. That's all I had.
Thank you. Mr. Seyfried?
Great, thank you, Your Honor. I've got some notebooks in front of you, the 3 white ones that contain all of our exhibits 1 through 50. And I've got these over here.
Okay.
I think we'll be bouncing back and forth between the different notebooks to various exhibit numbers. And all of these exhibits, I believe through 38 were previously provided at the last hearing. We have some additional exhibits that we may use throughout this hearing. To the extent we do, we'll provide copies to the county and Mr. Tatum. All right, Ms. Schultz, your testimony that you reviewed this project for compliance with the Comp Plan and Land Development Code of the county?
I did, and just for clarification, because this is a complicated project, we had a prior employee who was, what we called our DRI subject matter expert. She was still on staff, and she also, she walked through it with me just to make sure that I wasn't missing something important.
And who was that employee?
Her name was is Renee Bradley.
Okay, she's still an employee with the county?
No, sir, she retired in January, unfortunately.
And what is your position with the county?
I'm the current planning manager. When I started the project, I was a senior planner.
All right, and part of your job duties are to review and analyze applications to determine compliance with the Comp Plan and Land Development Code?
Yes, sir.
All right, take a look at Exhibit 28 in this notebook, please.
Has there already been any discussion among the attorneys about any objections to these exhibits?
Mr. Tatum and I have agreed that he's seen our first 38 from the last go-round. He has no problem with those. The additional exhibits we'll be putting in a little bit later. He expressed no objection to mine. I expressed no objection to his.
What about the county?
That's the county position as well, Your Honor.
Thank you. All right, which exhibit are we going to, Mr.
We're going to go to
Seyfried?
28.
Thank you.
And do you recognize this document, Ms.
I do,
Schultz?
yes, sir.
Okay. It's the March 5th, 2025 Technical Review Committee Planning Report, right?
Yes, sir.
Okay, did you prepare this document?
I did.
Okay. And with respect, we're going to start talking a lot about setbacks, and that's going to be no surprise to you because we've discussed them before. Page 4 of Exhibit 28, 4 of 11, if you will, right here.
Okay. Yes, sir.
And the additional comments, number 5 is the only comment in the report that I saw that addressed setbacks, correct?
I mean, you may want to rephrase that since you're asking her if it's the only comment you addressed. Let's try it again.
Oh, I'm sorry. Is there any other discussion regarding setbacks in the staff report other than number 5 on page 4 of 11?
Not in this report. This was actually a first draft of a report as the, as we were going through the process.
Right, and we're going to get to the others.
Okay.
And so in this report, as of March 5th, 2025, it was the county's position that the increased setbacks for tall structures did not apply. Is that correct?
Well, and if you'll read on, it doesn't say that in totality. It goes on to say, shall not apply internally to mixed-use developments having a common plan of design. Therefore, standard setbacks are applicable.
So the conclusion there was standard setbacks are applicable.
And this was, yes, and this was talking to, about the internal setbacks.
All right, and what are the,
I'm sorry, where in this report is this discussion?
it's on page 4 of 11, Your Honor,
Thank you.
bottom, it's additional comment number 5.
Thank you.
And when you're referring to, in number 5, you say the requirement for increased setbacks for tall structures. Are you referring to section 5.00.03A1 of the Land Development Code?
I don't have that section number in front of me, so
Okay.
I can't confirm that that's
All
the
right,
right
well,
section.
let's turn to number 24.
Okay.
Exhibit 24, I think it's the 3rd page. It's a sorry,
Okay.
this is a composite exhibit, so it's got a few different sections in there.
Okay.
It says page 2 of 113 at the top. It sets out section 5.0003 building setbacks, correct?
Correct.
Okay. And footnote 1, is that what you're referring to as the additional setbacks for tall structures in South Walton County?
Yes, sir.
Okay. And would you agree with me that this footnote requires additional setbacks of 1/2 foot for each 1 foot of building height above 36 feet?
Yes, sir. For external projects.
External lot lines.
Yes, sir.
Okay, not, because it goes on to say it shall not apply to internally to mixed-use developments having a common plan of design, correct?
Correct.
Okay. And let's take a look at Exhibit 31 so we can get an orientation of interior setbacks and exterior. All right. Exhibit 31 is a printout of the Walton County property appraiser map, or section of it at least. And it shows, does it properly identify the Echelon site?
It does.
Okay. And the south boundary of the Echelon site borders, it appears to be 3 different subdivisions, is that correct?
Yes, sir.
And that would be an exterior lot line, correct? The south border?
Yes, sir.
Okay. Because the east or the west border of Echelon is still in the DRI, correct?
Yes, sir.
Okay. And the east border would be an external lot line as well, correct?
Correct.
Okay. And then the north boundary line would be an internal lot line because it borders the DRI, correct?
Correct.
Okay. So the external lot lines that the setback could potentially apply to would be the eastern boundary and the southern boundary, correct?
Correct.
All right. Since the March 2nd, 2025 staff report, have you had opportunity to discuss the proper setbacks to the eastern boundary and the southern boundary for this project?
Yes.
Who did you have those discussions with?
My goodness, a number of people. Spoken to our planning director, our land use attorney, spoken with the applicant, spoken with you.
All right, and what is the county's position today as to what the proper southerly setback or the proper setback is from the southern boundary line?
It's the standard setbacks from the southern boundary line.
And when you say standard, let's go back to 24 and establish what that is. Okay. right, can you identify what the standard setback is in table 5.1 for the southerly boundary?
Give me a page number again. I'm sorry. Is that 2 of 113?
Yeah, 2 of 113, Your
Thank
Honor.
you.
Thank you.
I need to look at, I'd have to look at the site plan to recall off the top of my head if that southern line is considered a front or a side. So it would either be 20 or 15 feet.
I believe that southerly boundary is determined to be a side, so it would be 15 feet if it's the side.
That would be correct.
And then the easterly boundary setback, which would be the rear, is what?
20 feet.
And that's the county's position as to the proper setbacks today to be in compliance with this code?
There's, yes, I mean, there's additional setback from one residential property, but to the immediate east is a spray field for a wastewater treatment plant. I don't recall the linear footage of how much of the residential lot that is shown on Exhibit 31 borders this project.
All right, you just said the setback was the standard setback of 20 feet from the easterly border, correct?
Yes,
Is that the county's official position, that the setback along the easterly border is 20 feet from the property line?
from the spray field, yes.
Okay. What about the house that borders the eastern property boundary, the Kajanic property that's one of my clients? What's the setback from that property?
I don't recall the exact number. The applicant has a diagram, I know, that helps illustrate it. I just don't have it in front of me.
What did you, as the planning manager in this case, determine the appropriate setback to be in feet from that easterly property?
I really don't recall, sir.
Well, how can you testify that this project is in compliance with the setback requirement when you don't know what the setback
I just don't
requirement
have
is?
the number.
Is it more than 20 feet?
Yes.
Well, how did you calculate the setback number?
We measured it from the property. I just don't have that, again, I don't have that data in front of me.
Okay, well, let's go back to 24 because I'm confused here. You said the setback from the easterly border was 20 feet, the
Yes.
standard. Now you're telling me there's a different setback for the border of the Coppinich property, but you don't know what it is.
No, I don't have that number in front of me, and I don't want to make something up that's
Okay.
not correct for testimony.
Well, does footnote number 1 apply to the Coppinich property since it's single family?
Yes, at first we did not think so, simply because that is it's got 2 full-size homes on a single-family lot, and it's a short-term rental that was listed on the market for sale as a rental property. We did not apply it in the beginning, but after our discussions with you, we went back and looked at it, and we did apply it. Again, I don't have the number in front of
Okay,
me. I
well-
should have prepared with that, but I do not have that.
That's
exact
all right.
number.
We're going to calculate it right now. So under footnote 1 that you just testified applies to the Coppinich property, correct?
Yes.
Okay. It says that increase the abutting setback line for single non-residential uses and single-use multifamily residential uses adjacent to existing single-family residential uses by an additional 1/2 foot for each 1 foot increase in building height above 36 feet. So to figure out this equation, what is the building height of this 24-story condo?
And I don't have that number right in front of me. I'd have to pull the architecturals.
That's all right, I've got that. So let's go to your staff report, which is 42. And is that in that book? Nope, I gotta get you another book.
Your Honor,
Yes.
the discussion was Mr. Seifert's initial 38 exhibits that had been supplied. I don't think that we have discussed further exhibits past number 38.
Okay.
We have not. 42 is the staff report. She just introduces Exhibit 1.
Do you need to look at the staff report in his exhibits to make sure it's the same version? You want to look at that?
No,
Okay.
Your Honor, I just want to make sure that we're clear if we're going to other exhibits within Mr. Seifert's presentation.
Yes. Okay. Well, just make sure you interject with what your objection is. Okay. Thank you.
Okay, and for clarification, Your Honor, Exhibit 42 that's in there does not include about 300 pages of public comment. I didn't reprint all of that out, but it's a redacted version, if you will, of the staff report. Okay, so looking at the staff report, there should be a purple tab on A10. Find it for you.
Does your exhibit have the same pagination as the staff report that's been admitted in evidence?
It does not have base stamps. The staff report that we got did not have base stamp numbers in it, Your Honor. So, and I'm looking at the south elevation A10. Was that tabbed in your notebook, Your Honor?
I was trying not to have to open
If you're looking at
another
the
notebook.
PDF, I have that PDF number.
Okay, great. That'd be helpful.
It is PDF page 70.
Okay, thank you.
All right, are you there, Your Honor?
Yes, I'm going to go ahead and use your exhibit because you're getting to the plans and the PDF. I would have to
Yeah.
move all over the
scroll
place.
around.
So we're at the purple tab then in
Well,
42? Or
You have two purple
48?
tabs or just one?
One. Yes. Okay. Hopefully you have it up there. Oh, okay, great. All right, thank you.
I apologize. I thought I had that one tabbed too, Your Honor.
No problem.
Okay, so A10 is the south elevation plans for the condo, correct?
Yes,
Okay, at the top right, the measurement shows 314 feet for height, correct? And I know it's small.
classes. That's what it appears to be.
Okay, so the building structure is 314 feet in height. So let's go back to Exhibit 24 to do our calculations. Okay, and if we subtract, again, we're back at the table and Exhibit 24, page 2 of 13. So we take 314 feet and we subtract 36 feet. That leaves us with 278, correct?
Take your word for it.
Okay.
I don't have a calculator in front of me.
All right, do you want a calculator? Or do you trust me?
I'll trust you.
Okay, so that leaves 278 feet above the 36 feet, correct?
That sounds correct.
And the set, and under footnote 1, you're required to have an additional 1/2 foot for each of those 278 feet, correct?
Yes, sir.
Okay, so if you divide 278 in half, you would come up with an additional 139 feet, correct?
That sounds correct.
Okay, so applying the additional height restriction, you have an additional 139 feet plus the 20 feet of standard setback, correct?
Yes,
Okay, and so that's 159 feet of setback, correct?
using that calculation, yes.
Is that the calculation you came up with additional for the additional setback?
Well, we looked at it a number of ways.
Well, my
Because,
question first, and we'll get to that, I don't mean to interrupt you, but
Okay.
What number did you calculate for the setback pursuant to footnote 1?
again, I don't have that right in front of me. I don't remember that number.
Can we find out if there's a document that would refresh her recollection so this is going to be more orderly for me?
Yeah, is there a document that refreshes your recollection to the county's calculation of that setback?
I'd probably have to go back to my paper file in my office where I was doing
Okay,
written notes.
all right, thank you.
Well, let me ask you this, did the county ever make a calculation of that setback?
Yes.
Okay.
Yes, and again, I'm sorry, go ahead.
That's okay. Well, I mean, we had discussions on October 23rd following the last,
Council is testifying.
I didn't hear the rest of the question, so I can't rule on that until I hear the rest of the question. Go ahead.
do you recall us having conversations following the last QJ postponement regarding these setbacks specifically from that property?
Yes.
Okay. And you understood our position was it was 159 feet, correct?
I don't remember the number, sir.
Okay. You remember it being an issue?
Yes.
Okay. And from October 23rd up until today, you're saying the county calculated some kind of setback, but you don't know what that number is?
I don't have the number, no, sir, not in front of me.
But we agree now it's 159 feet.
No, I'm not saying that that's what I agree to. Because again, we've looked at it a number of different ways, including the immediate impact on this one single-family lot is the parking garage, which is, I believe, a 60 feet, I believe is the height on that.
The building that is proposed on the site plan is not 159 feet set back from my client's property, is it?
I truly don't remember that number. If I did, I would testify to it.
No, I'm asking you if that building that you're looking at right there is within 159 feet of my client's property line.
I don't see the site plan in the file. Do you have this in here?
All right, let's take a look at applicant's exhibit number 11. Stephen, do you have a paper copy of that? For the witness?
Exhibit 11?
Yes. Maybe one for the judge? Oh, 13, yes, apologies.
Okay, thank you. I've got them on. Don't have anything more powerful than this one.
I'll share exhibit 11, exhibit 13, sorry. This is the applicant's exhibit 13 that they prepared for this proceeding. Now, does that document show that the building structure is within 159 feet of my client's property?
Based on this, no, it does not appear to be such.
Could you orient me as to where?
Yes.
Which,
sorry.
which line are we, boundary line are we referring to here?
If we're looking at it this way, Your Honor.
Well, I need her to testify
Okay.
for me. I see a north arrow on this. Were you talking about south or east? That's really all I need to know.
Ms. Schultz, can you tell the ALJ where my client's property is in relation to this drawing?
So it's there's 15 feet of his client's property that abuts this project on the southeast corner. If you see the north,
Southeast corner.
yes, ma'am. If you see the north arrow on the
Uh-huh.
bottom right of the page.
Okay.
And along that eastern boundary line, how close does the structure get to the eastern boundary line according to the measurements by the applicant on that document?
There's, on this particular drawing, there's not a dimension from the corner of that building to your client's 15 feet.
I'm
of
asking about
property.
the property line to the building.
Okay, from the spray field, it's 20.6 feet. There's 2 points that show 20.6 feet, and there's a point that shows 26.5 feet, and there's a point that shows 57.8 feet.
So the building is as close as 20.6 feet to the eastern property boundary line, correct?
From the spray field.
That's the eastern property boundary line, correct?
Correct, that's not single-family residential.
Okay. Now, how did you apply the setback from the eastern property boundary? Where does the 20 feet start, and where does the additional setback from my client's property begin?
So your client has 15 feet to the south on the eastern property line. And again, the immediate impact of that property is a parking garage that is 60 feet. So 60 feet is, I think if I saw that number correctly in your exhibit, and I would ask, if you don't know the answer, the applicant would have to testify to that at some point. If I have that number wrong, and you back out the 38 feet, that's a 22-foot setback from the 15 feet of the residential lot.
Okay, you kept saying immediate impact. Can you show me in 5.00.03 building setback requirements where there's some kind of exception to the setback rule for a property boundary line for immediate impacts?
No, it doesn't say one way or the other. It doesn't give any type of explicit interpretation of that.
And are you adding that in?
I'm sorry, I don't understand what you're asking.
You seem to have suggested that there's a new standard based on immediate impact to a specific property along the eastern boundary line that you consider in determining setback lengths.
No, I'm not adding that in. It's,
Okay, well,
but it is open to, it's subjective because it doesn't say explicitly.
And was it your opinion that 22 feet setback would be required? I'm sorry, clarify
Well,
that
it's
number
22
for-
additional.
Okay.
so 44 feet?
Yes, sir.
And that would apply to the entire eastern boundary line?
No, sir.
Okay. Why don't you draw on that document number 13 what your opinion or the county's position is as to the proper setback area from my client's property along the eastern boundary line?
I'm sorry, I'm not understanding what you're asking me to do.
I want you to draw, to take the pen and draw if it's this area down here, if it's a circle, if the whole boundary line is a setback. I want to understand where the setback is, because you're just keep talking about from my client's property. Every setback I've ever seen is the whole property line.
It's 15 feet.
Okay. How far west does it go?
It doesn't. That single family doesn't extend west.
I'm talking about the setback that you've calculated. How far west does the setback go?
It's only for this property, because this property to the south, the other projects are not single family.
Starting on the corner boundary, how many feet west is the setback according to the code under your interpretation?
I'm sorry, I'm not following what your
You
question.
just said 44 feet, right?
From the structure itself to this property.
Setbacks apply from on a property line back into the project, correct?
Yes.
Okay, so that's what I'm asking for. I forget where the building is now. When you start on this property line, my client's property line, you said the setback is 44 feet, correct?
From the
From the
affected
property line. Okay, so from this property line, 44 feet west, the setback ends, right? That's the setback area.
But this single family doesn't extend west. I'm sorry.
What are you measuring the 44-foot setback from? The property line, correct?
From this common property line.
Correct.
The 15 feet to the structure.
At what angle? Any angle?
From the closest angle, from the closest point. So this would be the closest point. This point. That's your client, the single family lot. It's their northwest corner is the closest to the structure.
Okay, under table 5.1, it says building setback requirements. 20 feet is the standard from the rear property line, correct?
Correct?
Okay, and the rear property line is the entire eastern boundary, correct?
Right.
Okay. And then you've got to add additional 159 feet for my client's property because it's 159. And you're saying that setback doesn't go west?
But the single family doesn't extend west.
Drawing on this. For a typical the setback line, 20 feet. It has to be 20 feet all the way down the property line, correct?
The 20 does, yes.
The 20 does.
Yes.
Okay, all right, I'm in agreement on that, because that's the rear. And over here, on the bottom, it's gotta be 15 feet all the way across, correct?
Right,
That's the standard setbacks.
correct.
Okay. So if it's set 20 feet that way to the west of the property boundary as the standard, when you add 159 feet to the 20, where do you add the extra 159 feet?
Well,
It-
again,
it
I
come-
added 22 feet, but it's only from the impacted property. I mean, the other properties aren't single family, so the additional setback would not apply.
Okay, so if it's 159 feet from,
Objection.
Yes. Go ahead, Ms. Davis first. I heard you first.
Asked and answered, and also the interference with the exhibit that Ms. Schultz has been marking on this exhibit and providing testimony regarding this exhibit. I'm at this point now, Mr. Seifert has made his own marks and providing his own testimony to the exhibit, so I'm going to object to this exhibit being entered into evidence, and again, asked and answered regarding his question.
Okay, I'm going to allow the exhibit to come in. What I need is for the witness to, and let me hear your objection. I'm sorry. Go. Are you just joining in?
What you're about to say might be ending my objection.
Okay, so I need the witness to initial the areas where she has marked this exhibit. Hold on just a second. And Mr. Seifert, if you would refrain from making marks on it yourself and just ask her to identify what's the southern boundary, what's the, so that she can make the marks, and that will really clarify as it comes in. Now, there's also an objection on asked and answered, and I think it hasn't been answered because I don't think this witness understands the question. So let me see if I can help clarify.
Please.
So, it's my understanding, your testimony, that the additional setback that's applicable to the portion of the subject lot adjacent to Mr. Seifert's client's property is only the last 15 feet in the southeastern corner, which is actually measured and shown on this particular exhibit. There's a 15-foot measured out there. His question is then the 44, I believe it was your testimony that a total setback of 44 feet from that lot line that is adjacent to his client's residential property applies, and I guess he's asking you, and Mr. Seifert, correct me if I'm wrong, but he's asking you then, where do you measure the 44 feet from? What's the starting point? And then when he keeps referring to it going west, what I mean, he means the setback on the property. How far west from the property line? And I think the answer is 44.
44.
Okay. All right. Does that help clarify that issue, Mr.
it does, Your Honor, and when, in measuring the 44 feet from the property line, is the 44 feet measured straight west or at an arc or at an angle, in your opinion?
So can you answer that question?
I mean, we made sure that the building was 44 feet from the entirety of that residential lot line.
Can you answer the question if it's measured direct point to point or if it goes at an angle of any kind? I think that's a simple question. If you know the answer, if you don't, just say it.
I mean, I feel like it's a direct point, my interpretation of a direct point, but I mean, the line is not, it's a little bit perpendicular to the lot line, if that makes sense.
All right.
So is the setback area an entire arc of 44 feet from my client's corner property?
So I'm going to say asked and answered at this
Okay.
point now.
Can you tell me what the answer was?
Well, she said it's a straight
It's
line.
a direct line.
She said it's a
Okay.
straight line.
All
Okay.
right.
No arc to the residential lot, so it wouldn't be an arc.
Now, are you about to mark on this again?
No, I'm looking at it, Your Honor. You want me to
Please
initial
don't mark
mines?
on it again.
Did-
No,
did-
I don't want you to initial because
Just
you're not
hers,
allowed
okay.
to testify. I want her to initial, and I'll know that her marks are the ones that are initial.
Okay. And with respect to the building height, you said, now, did you make this setback calculation as a professional planner yourself, or did somebody else in the planning department make this a calculation and analysis?
I mean, I made the interpretation.
Okay, that was my question, okay? And the entire building structure that we're looking at there, that garage area is connected and attached to the 314-foot building, correct?
That's correct.
Okay. And if you look at 5.0003, which is in Exhibit 24,
Before you leave that exhibit, I don't understand from looking at this exhibit where the garage is in relation to the condominium building. If you don't mind, if the witness could explain
Sure.
that to me?
So let me get oriented here. So the area, the whole southern portion of that building is the parking deck. And the thatched area that you see is the actual tower.
Okay, so there's all these little they look like units within a condominium building, all the southernmost portion here. Are those units or are those parking spaces?
Parking
They're
spaces.
parking spaces.
Yes, ma'am.
Okay, all right, thank you. That's very helpful.
You're welcome.
All right.
all right, Your Honor, and if we go back to Exhibit 42, it'll help with this, at least your
Okay, thank you.
visual. If you go back, we were at A10.
Yes, I'm there.
Okay, if you go back to the very page right before A1, it shows you kind of a rendering of the building. And so the building is built within and attached to the parking garage. Parking garage basically is the foundation of the building. The building is basically in the middle.
Okay, thank you.
Okay. All right, going back to Exhibit 24 and the setback rule. Under subsection A, it said setback requirements shall apply to all structures erected on the property, correct?
So where are you?
The very beginning, subsection A.
Yes,
And there's one structure being proposed to be built on this property, correct? One building structure?
that would be correct.
Okay, and that building structure, I think we agreed was 314 feet in height?
Yes.
Okay. So the setbacks would apply to the height of that structure rather than the height of the building garage, correct?
I think it could be interpreted a number of ways. And with the entitlement in the DRI, the height was considered at the time the building was anchored to that parcel.
You testified earlier in your direct that the DRI did not mention anything about setbacks and the current setbacks apply, correct?
Correct.
Okay. And with respect to the current setbacks, there is building structure within 159 feet of the corner of my client's property, isn't there, according to Exhibit 13? All right, this one.
Oh. Yes, that it does appear to be such.
And you said earlier, whose interpretation was it to determine the building height for purposes of these additional setbacks to be 60 feet rather than 314 feet? Is that your interpretation, or Mr. Showens, or somebody else?
No, that was mine. 314 feet.
You said earlier the parking garage was 60 feet in height, right? That's how you came up with this 44-foot
Yes,
number?
sir.
Okay, okay. And I'm asking you, was it your interpretation of this 5.0003 to use the height of 60 feet at the garage rather than the height of 314 feet to
Yes,
calculate the
that
setback?
was me.
Okay. All right, let's do the analysis for the additional setback, assuming it's 60 feet. So 60 minus 36 is what?
So 44 instead of 42.
Try not to skip steps for me. Okay, let's start with the 60 minus 36
Yeah,
and get the
yeah.
answer to
Si-
that.
60 minus 36 is what?
24.
24. And half of that is 12, correct?
Yes,
Okay, and so you add 12 feet to the 20 feet standard rear setback, correct?
correct.
So it's actually a 32-foot setback, correct?
That's correct. I apologize. I'm put on the spot here, and math is definitely not my forte.
It's all right,
All right,
just,
well, let's go back to
just take a breath and use the whatever tools you need. If you've got a calculator you need, just use it.
All right, let's go back to the staff report. Well, why isn't this setback contained in your staff report?
That's not something that we typically put in the staff report. I mean, maybe it should be, but it's not something we
Well-
typically put in there.
We look at, following your staff report of March that we looked at a moment ago, which I believe was Exhibit 28, there was another staff report, number 29, for your October 23rd meeting, correct?
So are you referring to Exhibit 29?
Exhibit 29, yes.
Thank
I'm
you.
sorry, Your Honor, what did I say? Attachment?
No, you just said number 29,
Number
and I'm
29,
trying to make
okay.
sure I'm following whether we're talking about an exhibit or a number within a staff report. So y'all are much more familiar with this than I am. Remember that, okay? Don't be afraid to explain it to me like I'm a fifth grader.
All right, so in Exhibit 29, this is a staff report dated October 23rd, 2025, correct?
Yes,
And you drafted this report, correct?
yes.
Okay. Now, let's flip to page 6 of 14. To the same.
My 6 or your 6?
Well,
My
6 of
6.
14.
Okay, my 6. All right.
So
All right,
six
here under additional.
of 14 is the county's numbering, right?
Right.
Smaller number,
Correct.
yes,
Well,
ma'am.
Yeah, one was the bait stamps for the entire package,
Okay, great. Thank
and
you.
one was for the other there. Okay, so in additional comments in number 4, you clarified your statement from the March staff report in the very last sentence to say the standard setbacks are applicable to internal lot lines, correct?
Correct.
Okay, so your staff report is addressing setbacks, is it not?
And it did in March, and that was something that when Renee and I were going through it, that's what we had discussed. And,
Okay, and then number 5, you added number 5 in the October report. That's not in the March report, correct?
that's right.
That's right. And it says, the project to the south of Echelon, Shops at Miramar, was approved as multifamily. Therefore, requirements for additional setbacks for tall buildings are not applicable. A copy of the Shops at Miramar DO is attached, correct?
That's correct.
Okay. So at least comment number 5 addresses setbacks being standard setbacks, right?
Correct.
Okay. This staff report did not address my client's property to the east, the Kajanic property, did it?
No, it did not.
Okay.
And tell us how to spell Kajanic for the record.
It's Kajganich.
Thank you.
Okay. I'm going to let's jump over to 31 again. And let's talk about villages at Miramar. All right, 31, the Paternoga property,
Yes.
is that part of the Villages at Miramar subdivision?
Yes.
And that's a townhome subdivision, correct?
It is a multifamily development.
Okay, well, let's talk about that. What is your definition of multifamily?
This particular project, the applicant suggested multifamily or indicated multifamily on the application, and every single development order was multifamily. This is not the type of project where you have a single family lot and you have two attached dwellings. This was done as, there's the common area with these attached dwellings within it.
Okay, my question was, what is your definition of multifamily? Was that it? Or is there one in the glossary of the Land Development Code that you're required to follow?
There's something more eloquent in the glossary that we could pull.
Okay, that would be in Exhibit 24. Should be on like page 12 in the bottom left.
Okay.
It's highlighted there. Read for me, dwelling multifamily residential.
Any residential structure containing 4 or more separate dwelling units.
That's the Land Development Code of multifamily dwelling, correct?
That's correct.
Read for me the definition of dwelling, single-family, attached.
A structure containing 2 or 3 separate dwelling units with common walls in between the units.
Taking a look at the villas at Miramar. I've got a picture of them. Let's go to Exhibit 27. Hey, have you been to the villas at Miramar Beach Villas, or villages at Miramar Beach?
Driven by there, I've
Have you-
not been within the development itself.
And what exhibit are we on now?
It's Exhibit 27, Your Honor. Okay, turn to page 3.
Three in that section, in section 27.
Well, maybe 1, 2, 3, 4. How about 4?
So the back of the second page?
Correct, yes.
Okay.
And it shows shows a building structure with peach colored. Do you see that?
Yes,
With a red
sir.
car in front?
Mm-hmm.
Okay.
I
And
do.
is that building structure a townhouse?
I can't tell from the picture.
And you can't tell how many units are in it?
I mean, it appears that there are 2, but
And with respect to Miramar Beach Villas on the right, the property appraiser map, did you ascertain and look at that to determine how many units are within each building in Miramar?
that was part of it. But Echelon touches common area. It doesn't touch a single family or an attached single-family lot.
We'll get to that in a second. My question to you is the structures within Miramar. Do they meet the definition of multifamily, which is a building or structure that contains 4 units?
Under today's definition, no, they do not.
Okay.
But again, Echelon does not touch those buildings,
We'll
lots.
we'll get to that, and I know you're. We'll get to that in a minute.
Okay.
But as far as the villas at Miramar, those contain 1, 2, 3, 4, 5, 10, 11, 12, 13, 14, 16 buildings with 2 units each, correct?
Yes,
And they meet the definition of single-family attached, which is a structure containing 2 or 3 separate dwelling units with common walls in between the units, correct?
the lots that are encompassed within the common area do.
Okay.
And
All right, so-
interesting, when this project was approved, it was approved with commercial on the bottom floor, and then it was later amended to remove the commercial. But again, it was indicated initially as multifamily and commercial. It was a mixed-use development.
All right, and we're gonna get to that, I know, because that's kind of what y'all have cited. And that's what you cited in your staff report as a justification for no additional setbacks, correct?
Correct.
Nowhere in your staff report did you put this common area abutting Echelon lot as a justification for not having additional setbacks, correct?
I may not have said it explicitly, but that's, I mean, the whole project is multifamily.
You just testified 16 buildings meet the definition of single-family attached, correct?
The buildings within the development do, but the development is multifamily.
Okay, show me within the development a single building with 4 units in it that meets the definition of multifamily.
That doesn't exist, but the project was approved as multifamily, the development order, even the amended development order where the commercial came out. The applicant at the time even put in the application that it was multifamily and commercial mixed use and then down to multifamily. And in looking at it with, if the lots along Alamo had the density to have 2 units and they were single-family attached, I would have looked at those differently. These are not single-family lots that abut this project.
Okay, the setback code doesn't apply to single-family lots, does it?
I have to go back and read it again.
Well, we can do that. That's Exhibit 24.
Its uses, and the use that directly abuts Echelon is common area.
And that's the argument you picked up from the applicant, right, after?
No, sir, we looked at that the entire time. We looked at the development order, we looked at the abutting use.
Okay, so, but nowhere in your staff report do you say the abutting use or the adjacent area is common area and thus it doesn't apply. You didn't say that anywhere in your staff report, did you?
I didn't explicitly say that. There are a lot of things
Right.
that I did not put in the staff report as far as all the justification. I mean,
Well,
it's an organic document. It's hard to capture every single thought in a staff report.
no, I understand, and I'm going over what's in the document.
Yes,
to-
sir.
to-
No, I understand. I
To
understand.
try to determine compliance
I
with
wish,
it, at
I
least.
wish I could have for the foresight of something like this so that I could put every single thought in there to justify, but, again.
Well, you did have that foresight when we met on October 23rd. You heard our objections and our position, right?
Well, yeah, I mean, we had discussions about it for sure.
And nothing changed in that staff report relating to these setbacks between our discussion about it October 23rd and November, or today, right?
There were some minor changes, nothing
you-
significant.
At that meeting on October 23rd, did you mention to us the common area was a justification for no additional setbacks?
I really don't remember the full discussion.
All right, now let's move on to the DO that you rely on in your planning report for justification that a property that contains 16 single-family attached dwellings is in actuality a multifamily subdivision. And this is the purple tab, Your Honor, under 42. that.
Okay. I thought that was my book for a second. 40. Tab.
Development order that you've been testifying to that approved Miramar Villas, or at least part of it, as a multi-family subdivision?
Yes, sir.
Okay. And you've got some highlights in there, correct?
Yes, sir.
Okay, it says multifamily units, 32, correct?
Yes, sir.
And then it talks about the number of buildings, and this is 14 buildings. Then it says size type of each structure. It says 10 two-unit townhomes, correct?
Yes.
Okay, that's not multifamily, is it?
That particular section of the development order isn't identifying the use, it's giving the units.
Okay. A two-unit townhome meets the definition of single-family attached that we went over earlier, correct?
It could,
Well, it does, doesn't it?
under today's ordinance, yes.
Okay. And then it says 4 three-unit condos with a total of 13,742 square foot commercial on the first floor.
Correct.
3-unit condos meet the definition of single-family attached under the Land Development Code, correct?
Yes.
So in this description of the type of structure, there's not a description of a single building with 4 units in it, is there?
There's also no indication under the single-family unit section that any of this was single-family.
My question to you was, there's not any indication on this development order that there is a building proposed with 4 or more units in it, correct?
Not under the description, no.
Okay. And as the project, I believe you said the project was modified, amended after time, correct?
Yes, I think I have notes of when it was amended. I don't recall without having to go through some paperwork, but it was amended to, I know that the commercial on the first floor was removed.
And attached to that development order, behind it, you have a Shops of Miramar plat, correct?
Correct.
Okay. And that shows the hatched area. Does that show the common area that you're referring to?
It does.
Okay. And then it shows individual lots.
All right, so let me catch up with you. So we're on page 2
Yeah, it's-
of the plat.
Yeah, it's 2 pages past the DO.
Thank you.
Okay, and it shows 21 lots on that plat, correct?
Yes.
Lot 1 is a large lot that fronts Highway 98, correct?
Scenic Gulf, yes, sir.
Scenic Gulf, I'm sorry.
That's okay.
And then lots 2 through 21 are the townhouse lots, correct?
Correct.
And all of those townhouses were constructed consistent with this plat, correct?
I can't testify to that. I would have to make that assumption.
All right, take a look at 45. Which are some certificates of occupancy for some of the Miramar Beach units. It indicates residential 2-family duplex, correct?
It does, but I think it's important to note that definitions within the Land Development Code that relate to zoning are often very different than what the building code is. So I don't think you can link this description to what was approved under zoning.
Okay, hold on, there's an objection. Okay. Well, actually, none of them have been entered in the record yet. So, yeah,
sorry,
make
did
sure
y'all
y'all
do that?
come up to
Apologies.
the microphone for the record, and especially because when I have to go back and listen to this, I have determined I cannot hear anything if y'all are not on the microphone. So thank you.
I'm sorry, Stephen Tatum for the record. We just had an objection. We've not seen the exhibit that he's referring to, Exhibit 45, but I do believe they've got a copy for us.
But you do believe what?
We have
Oh,
a copy
okay.
now.
Okay. All right, so do you have an objection to this witness being questioned regarding this exhibit?
Sorry, I missed that, Your Honor.
Do you have an objection to her being questioned on this exhibit?
I do not.
Okay, thank you. And I'm gonna, Mr. Safer, you have not asked for my help, but I'm going to interject. We will get through this much more quickly if you will just answer Mr. Safer's questions to the best of your ability.
Yes, ma'am.
Your attorney will have the opportunity to redirect.
Oh, yes, ma'am.
Okay, so I really appreciate all expert witnesses want to do that. They want to help. And so this is a long day we have ahead of us. So I'm going to ask you to try your best just to answer the question that he's asking you, and bearing in mind that your attorney can redirect
ma'am.
and
Thank
you'll have
you.
an opportunity to explain. Okay. Thank you. Yes, Ms. Davis, do you have an objection to being questioned on this document?
I'm going to object because I have a lack of foundation as to the relevance.
All right, well, those are separate objections.
Right.
So is there a lack of foundation and lack of relevance?
Yes.
Okay. Your response, Mr. Seyfried.
Thank you, Your Honor. I think the first response is this is a QJ hearing, so everything comes in. That's my experience with QJ hearings under state law. There is no evidence code. The county has not adopted any kind of rules regarding evidence code that governs this. So to stand up here and make up evidentiary rules for a QJ hearing when the Board of County Commissioners didn't, I think is inappropriate. So that's my blanket objection to anything of that. But these are the certificates of occupancy that demonstrate this is a single family attached unit. There's not 4 units attached to any of these buildings.
Okay. So Ms. Davis, would you address his response to your objection that there are no evidentiary standards that apply under this quasi-judicial hearing?
It's still a judicial hearing, whether it be in a quasi context or not. I mean, we still have to lay foundations for everything that we do. That it's not just free game all the time. There are some more lax rules, but there is some parameters that always have to be abided by when providing any kind of sworn testimony.
Okay.
I would just like to add, Your Honor, that we have no objection to stipulating that his client's unit at the shop or cottages of Miramar is only connected to one other dwelling unit.
Villas?
Yeah, Miramar Villas. Is only connected to one other dwelling unit. And that kind of ends this whole line of questioning, in my opinion.
Well, I don't know if it does. Does it, Mr. Seyfried?
It will narrow it, yes.
Okay. So what I'm going to do, though, I don't have the applicable law in front of me as to whether, I'm used to conducting hearings under 120, and there are certainly evidentiary standards that apply. I don't have the law in front of me about the quasi-judicial hearings. I know the law on testimony has to be under oath, subject to cross-examination. I have to open a public hearing and close a public hearing. So what I'm going to do today is allow the exhibits in, and I am going to require the parties in this case to submit proposed orders. I was going to ask you if you wanted to, but I think it's going to be very helpful to me. So I'm going to ask you to address that particular legal issue in your proposed orders, so I can make a final determination on the exhibits at that time. All right, so hopefully this narrows your inquiry, and let's let you proceed.
Well, thank you, Your Honor. All right, moving to Exhibit 46
All right, so you're skipping over 45.
for now.
Okay.
Or we were just addressing 45.
Right.
Right, yeah, so I think she answered my question on that.
Okay.
We're moving to 46, which is a plat of La Teresa, which is the replat of Lot 1 that we saw in the shops at Miramar. Correct, Ms. Schultz?
Correct.
Okay. And that plat shows an additional 6 buildings with 2 units each in them, correct?
Correct.
And so, and that's what was built and exists today, correct?
Correct.
All right, so the Villages of Miramar is a subdivision of 16 townhome buildings, each containing 2 units, correct?
That sounds correct. I can't remember the number from the other. Let's see, 1, 2. That'd be correct, 16.
All right.
16 buildings.
And Mr. Seifert, just for planning purposes, how much longer do you think you have with this witness?
Well, if I get direct answers, it'll be a lot shorter, maybe 30 minutes.
Okay, let's take a break. I
Okay.
need a comfort break. If we could just take 5 minutes and we'll come right back.
Perfect, thank you.
Thank you.
talk to her about this one.
Your finger in a light socket, it'll be fine.
Okay, let's go back on the record. Thank you. And Mr. Seyfried, you may proceed.
All right. Thank you, Your Honor. Going back to Exhibit 24 with these setback requirements. With respect to the south boundary line that's adjacent to the Miramar, or the villas at Miramar subdivision, I believe you said the standard setback there was 15 feet. Is that correct?
Yes, sir.
And you did not apply any additional setback under footnote 1 of 5.0003 because you deemed the subdivision to be multifamily, correct?
Correct.
Okay. If the ALJ deems that subdivision to be single-family, additional setbacks would apply, correct?
Correct.
Okay. And let's calculate what those would be in the event she makes that decision. And we did it a little bit earlier. We took 314 feet, we subtracted 36, we got 278, correct?
I'm gonna take your word for it.
Okay, and we divide that by 2,
Yes,
gives us 139 feet of additional setback, right?
sounds correct.
And then you add that to the 15 feet of setback, the standard setback for the side yard, correct?
Yes,
So that gives you 154 feet of setback from the south boundary line in the event the magistrate deems that to be a single-family subdivision, correct?
yes, sir.
Okay.
That would be correct.
What was the total?
154.
Thank you.
All right, let's take a look at Exhibit 39. Do you recall this email exchange?
Yes, sir.
And I believe this was provided to us shortly before the last hearing, correct?
I don't recall when.
And if we go back to, I guess, the second to the last page, it starts out with an email dated September 10th, 2024, from Mr. Eubanks to yourself and Miss Renee Bradley, correct?
Yes.
And who is Mr. Eubanks?
He is the applicant. He is the engineer of record for the property owner.
And in this email, he was asking about what the setback would be for the southerly border, correct?
I'm gonna have to read through it real quick.
And Mr. Seyfried, so we're looking at the originating email, meaning the last one in the string,
Correct, yes, ma'am.
dated September 10th, 2024.
Correct, 10:06 a.m.
Okay, well, I'm sorry, what was your question?
My question is, in one of the notes, he was asking about what the setback would be for the southern property line.
Yes,
And then you responded on September 10th, I think in the second paragraph. The first paragraph deals with, I think the other issue you asked about. It says, I agree with your thoughts about the additional setback not being required. The developments to the south of this parcel meet the definition of multifamily dwellings. Parentheses, multifamily residential, any residential structure containing 4 or more separate dwelling units, close parentheses, so the additional setbacks would not be applicable. Is that what you wrote?
It is.
And you use the multifamily residential definition is straight from the LDC, isn't it?
Yes.
And at the time you wrote this email on September 10th, there were not 4 units in any building on the Villas of Miramar, were there?
I'm sorry, would you say that again?
At the time you wrote this email, September 10th, you knew there was no 4 units in any building on Miramar Villas, correct?
That's correct.
Okay. So your email is incorrect when you say the developments to the south meet the definition of multifamily dwellings, any residential structure containing 4 or more units, correct?
Correct.
After this email, when issues arose regarding the setbacks, that's when you went and researched the development order for Miramar Villas, correct?
To get the documentation, yes.
To update your staff report to indicate why you believed the setbacks, additional setbacks did not apply to the southerly property boundary, right? You understand that? Or you may-
I understand your question. That's not exactly, it wasn't it was basically just to have the documentation to back up our position. And again, you know, I mean, when that was, whenever Renee and I looked at this, she knew that was considered multifamily under the approval.
You're testifying as to what Renee believed at that time period?
Right, during our review of this together, yes.
All right, and then the next email, or a few emails, on the, I guess, the first page of that email chain. It is one from you to Stephen Schoen, July 16th, 2025. Do you see that?
Yes,
Okay. And this is dated July 16th, 2025, correct?
yes.
And this was after the Planning Commission meeting, correct?
I don't
But-
recall the date, but it was around that time.
Okay. And it says, I located the email chain that Jamie mentioned to you, and I am providing to you with a copy to Jamie. I spoke with Jamie earlier, and he asked that I also copy Ken Metcalf, who worked on the Seascape DRI. Then you go into states,
Court reporter, how you doing? Okay, thank you.
sea cabins in the village at Miramar to the south of the subject site are townhome multifamily developments. The additional setback would not be applicable for lot line adjacent to these developments. Did you have the development order that you're relying on today at that time, July 16th?
I truly don't recall what date I pulled that DO.
And then the next paragraph, it says, as shown in the first screenshot, you can see that there is only one adjacent single-family property that adjoins the Echelon site on the southeast corner. It appears that only 12 plus minus feet of that lot adjoins Echelon. In hindsight, I was probably wrong, but I recall thinking that this property is not single-family because it contains 2 dwellings, specifically based on the size of the dwellings. It's not an SFD with ADU. It is 2 dwellings as shown in the second screenshot. Was that accurate to say that when you originally looked at the setbacks and calculated them, you believed the Coppinich property was multifamily instead of single family?
Yes, because it had two full-size dwellings on it.
And so as of July 16th, which was after the Planning Commission, the county had to come up with an interpretation to meet setback requirements for that property, correct?
I'm not sure that I follow your question.
Okay. The first time you realized that additional setbacks may apply to the Coppinich property was after the Planning Commission meeting in July 16th, correct?
Yes,
You didn't, interpretation you're developing today or you're testifying to today regarding proper setbacks from the Coppinich property did not exist in September 2024, did it?
24, no, sir,
It was developed after July 16th, 2025, correct?
correct. Well, around that time, yes.
All right, and then it says, if needed, I will get with Jamie to determine what the setback needs to be at this corner. Did you ever get with Jamie to figure out what that setback needs to be at the corner?
There were discussions, I don't recall the
Yeah.
details.
And you don't recall what that setback ultimately was determined to be by the county, correct?
Not back during that time, no, sir. Yeah, just, that's correct.
All right, let's go to Exhibit 42 again. This time we will look at page 7 of 14.
Okay.
All right, on the top of page 7 of 14, it says additional comment. There's a block at the very top of that page. It says consistency with the comp plan, and then it's got a box, yes or no, and consistency with the land development code with a box, yes or no, correct?
Yes,
Both of those are checked yes, correct?
yes.
But then the additional comment, is this your comment? Did you draft this?
This standard language that we have for our staff reports,
Standard language for all staff reports?
for those that are found to be in compliance with the comprehensive plan and LDC, yes.
All right, and additional comment says, planning and development services staff has found the application to be complete and substantially consistent with the comprehensive plan and LDC.
That
Is
question?
Yeah, is substantially consistent the standard by which the planning department determines whether an application is consistent with the comp plan?
Repeat that question?
Yeah, is substantially consistent the standard?
The standard,
An application or development has to be consistent with the LDC and the comp plan, correct?
yes.
That's the legal standard, right?
Yes.
It can't be close to complying with it, can it?
No, sir.
It's got to be in actual compliance, right?
Correct.
Okay, but your statement here says this project is substantially consistent with the LDC and comp plan, correct?
Yes.
And it should not be entitled to approval if it's only substantially consistent rather than fully consistent, correct?
This, again, this is standard language that we use in our staff reports once all of the outstanding comments, not conditions, but comments are resolved.
Okay, well, I had a chance to look at other staff reports to ascertain whether that's the standard or not. And, marked, it should be marked probably 51.
Now, is it just an impeachment exhibit? Does it actually need to come in, or?
Yeah, it will. We'll move it in eventually.
Okay.
And this is, and I'll have the witness testify to it. Identify what that document is.
This is, it's a staff report.
Okay, for it's a staff report for a development project that would come to a QJ hearing?
Yes.
Okay. If you go to the orange tab there, what page are you on?
5 of 14. on our
5 of
pages.
14. And who was the planner that prepared this report?
This was Stephen.
And that's your boss now?
It is.
Okay. And in that block that we were just talking about in your staff report, you said this is common language, right?
It is.
That language is not in that staff report, is it?
I can't speak to someone else's staff report.
Is it?
It's not here, no, sir.
It's not there, right?
Correct.
Okay.
It's not here.
It's not common language for everybody's staff report, is it?
It actually is. We have templates in our shared drive that have that language in there that we are to use now. I have seen people omit it, but it is in our template that we use. And there's 3 iterations of that language as well, you know, if it doesn't meet it, anyway.
Well, while we're here, we'll go ahead and I'll have you look through these 3 other reports from Mr. Schoen. just so it's clear that those three reports don't have that language either. Want to identify that document by date?
It's February of 2024. The staff report was done in 23, and I don't recall when we were told, there may be an email or something, but I don't recall when we were told to start using that language. I don't know if it was after this report was last updated December 27th of 23, according to the revision date at the bottom.
Okay, and who told you to start using that language?
I don't remember if that came from Stephen or Schoen or Kristen Shell. I really don't recall who gave us the wording.
All right, well, did you see that language in?
No,
that
sir,
staff
it's
report?
not here.
Okay.
It's clearly not here.
Okay, all right. All right, thank you. Now, we'll mark that as Exhibit 52.
Okay.
All right, let's jump back to Exhibit 39, which is the email we looked at a moment ago. Talking about setbacks in July 16th. All right, now in July 16th, looks like you copied Mr. Metcalf. Who's Mr. Metcalf?
He is a planner with Stearns and Weaver who has done a substantial amount of planning work for the Seascape DRI.
Okay. And in response to that email that you copied him on, talking about the setbacks and asserting Village at Miramar was multifamily, he responded with his own interpretation of proper setbacks, did he not?
He did.
Yeah. And he came up with this interpretation that Miramar Beach Villas and the Alamo House or the Kapanich House is a short-term vacation rental unit attached instead of a single-family residential attached, correct?
Read through it real quick. That sounds correct, but it's been a minute since I've looked at this.
It's okay, you can look at it.
Okay, thank you. That's correct. That's what it says.
Okay. And the county has rejected that interpretation of the uses being single-family vacation rental units to determine setback distances, correct?
That's a legal question. I'm going to have to defer to our land use attorney.
Well, you're not sitting here testifying as a planner that the setbacks don't apply because the Villages at Miramar is a short-term vacation rental unit, are you?
Correct.
That's not your professional opinion, is it?
What is that?
I said, that's not your professional opinion. That Villages at Miramar don't have, or the setbacks don't have to comply with the southerly boundary because
No, sir.
Villages at Miramar are short-term vacation rental units.
That's correct. That's my,
Same, your professional opinion is just because the Alamo property, the Coppinich property is used for vacation rentals, that doesn't dictate what the setbacks are, correct?
correct.
Okay. And he asked you at the end, he states, I would suggest that the staff report be revised to include explicit findings regarding the proper classification of the above units. The county did not do that, did they?
We did not.
All right. Did you see anything in here about common area of the Villages at Miramar as a basis for the setbacks not applying?
In Mr. Metcalf's email?
Correct.
No, sir, I don't.
When did the county first develop this common area is what is abutting the property, and the common area is the use as opposed to single family attached?
I mean, I sound like a broken record, but again, when it first came in and Renee and I started reviewing it, she was the one that was showing me that it was, that it was multifamily. And we looked at the common area around it. I may not have clearly stated that in any documents, but that was from the get-go.
All right. Let's look back at Exhibit 24, the setback requirement. All right, and it talks about in footnote 1, the additional setbacks would apply if the single-use multifamily, if there are single-use multifamily uses adjacent to existing single-family residential units, correct?
That's what it says.
That uses the word adjacent. What's your definition of adjacent?
Abutting, adjoining, right next door,
Contiguous?
contiguous.
All right, does the Land Development Code define adjacent?
I don't know.
All right,
Without
well,
looking.
we will look a little bit further down in that exhibit, composite exhibit 24, on page 13. At the top, abut is defined, correct? Okay, and it's defined to say to physically touch or border upon or to share a common property line, correct?
Correct.
Okay, is adjacent defined anywhere in there?
It does not appear to be, no, sir.
Okay. And are you aware of the ordinary dictionary definition of adjacent?
No, I guess not.
All right, let's
That's not common use of it.
okay, let's take a look at exhibit 41. The definition of adjacent according to the 9th New Collegiate Dictionary.
Oh, I'm going to interrupt for a second. So, Mr. Safran, we're getting into legal arguments that would be made in more of a, like your written argument to me? I mean, do we need this witness to testify about common, ordinary dictionary definitions?
Well, I'm just wanting to know if it's her planning as an expert planner, if she views adjacent meaning this exact same thing as abut, which is contiguous, as opposed to there can be space in between in accordance with this definition.
Okay, go ahead.
All right. The definition of adjacent here in this dictionary says not distant, nearby, having a common endpoint or border, immediately preceding or following, having the vertex and one side in common. Then it goes on to say synonym, says mean being in close proximity, may or may not imply contact, but always implies absence of anything of the same kind in between. Is that your understanding or how you apply adjacent?
It is not.
Do you apply the word adjacent consistent with the definition of abut?
I feel like I do, yes.
Okay, all right. All right, you talked a little bit earlier. Did you conduct an analysis of compatibility of this project with the adjacent uses?
No, sir. Compatibility, no. Not under the general, not under our, how we apply compatibility, no.
How do you apply compatibility?
There's certain projects that require compatibility analysis. It's done by a professional.
Okay. And do you believe, in your personal opinion, that this project is compatible with the adjacent uses to the south and to the southeast?
That's a tough question to answer.
I know.
I mean, because my personal opinion doesn't matter when there's an entitlement.
Well, I think your personal opinion does matter. You're a professional planner, and if the ALJ determines that she needs to determine whether it's compatible or not, she's going to hear opinions from different experts here. And as a professional planner, want to know what your professional opinion is.
Do I have to answer that question?
Unless your attorney has some objection, I haven't heard one.
This is a big project next to these dwellings. It's a big project.
And you have seen, you can turn to Exhibit 17. You've seen the renderings that were provided to you last month by us. Did the applicant, what are these renderings typically used for, if you will, in the planning realm?
To look at bulk and impact.
Bulk and size
Size, yes.
in relation to adjacent uses?
Yes, sir.
Okay, and do you believe this rendering accurately reflects the bulk and the impact of this 24-foot, 314-foot building?
It appears to.
And so is it your professional opinion that this project is not compatible with the adjacent uses?
If this entitlement were to come before the board today, I would not be able to recommend approval of it. But that was determined by the BCC.
Because
I'm sorry,
you-
I'm doing it again. I
Yep.
keep going.
Because you personally believe it's not compatible, correct, as a planner?
Correct.
Okay. All right, are you aware of any construction that has occurred on the Echelon parcel since 2022?
No, sir.
You know if any construction has occurred on the Echelon parcel since 2022?
I'm not aware of any. There's not been any development orders approved.
Since you said in 2022, the DRI was amended, a development order was issued to amend it to give an option of a 24-story building or either 32 single-family homes, correct?
I didn't testify to that earlier, but that is the case with that 22 DRI amendment. It gave the single-family option.
And did any construction, since that approval began, has there been any construction on the Echelon site?
Not to my knowledge.
All right. And the original parcel owner following that 2022 DO actually elected to develop the property with 32 single-family homes in September of 2023, correct?
I don't remember the date, but there was an application for 32 single-family homes. That was a planned unit development project that was never brought to fruition. There was never a DO issued.
Okay. All right, I don't have any further questions at this time, Your Honor. Thank you very much, Mrs. Schultz.
You're welcome. Thank you.
Yeah, you can put them right up.
Okay.
All right, redirect, Ms. Davis, when we're cleared out here.
Yeah, sorry, I got a lot of stuff.
Ms. Schultz, I want to, got really two questions. So your testimony at this point is the setbacks for the southern edge of the parcel in your review as a planner. The southern edge of the parcel, what is the setback that you believe should be applied?
Along that southern boundary line is 15 feet.
And then on the eastern boundary?
The majority of it is 20 feet. There's a 15-foot section on the southern common property line that is an additional setback.
Oh, I know you answered some questions regarding an email. I think it was Exhibit 39 with Mr. Eubanks. So were you told by Mr. Eubanks what the setback should be? Or did you come up with that opinion on your own through your research?
Through research. I don't recall us ever having a discussion about a number, like a linear distance.
You still have Exhibit 39? Can you explain for us the meaning of the line in your email regarding we would have to ask Mr. Eubanks what the setback should be?
Well, I think my intent with that was because, I mean, I didn't have the tools to scale it off and do an exact measurement. You know, and that's what I meant by that, so that there could be some type of illustration to show where the building should be with that additional setback.
I don't have any other questions.
All right, thank you.
Just a couple from me, Your Honor. Ms. Schultz, I believe you established with Mr. Seyffert's help that the required setback for the garage area to the south of the property is 32 feet.
Yes.
Is that correct?
That's correct.
And on Exhibit 13 that you were looking at, which I believe is up there, but this is an exact copy of it, and you can grab that one if you would like. What is the setback on the south side as shown on that exhibit?
Are you talking about the southeast corner?
No, the actual south,
Okay, so.
closest
so-
point on the south side of the garage to the property line.
So the most narrow is 22.5 feet.
Okay. And is that in adjacent to the Miramar Villas?
It is.
Okay, all right. And then it's still your position that Miramar Villas is a multifamily project because it was approved that way back in 2007, correct?
Correct.
Okay. And if it's a multifamily project, what is the required setback?
Just the standard, in this case, it would be 20 feet.
Okay, all right. And assuming 20 feet, this project's in compliance, correct?
Correct.
All right, now let's move on to the southeast corner. Measuring from Mr. Seyffert's client's property line as shown on this exhibit, what is the measurement to the
Which
garage?
client? 'Cause we got.
I'm sorry, the
Okay.
client in the southeast corner of our,
And maybe for the record, if you just say Miramar Villas or Villas, and then the other one, use that name,
Okay,
that'll be really helpful.
I'm sorry.
No problem.
I call it the Alamo property.
Yeah, can we call it the Alamo property because this client's name?
The road is Alamo that it fronts.
Okay.
So from the Alamo property, that would be the northwest corner of that Alamo lot. What is the distance to the garage in a straight line?
The closest distance is 49 point, I believe that's a 7.
Mhm. And we've established there that the distance needs to be what? You recall?
32 feet.
Would that be 32 feet? Yes, that's right. You're right. Sorry. And what does the measurement show there?
49.7.
Okay. So is that in compliance with the required setback based on Mr. Seyffert's calculations that he walked you through?
Yes, we're using the parking garage as the standard.
Okay. And then to the tower, which as you mentioned is the hatched area shown on that exhibit.
Yes.
What is the distance shown on that plan to the tower?
It shows 158.9 feet.
And what was the calculation that you determined when Mr. Seyfert was the required setback?
I do not recall that number.
Okay. Would it help if I reminded you that you discussed a number of 159 feet?
That sounds right, yes.
Okay. So the tower is set back 158.9 feet from that corner of the property line. Is that
Yes,
what you
that's
see there?
correct.
And the required setback, in your opinion, if Mr. Seyfert's argument is correct, would be 159 feet.
Correct.
So at the very least, if the tower were constructed where it's at today, or where it's shown there on that plan, it would be off by 1/10 of a foot?
Something like that, yes.
Okay, all right. Is that an issue that cannot be resolved through a condition or a revised set of plans showing that what would be 1.2 inches moved, if that was the only problem with this project?
In my opinion, no. We could make that a condition of approval and then require a revised site plan that met that additional setback.
Okay, thank you for that. So back to Miramar Villas for a second. We discussed, and I think you and Mr. Seyfert discussed this, but what is the property that is directly south of our property at the Miramar Villas? What is that what is our property adjacent to at Miramar Villas? So on the plat, yeah, I may be asking the question confusingly. Are we adjacent to a lot that is part of the Miramar Villas plat, or are we adjacent to common area that is part of the Miramar
Oh,
Villas
common
plat?
area. It's
Okay.
common area of the multifamily development.
So the use of that particular area is multifamily common area, in your opinion?
Yes, that's correct.
Okay. Now, I know there was some discussion about compatibility and your personal opinion about this particular project. But is it also your opinion that the Board of County Commissioners had already determined that the project was compatible with the surrounding area?
Absolutely.
And that would have happened 3 times?
Theoretically, yes.
In 2000, in 2008, and in 2022?
That's exactly right.
Okay. And just in your general opinion as an expert planner, the area of Miramar Beach, has it developed into one large resort vacation area?
For the most part, it has.
Thank you. I have nothing further.
Thank you. Thank you for your help.
You're welcome. Thank you.
All right, Ms. Davis, anything else? Do you have another witness?
I think at this point, with the length of things going, I would make the suggestion that we take a short 20-minute lunch break at this point, because if we get into any other witness, then we're going to be an extended period of time.
Does the county have another witness to present?
Yes, Your Honor, I have one more.
All right, the counsel for the other parties have an objection to taking a 20-minute lunch break at this point. Now, I see Mr. Seyfried says no. Yes, Mr. Taylor?
Your Honor, I have no objection to 20 minutes.
All right, let's do it. So we will break down. We'll reconvene at 12:05 according to that clock in the back of the room. Thank you.
All right, 12:05. Did you get those printouts that you needed?
52. Yes, those are the ones you're referring to. Okay, thank you.
Mr. Schoen, is that standard language that would be reflected in staff reports prepared today?
The minimum consistency, substantial consistency with the comprehensive plan and land development code.
That's correct.
That statement would be, yes, that is consistent with our current staff report template.
Why are they not in those staff reports?
I think that prior to my predecessor leaving, we worked to institute a sort of template for all of our forms and different documents that we utilize. So there really wasn't a standard in many ways until earlier this year. In this time frame, we had some loose sort of templates. Again, we tried to hone in on being consistent, and we're still honestly attempting to be consistent with all of our documentation to this day. So that is a constant struggle. But in terms of our standardized forms, that work was really kind of accomplished at the beginning of this year, probably February, May timeframe.
I don't have any other questions, Your Honor.
I will say, though, if I can add to this
Certainly.
just a bit. So when these major reports would have gone before the BCC, we did have a standardized form, even I believe in this time, where that statement was actually a checkbox in that form. That was an executive summary that was heading our staff reports in front of the BCC, and that I believe that had that statement on it at the time. So.
I think you're adding that context.
Okay. Mr. Tatum, any questions?
No questions, Your Honor.
All right, Mr. Seyfried.
You were looking at exhibits 51 and 52, which are your staff reports from 2024, correct? Staff report for today that Ms. Schultz prepared, and the statement that we're talking about that's at issue is the block form that says consistency with the comp plan and land development code. It has 2 checked yes or no boxes.
Mm-hmm.
And then the additional comment under it, where Ms. Schultz stated, Planning and Development Services staff has found the application to be complete and substantially consistent with the comp plan and LDC.
And Mr. Schoen, just make sure you give me yes or no answers, not mm-hmm and Okay, thank you.
Oh, did I do that previously?
Yes.
Oh, I apologize.
Just now, it's okay.
And is it your testimony that that language that Ms. Schultz used is the standard, typical language all planners began using at the beginning of this year?
It is, excuse me, it is something very similar to that. It's been over a year since I've actually composed a staff report, I believe. So it is something similar to that.
Okay, but it's not that exact language, correct?
It may in fact be that. I just don't have a staff report in front of me from this year or last or.
That's a staff report from this year, correct?
That's what it says.
Okay, and we'll mark as an exhibit later. This is a staff report for today for Hunter's Village that just got posted home.
Looks like the same language, right?
Read that language for me, an additional comment.
Planning and Development Services staff believe the proposed project is consistent with the Comprehensive Plan and Land Development Code.
It does not use substantially compliant with the Comp Plan and Land Development Code, does it?
No, you're right. The substantially consistent, substantially does not appear to be in that statement.
Okay. So the language within Exhibit 42 is not the standard language for the Walton County Planning Department, correct?
I would actually argue that I think that's probably inconsistent with our normal reporting.
And
I think substantially consistent.
when you say that, I need
Yes.
you to be more specific.
I think substantially consistent is the term that was settled on previously this year. I think that report is missing the.
And by that, you mean Hunter's Ridge?
I'm sorry,
Hunter's
yes, project number MAJ 2545, Hunters Village Subdivision.
Village, thank you.
That additional comment, I believe, is the incorrect version of what should be in the report.
And so if this language is used by this same planner for the other 3 items today, that planner would be using the wrong language?
Correct.
Why does the planning department have language of substantially consistent when the legal standard is consistent?
I believe that was established with our previous land use attorney.
You believe or you know?
I believe.
All right, no further questions. Thank you, Your Honor.
Thank you.
Thank you.
Any redirect? Ms. Davis?
No, Your Honor.
Okay, anything, Mr. Tatum?
Mr. Schoen, could it be that the use of the word substantially consistent in this particular context is because there are certain things about our project that are not today consistent with the comprehensive plan, but are consistent with the DRI approvals that were approved prior to changes in the comprehensive plan?
No.
Well, I'll sustain on leading because this is not cross-examination. So if you want to ask a non-leading question.
I'm not sure in this direct either, but
Well, it's
he's not my
redirect.
witness.
I mean,
In any event,
But I would think the correct context, it would be characterized as cross-examination because this is the county's witness.
that would be my position as well, but
well,
let's see if I can read.
I mean, I think he is offered as the county's witness. Okay. All right, Ms. Davis, I'll accept that. So yes, I'll overrule then on the objection on leading. You may proceed.
Let me ask it again.
That'd be nice.
Could it be that the wording substantially consistent used in that staff report for this particular project is because there are elements of the project that are not consistent with today's comprehensive plan and LDC, but are consistent with the DRI approvals already granted?
No, in my opinion, and again, it's been a moment since I've drafted a staff report, but if my recollection serves me correctly, the substantially should be what is utilized in this statement. While I agree that there are components that don't necessarily meet our current standard but are in keeping with the DRI, I don't think that was the reason this was attached here. But ultimately, I didn't author this report, so I can't speak too intelligently about that.
Understood. Thank you. That's all I've got.
Thank you. All right. Thank you, Mr. Schoen. All right, Ms. Davis, does the county have anything else?
No, Your Honor, not at this time.
Thank you. All right, Mr. Tatum, are you ready to proceed with the applicant's case presentation?
Yes, I am, Your Honor.
All right. You may call your first witness. Oh, did you want to do an opening?
Yeah, I was going to do a bit of an intro.
Okay.
Just an opening statement here. As you already know, I am representative of the H&S LLC, was the applicant for this Echelon condo project. Believe we have been through the particulars of the project pretty well. You will hear some more maybe redundant information from our witnesses. I apologize for that, but it can't be helped in this particular circumstance. This parcel has been vested for over about 25 years for 24 stories, 250 unit condominium. My clients did their due diligence before purchasing the lot. They came and met with county staff on several occasions to determine if what they were doing would be allowed, the proposed use. This is not a new proposal that is seeking approval. This is the culmination of decades, literal decades of planning, multiple DRI amendments, and substantial investments by my clients and the previous owners. It was all in reliance on the rights that were granted back in 2000 by the county. Subsequent approvals of neighboring projects have also shown that it's the county's position that this project is consistent with the area and the neighbors to the south. In your records, in the evidence that we have already presented, which I don't think we've actually moved them in.
Right, you have not.
So I would like at this time to move in the binder. I presented you everything in it. We will be relying on everything in there.
All right, so the applicant is moving applicants exhibits 1 through 20. Is that correct? 1
That's
through
correct.
20. Are there any objections?
No, Your Honor, I believe these have been previously disclosed, so at this point, there's no objection.
Mr. Seyfried? All right, so applicants exhibits 1 through 20 are admitted.
Okay. Also in there, you will find a legal memo from me in response to the legal memo provided by the opposition a month ago or so. The exhibits numbers in there also are referenced in my legal memo, will match the exhibit numbers from today. Aside from that, I will go ahead and call my first witness.
Oh, let me ask you a couple questions
Okay.
after opening. So the county's position, which has been expressed pretty well today, is that many of the requirements of the LDC do not apply because the DRI development order governs. However, the setbacks that are required in the LDC do apply. Do you agree with that position?
I do agree with that position. I agree with, unless the DRI specifically addresses a development standard, that a new standard later adopted would apply, provided that the new standard does not make completion of the entitlements impossible.
That was going to be my follow-up question. So what if applying the setbacks that are required in the code today prevents Echelon from achieving the height? Well, actually, I don't know if there is a height. It's stories that it's vested for, right? So let's just ask it in those terms then. What if applying the setbacks prevented Echelon from achieving the number of stories it's vested for? What's the position?
Then our position would be that those setbacks do not apply to us.
And is there, in the land development code for Walton County, a height of a story? Is story defined by height?
To my knowledge, story is not defined. I know that this was a point of contention several years back. The actual definition for setbacks were changed because of the use of the word story prior. But I do not believe we have a definition today.
Thank you.
Okay.
You may call your first witness.
All right. First, I am going to call our civil engineer, Mr. Jamie Eubanks.
Welcome, Mr. Eubanks. If you would please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Please state and spell your name for the record.
Jamie, Jamie, Eubanks, Eubanks.
And before you get started, I'm going to ask the parties if there are stipulations to expertise of any witnesses, if we could make those stipulations early on before getting too far into all of the background and education experience of the witnesses.
All right, Your Honor, I would tender Mr. Eubanks as an expert in civil engineering and site design. I don't know if there's an objection.
Is there an objection from the county?
No, Your Honor, the county would stipulate.
Okay. Is there an objection from the opposition? Okay. Civil engineering and
Site design.
site design. Okay. Mr. Eubanks is accepted as an expert in civil engineering and site design. And I do not mean, Mr. Tatum, that you have to forego all of the questions. I am interested in at least a sketch of his background.
All right, Mr. Eubanks, to that point, could you tell us about your educational background and training?
Sure, I have a Bachelor's of Science in Environmental Engineering from Tulane University.
And do you hold any special certifications?
I'm a registered professional engineer in the state of Florida.
Okay. What's your professional experience been?
So I've been doing this about 21 years, all within Walton County and the surrounding properties. I've worked throughout all of them. I've been a professional engineer now for 16-ish of those years.
And how familiar are you with the standards from the Walton County Land Development Code?
quite familiar. I've done hundreds, if not 1,000 projects.
And have you presented these projects before as an expert?
I have.
All right. So were you responsible for, or primarily responsible for the design of this project?
Correct.
If you would, please just briefly go over the characteristics of the project with the magistrate.
Sure. So, as I'm sure she's aware at this point, it is 24-story condominium, 246 units is the exact number now. Excuse me. Has some accessory space, spa, things like that, pool, and whatnot. You know, we met early on before this particular project ever started with county staff to go through the typical pre-application process, certainly asked questions of staff, got input, which led us to the initial site design where we incorporated the architect's building footprint into the site. In this particular case, this being a seascape and being a master plan DRI, a lot of the infrastructure for this development is in place: access roadways, water and sewer, stormwater stub outs, things of that nature. So really facilitating that into our project was the next step.
All right. And have you had an opportunity to look at the current stormwater plan that was approved for the DRI?
I have.
And does our project fit within the parameters of that plan?
So it does, and I reviewed this from multiple different sources, and I don't know how deep you want me to get into it right now or not.
But glaze over the top for the time
Okay.
being.
So essentially, the Seascape DRI, this particular basin area, drainage area, if you will, consists of just over 103 acres. And all that is treated through a master plan with what is known as Lake Stewart or Stewart Lake, depending on which document you read. And again, there's a master plan. So to our site is a 48-inch stub out for us to connect our stormwater to. And in reviewing that, we went back to review the drainage basin maps to ensure that this property was included in that initial master design. We worked with the county, and if you'd like, I can read in some of what the county wrote about it. So the county's reviewing engineer, DRMP at the time, we submitted this information and they wrote, and I will read slowly. The stormwater management facility for this development was included in the master stormwater plan for the Seascape DRI, which has been approved by the county. A 48-inch stormwater pipe was stubbed out to the property to allow for connection to the master stormwater management system. The stormwater management facility will continue to meet the Walton County standards. So again, we took the stormwater runoff from our site. We were lucky enough to have this master plan to connect to, and we did that. And while not necessarily relevant to this case, from the county standpoint, we did go a step further, check the DEP files, and again, confirmed, I won't read it all in, but perhaps I'll read this last piece that does say construction of a 250-unit, 24-story condominium within the Lake Stewart permitted stormwater drainage basin within Seascape Resorts in South Walton County has been determined to be exempt from requirements to obtain a stormwater treatment permit as established by Rule 62-25.020, parentheses 10, Florida Administrative Code. So I say that just to say that we reviewed it from multiple different perspectives to make sure they were consistent with that.
Okay.
And Mr. Tatum, is that document he's reading from an exhibit that has been admitted?
It has not been admitted, and that's what I was just sitting here thinking. I would like to move it in. I'm afraid that's the only version, only copy we have, though.
I brought
isn't it?
extra copies.
You did bring extra copies.
Yes.
Thank you very much.
Grab them here.
Man.
Yes, you
Okay.
are. Yeah, so if you
Grab
don't
them
mind,
now.
grab them for us.
All right, so you want to move it as applicant's exhibit 21?
That would be correct.
And is it is it multiple documents or? Hold on, wait until you're at the mic for me.
For the DRMP, because that's part of the staff report, so just.
Thank you. All right, so applicants are offering Exhibit 21. Letter from State Department of Environmental Protection, Notice of Determination of Qualification for Stormwater Exemption. Is there any objection? All right, at this time, applicant's Exhibit 21 is admitted. You may proceed.
Do I need to give the clerk one? Karen, are you good for this? Okay. That's what I was just thinking.
Yeah, just for the record, to make sure the parties understand, once again, under this operating agreement, I guess, between the Division of Administrative Hearings and the county is still responsible for the record. We want to make sure the clerk's office gets every exhibit so that it can be made part of the record. So before we leave today, we'll make sure. Thank you.
Understood. Thank you. Finally, is there anything else I should have asked you to address that I haven't thought of?
I was going to mention traffic. The opposing counsel and Ms. Schultz went through that in terms of the vesting pretty well. I will add, if I can find my document, Ms. Schultz read into the record the letter from DRMP about vesting, but she did not read the final statement under traffic impact study review comments, so I can't read that. And this is part of the
Also part of the
staff.
record already.
No further traffic impact study comments. Trips generated by the proposed development are vested under the previously approved Seascape Development of Regional Impact, DRI.
Thank you. And that's all I have for Mr. Eubanks.
Okay. Ms. Davis, any questions for Mr. Eubanks?
Your Honor, I don't have any.
Okay. And Mr. Seyfried? All right. Thank you, Mr. Eubanks. May call your next witness.
All right. Thank you, Your Honor. Next witness will be Philip Partington. He is our architect.
Please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, and please state and spell your name for the record.
Philip Partington, Philip, Partington.
Thank you. You may proceed, Mr. Tatum.
And I'm not sure there's going to be any stipulation on his qualifications as a expert in high-rise coastal design. That's what I'm seeking to qualify him as. So.
Okay, let's find out.
That.
At this point, I've never met the guy a day in my life, so I have no basis to give any kind of stipulation.
All right, well, let's hear from him then. We'll go through it.
I don't mind qualifying.
Let's go through it. All right.
All right, Mr. Partington, what would you say your area of expertise is?
I'm a registered architect, both in the state of Florida and nationally. I graduated from Tulane University with a master's degree in 1995. Worked for a large national firm in Atlanta, Georgia for a number of years, and then moved back to Pensacola, Florida to raise my family. And I've been a partner at SMP Architecture for the last 20 years. So a mixed practice, but the largest projects that I have done are coastal condominiums and hotels.
When you say you're registered architect in Florida and nationally, what do you mean nationally?
There's the NCARB is a process that you're accredited nationally and you can apply for registration in other states.
What did you call that? NCARB?
NCARB.
What does that stand for? Or give me the letters.
Oh, I knew you were going to ask me that. I think it's National Council of Architectural Records Board.
Thank you.
In your estimation, how many high-rise, medium, or I don't know if medium-rise is the right wording there, but condominium and hotel projects have you worked on?
Well, I've worked on quite a bit. Not all of them have been built, but probably 5 high-rise towers on the Gulf Coast, from Mississippi to Panama City.
Do you hold any other specialized knowledge relevant to this particular project?
Other than just having practiced for 30 years, no.
Okay, all right. Have you reviewed this project, the entirety of the application that we have submitted?
I have, yes. I've been involved since day one.
Okay.
As an architect, the first thing we do before putting pencil to paper is meet with county planning staff to determine what the entitlements are and the
All right,
setbacks.
hold on just a second. So, Mr. Tatum, have you completed the background experience and training
Yes.
questions? Okay.
So at
So
this
he's-
time, I would tender him as a
right.
expert.
Being offered as an expert still in high-rise coastal design?
Yes.
Okay. Ms. Davis, do you have an objection?
Not at this time, Your Honor.
Okay. Mr. Seyfried?
Fact, Your Honor, I don't know what coastal high-rise design expertise really is. So I object to that extent. Do I have objections that he's helped build 5 high-rises? No.
Right, right. So I have to say, Mr. Tatum, I'm not familiar with that as an area of expertise. I do note that when you asked Mr. Partington what his area of expertise was, he didn't say that. He gave you all of his background and then said the largest projects he's worked on are the coastal hotel and condo projects. So I guess I'm just not familiar with it as an area of expertise. It seems very niche. So can you help me a little bit more?
Well, probably the best way to handle it is just to ask to tender him, have him qualified as a professional architect, as an expert architect.
As an expert in architecture?
Yes.
How about that?
Yeah.
All right. Any objection?
I definitely feel much more comfortable with that.
Okay. All right. Mr. Seyfried? All right. So accepted then as an expert in architecture. All right. You may proceed.
All right, Mr. Partington. This is just some quick questions for me. Did you assist in the design of this proposed condo?
I did, since we were engaged, yes.
And as you were working through the design, you and your associates, did you take any special steps to design the project to help achieve compatibility with the surrounding area? And by that, I mean, are there elements to the project that are designed because of the proximity to the shorter buildings?
We did take that into consideration. So what we're selling is the view of the Gulf, and so the natural inclination would be to push the whole tower as far forward as you can. And in this case, it's terraced back, so the tower is pushed back on the site, and which diminishes some of the views of the lower units. And we also proposed enhanced landscaping in the right-of-way between the two properties. So I think those two items.
By the right-of-way between the two properties, do you mean along that southern boundary line?
Correct.
Okay.
Yes.
With that, I have no further questions for Mr. Partington.
Okay. Let me ask for a clarifying question. When you say the inclination would be to push it as close as possible to the boundary line, I assume you're referring to the boundary line that's closest to the coast.
Correct. Yeah, the southern
boundary line.
setback.
Thank you. Okay. Any other questions for him in light of the question I asked, Mr.
No, ma'am.
Tatum?
None for
All
me.
right. Ms. Davis, questions for this witness?
As far as the enhanced plantings that you're discussing, that's kind of outside your expertise, is that right?
Correct. We engaged a landscape architect.
I don't have any other questions.
Mr. Seyfried?
Mr. Partington, did you prepare these renderings that have been marked as Exhibit 16 for the applicant?
They were prepared under my direction, yes.
Did you review these renderings for accuracy?
I did.
Do you have another copy? Really, I think, Your Honor, you should have their applicant notebook.
I do.
Okay,
I've
we're
got
looking
it.
at 16. respect to the rendering that's shown here on page 2, the location of the building is set all the way over along the edge of Miramar, right? This boundary, this eastern boundary seems to line up with the middle of Miramar in this photo?
So, these are, just keep in mind, these are architectural renderings. The building was modeled three-dimensionally and was placed on the site plan as you have access.
Well, what I'm trying to get at, this is not an accurate rendering of where that building's gonna actually be built in relation to my client's property over here on Alamo and the Miramar properties. It's gonna be closer to them, correct?
I really couldn't say. So we modeled our building, so our building is correct. The background is taken from Google Earth, and the intent is not to show that.
Okay, so this rendering is not accurate with respect to what's around it. It's accurate to the building.
Correct.
Okay.
And yes.
Okay, great, thank you. That was my only question. Thank you.
Okay. Mr.
Just-
Tatum, any follow-up?
Just one more follow-up, Your Honor. On this particular rendering that he was asking you about, which is the second page of Exhibit 16. Just for the record, what direction are we facing?
You're looking south, so you're on the north side.
And if I were standing looking where that's at, would I be on the applicant's property?
No, you'd be hovering above the spray field.
Okay, all right. And is there behind this that can't be seen, parking garage? Or does that show the parking garage?
This shows the back side of the parking garage,
Okay.
yes.
So it's relatively accurate as far as our site plan goes.
No, it is accurate as
Okay.
far as our site plan
All right.
goes.
That's all I've got. Thank you.
Okay, thank you.
Thank you.
All right, next I am going to call Mr. Ken Metcalf. And Mr. Metcalf has a PowerPoint presentation he's going to present after we either get him qualified or get some stipulations.
Okay, great. You would please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, and please state and spell your name for the record.
Kenneth Metcalf, Kennethmetcalf.
All right, Mr. Tatum, you may proceed.
All right, so today I'll be seeking to qualify Mr. Metcalf as an expert in urban and regional planning and developments of regional impact. I don't know if there's an objection to that or not.
Ms. Davis?
No, Your Honor, there's no objection. I am familiar with Mr. Metcalf, and I would be of the opinion that he would qualify in both of those regards.
All right. Mr. Seyfried?
No objection, Your Honor.
Okay.
All right, with that, I'm
So
sorry.
accepted
you.
as an expert in urban and regional planning and developments of regional impact. Now you may proceed.
All right, since we did that, I am going to let Mr. Metcalf work through the presentation he has prepared for you that will answer many of the concerns that came up during the first witness. And then I will have some follow-ups after that.
Okay. And I'll just note for the record, Mr. Metcalf's CV has been admitted as Exhibit 10. Thank you.
Is that the front of your presentation? Okay.
All right, just so you'll know, I'm not seeing anything. So if it's important for me to see the presentation, it needs to be either on that screen or on this computer screen in front of me. And it could be that this monitor isn't on. I thought maybe it was going to come up over here.
Well, that's it right there.
Okay.
They just have to figure out what they want.
Okay.
They can't think of it.
All right.
Good afternoon, Your Honor.
Afternoon.
Let's go ahead and just go to the second slide. Today I'm going to cover 5 different subject areas, an overview of Echelon proposed development, very brief. You've heard about it already. I want to give some history on the seascape development of regional impact, because I think that context is, of course, very important here today.
And if you would bring that microphone down.
Or I'm not as tall as Stephen.
Well, few people are.
Consistency with the seascape development of regional impact, consistency with the Walton County Comprehensive Plan, and consistency with the Walton County Land Development Code. Next slide, please. So I'm not going to belabor the description of the Echelon project. I'll just direct your attention to the last bullet. Does it work now?
Yeah, you had to flip the button to turn it on.
Well, that helps.
It's
And
the
where do-
basics.
Where
It's
do I
the
point it
basics.
at?
You just
Oh, okay. Thank you. So as we've discussed, the 246 units on the 24-story building height are vested by the Seascape DRI development order. Here I've given a list of the Seascape DRI development order amendments. I'm not going to go through all of these and describe them. Suffice it to say, the important ones, I think, for our purposes today would be the ordinance number 2024 that was adopted on August 8, 2000. Ordinance number 2008-34 adopted on October 14th, 2008. And then the ordinance or the final order that was approved on November 22nd, 2022. Just so you understand, I served as the applicant's agent for that November 22nd, 2022 amendment. I completed that application, I filed it, I testified at the hearings, and I'm very knowledgeable about that amendment. I also want to just call your attention to the fact that the County Board of County Commissioners issued what they call a final order that's recorded in the Walton County official records. Staff also subsequently issued a final major development order in 2022 after the public hearing, and I'm going to talk about that because we have some concerns with that final order. So first, I want to make clear the Seascape DRI development order has not expired. The current build-out and expiration date is February 26, 2048. The way we reached that date is we had, as most consultants do, have filed a series of extensions, notices under Section 252.363 Florida statutes. And those all led to ultimately the April 11, 2041 date that you see at the top there that was included with the final development order issued by staff. And we agree with that date. And then we filed those subsequent notices that I have listed there that told and extended the expiration and build-out date. And of course, under the statute, it gives, it was amended a few years back, to allow two 24-month extensions. We utilized those extensions, and then once those were utilized, then the remaining notices were just for tolling. I want to show you the Seascape Master Plan because I think a visual really helps, and you haven't had one yet for what occurred in 2000. The Seascape Master Plan shows the location of the 24-story building, that allowable location, not the building itself, not the footprint. And that's denoted with a C with a circle around it. And that all occurs within an area that's referenced as Area A. And that same area was approved for the 250 dwelling units that you've heard about today. And importantly, that ordinance was not appealed. This is the 2000 Seascape Master Plan that was approved by that ordinance. And just to make clear where I've doctored it, you see the red circles. So I did that to blow it up and so that we could all actually read it.
Just a second. Can the clerk's office move the Zoom bar at the top to somewhere else on the screen, or if it could be minimized anymore? I know when I'm operating it, I can drag that whole thing around. I don't know if I can minimize it a little more. If we have a Zoom expert in the room who would offer assistance. All right. While they're looking at that, I don't want to hold it up anymore. So while they're looking at that, go ahead. I see the red circles.
Yeah,
That's
so the
where you are.
larger circle I superimposed. I superimposed the smaller one just to highlight the area, then drew an arrow down to blow that up for you. So what you're seeing in the bigger circle is exactly what's shown at the top that you can't see because of the screen. And what that shows is, again, that circle with the C inside of it, denoting the area where 24 stories is allowed. Below that circle, you'll see where I zoomed in and did a snippet of the southeast corner of the DRI so that you could see Area A. And as you can see, that references the 250 dwelling units. It references St. Andrews. Okay.
Thank you.
So that's the location. That's what we're talking about. That's the Echelon property. That's essentially the western 2/3 of the Echelon property. And as you heard about earlier today, in 2000, the master plan called for those 48 dwelling units in the right corner. Section 2 of that ordinance includes findings of fact. It's important to note that the Board of County Commissioners determined that the development at that time was consistent with all local land development regulations.
Were you trying to advance to another slide?
Yeah, I pressed it. Are we not on section 2?
No. Did I mess that up by asking them to try to move the bar at the top?
I don't know. Well, it would be nice if the bar were removed.
Yes, it would, wouldn't it?
It's going to cover a lot of my titles, I think.
Right, right. Well, the attorneys may never forgive me for this, but since we're trying to work on that, I'm going to ask you another question. So in your opinion, is the parcel or the project vested for any particular height? Does the 24 stories convert to any particular height?
No, it's just vested for 24 stories, and you asked earlier if there was a definition of story that in some way established the height per story. County has a definition in the code of story, but it doesn't mention a numerical figure for the height of each story.
Okay.
It's more like a description as you would expect from essentially the ground to the next story, the next floor,
Okay.
and from one floor to the next floor, so
Okay.
forth.
So as far as you know, is there a building code definition that specifies height of a story of a building?
I'm not sure if the Florida Building Code does
I
that.
think I would know, right? But
I don't think it does, because I've worked in a number of jurisdictions where it appeared the definitions had different
right.
different numerical standards.
Just for the audience, they'll know why I said that. So in a prior life, I was the Florida Building Commission's attorney and dealt with the rewrite or the development of the statewide building code. And I was trying to remember, is there any definition of story that had a height associated? All right, you may, can you not advance it? Okay. Is that the computer from which we're screen sharing? Yes. Okay. Oh, and so when you let's go off the record. Thank you. You can always remind me about that. Okay. When you take your cursor up there and try to move that bar, it doesn't move at all?
Yeah, it moves, but it doesn't move on
Oh,
the computer.
okay. All right, well then let's scrap that issue, see if we can get back to where he can control moving to the next slide then.
And what I can do is just read the title of of each slide, if that works, because I think that's probably the only part that's obscure.
Yes. Wait a minute, hold on. I know we're not on the record, but still.
The problem's gonna be is it's gonna disconnect.
No, not if you stop sharing, it shouldn't. Yeah. And the only people who are on there, did we establish, are they the expert witnesses who are waiting to testify?
I'm not sure who all the 20 people are.
Okay.
Our expert witnesses are here.
Oh, okay, okay,
It's just two clients that'll be testifying.
okay. Then would you have any objection, Mr. Seyfried, if we weren't screen sharing with them, if that helps with this presentation? Okay, thank you. If we can figure out how to do that. Is it possible that just this system interior here has frozen?
Not sure. I tried to get some technical support, but they're all in a meeting.
There it goes. Yay, look at that. Whatever you did, it worked. Okay. Mr. Tatum, the expert. Okay. Oh, came back.
But this still looks the same. Are you
still came right back.
I turned it back on and we're on a different screen here than what's showing up there.
We're gonna crowdsource the the solve to solve this problem.
Okay, here we go.
Okay. Well, I've given up on getting rid of the bar. He can read the titles. Let's just try to facilitate moving through this.
Like my printed copy?
No, 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 no. I'm fine. Thank you.
You want to turn this a little bit so you can see better?
Screen change?
I am. Thank you.
Yes.
Jeremy. Hey, thank you. So we're in our special magistrate hearing, and we've got the PowerPoint up, and we're also zooming it. And on the TV, there's a banner for Zoom that's over the top of the
I don't
slides on the
think him and
PowerPoint.
I can reach that.
And we can't figure out how to turn that off. Do you know how we can do that?
No.
Yeah, it's like a little, it's like a bar that is like a control bar over the slides.
It's the Zoom control bar.
That's the Zoom control bar.
Okay.
FYI, our internet did crash yesterday, so we're constantly having these.
So the title of this slide is Section 2 of Ordinance Number 2000-24.
Thank you.
And again, the point of this slide is that the Board of County Commissioners determined that DRI amendment was consistent with the comprehensive plan and the local land development code, land development regulations. And that would have included a determination of compatibility, presumably, unless they considered it already vested. But the ADA, the application for development approval for this DRI, actually authorized 24 stories, but not at this location. So I think they would have probably considered compatibility at that time. I haven't listened to a recording to know that for sure or reviewed minutes. This slide is titled Ordinance Number 2008-34, Development Order Amendment. So again, I'm just going to show you this 2008 Seascape Master Plan Amendment like I did for the last one. You'll see that the area in yellow is identified where the 24-story building and 250 dwelling units would be allowed. And that area is also it's an expansion to the east of what you saw on the 2000 master plan. So it fills out that corner that was previously 48 single family, allows the 24-story building and the 250 dwelling units to occupy the entirety of that parcel. And I mentioned the parcel number here. The master plan includes a note, and this is also in the DRI, that these are approximate boundaries. But I think it's a fair statement that the parcel number, as we're looking at it, corresponds with Area A. And that's where the Echelon development is proposed. Again, in this ordinance, same finding by the Board of County Commissioners that Section 2 of the ordinance that confirms that the development was consistent with the comprehensive plan and the local land development regulations. This is the 2008 master plan.
It didn't advance. Let's try it again.
Thank you. So you can see on this master plan, the corner, the yellow in the far southeast corner, and how it kind of filled out that eastern portion. And I'm going to advance to the next slide that just blows up that corner so that you can see the Echelon parcel back in 2008 that was vested for this use, for the 24-story condo and the 250-unit residential project. And you can see the surrounding uses to the south and to the southeast in this photo, or in this master plan.
Tell me what they are real quick, if you could go back to it. I'm assuming the parcel to the east is a spray field.
Is the what?
Is that the spray field?
Yes. And then to the south, the undeveloped area is Miramar Beach Villas. And then Summer Haven would be immediately to the left on your screen of that area. And then Sea Cabins farther to the left. Okay. And you can see the table. This is, of course, just you're seeing part of the table from the full master plan because I cropped it here, but you can see where it refers to the 24 stories and 250 units is remaining, meaning that those entitlements hadn't yet been utilized for development. I think I was describing something and I hadn't shifted forward yet. But
no, I was looking at the other picture and asking
Okay.
about the surroundings, so I can just see it a little better on this one. Fine, go ahead.
apologize for that. So the 2022 amendment is important to put in perspective. It didn't establish the vested right for the 24-story condominium and the 250 units. That was already established partly on the property by ordinance 2000-24, then throughout the entirety of the property by ordinance 2008-34. Importantly, what this amendment did was allowed for the option to be able to do 32 single-family dwelling units that we referred to as option A1 in the development order amendment application that we filed. And the idea there was that the developer was, at that time, the owner was considering, I should say the owner, not the developer. The owner was considering at that time whether to possibly forego doing the vested development and instead perhaps pursuing single-family units. And so we thought it was important to build that in as an option because market conditions change. You never know what may be happening in terms of financing and all kinds of reasons why it would be important to present that as an option. And I'll say that's not unusual at all. I mean, DRI development orders all across Florida have conversion matrices. They're sometimes called conversion matrices or matrix. Sometimes an equivalency chart is another term for them, but the idea is that you can convert one use to another based on equivalent impact. And I'll return to that point in a moment. This is the just the first page of the final order that was issued by the Board of County Commissioners for the 2022 amendment. And I just call your honor's attention to section 1A that says that the application for Seascape DRI amendment is hereby approved subject to the following conditions. And then A reads that the Seascape master plan authorizes and governs the location and types of land uses and development within the Seascape DRI. Boundaries on the Seascape master plan are approximate and subject to refinement during final permitting and so forth. That was the point I was making earlier, that these are approximate boundaries. Not particularly important for our discussion today, but This is the 2022 master plan. And I'll just give you a little bit of an overview, because this 2022 amendment involved more than just the option to do the 32 single family. You can see the yellow parcel in the southeast corner, same location that we've talked about before. The other yellow, a little bit farther to the left as you're looking at the screen, is an area where 200 units, a 200-unit tower could be built. The orange is an area where 4-story condominiums could be built. And then the red at the top are support commercial areas. And one of the interesting things that I thought we worked out on this that was, I think, helpful is how the uses would be adjusted if there was a conversion. So if you look at what you're looking at here are the notes from the master plan. I'll just go back for a moment. So if you look at the full screen master plan, you see those notes to the right. That's what I'm showing you blown up now. Okay. And then I zoomed in on the parcel again. So let me just read into the record. Note 1, parcel A may be developed with a 24-story building / 250 high-rise units, or may be converted to 32 single-family detached units using the conversion chart from option A1, resulting in a balance of 175 high-rise residential units, which may be transferred to parcels designated with a 1 and utilized for multifamily use. Transferred units may be converted to commercial or office uses subject to the PM peak hour conversion chart. All development on the identified parcel shall be limited to a maximum building height of 50 feet or 4 stories. So those, if we were to have converted and built 32 single-family homes instead of a tower, it would have allowed the equivalent of 175 residential units to be transferred to the locations identified with a 1 throughout the Seascape DRI. And those new locations would all be subject to the 50-foot height limitation. So we propose that, of course, to provide flexibility for the lot owner, but also with the idea that if that option were pursued, it would achieve greater consistency with what the county was trying to do with its 50-foot height limitation. I'm really concerned that the opposition has suggested that somehow that divests our right to do a 24-story tower. I think that's just nonsense, frankly. That's a really problematic position to tell a developer or landowner, you have vested rights, but if you try to propose anything that the county might like better, we're going to take your right away. I don't think the law reads that way. I don't think it makes sense from a policy perspective. It's very problematic. This is the table that's on the Seascape Master Plan. You can see on the right side of the screen or on the table, you see the 1,093 units remaining to develop. That's a combination of the 24-story condos, the 250, the 12-story condos, the 200, and the 4-story in the orange area, the 643. And then you'll see that we included a double asterisk at the bottom, a footnote, indicating if that option A1 is implemented, that those numbers, of course, would be adjusted accordingly. So I'm going through that background to make sure you understand from our perspective what we were trying to accomplish with that 2022 amendment, and in our position that a developer shouldn't be penalized for exploring those sort of options. So this is section 163.3167, parent 5, Florida statutes. This is the vesting provision in the statute. Nothing in this act shall limit or modify the rights of any person to complete any development, sorry, I'm going a little fast, that has been authorized as a development of regional impact pursuant to Chapter 380, or who has been issued a final development order, and development has commenced and is continuing in good faith. That language was modified a little bit compared to how it read back in 2008, but the gist is still the same, that a DRI has vested rights. And as long as that DRI is making a good faith effort to proceed with development of the DRI, it maintains that legal vested right. Walton County adopted a similar policy. Policy L-1.11.1 states in part that development with a final development order issued on or before November 7, 1996, where development has commenced and is continuing in good faith as of this date, or development authorized as a development of regional impact pursuant to Chapter 380 are vested. So this is essentially mirrors the statutory language, not exactly the same, but same concept, same legal right. Seascape has continued in the development in good faith over the many years. They've built a town center. They're currently working on a major project, the Grove Phase 1, that's in that orange area that's allowed 4 stories. It's been lots of development activity, lots of planning work going on. They've been reworking their stormwater system and their golf course over time. It's an evolving project. It's a big project, to be sure, and it requires adjustments over time. As I mentioned, we were somewhat concerned about the final development order issued by staff, and I'm going to talk about a couple of the conditions in that final development order that have raised our concerns about it. And I will say we had concerns with it and voiced those concerns at the time that this order was issued. Part of our concern, frankly, is the procedural approach of the county staff imposing additional conditions after a DRI development order was approved by the board. And that final order, if you look at the board's final order from my previous slide, we have it, I believe, in our exhibits. That final order had just 4 conditions to it. The order issued by staff added quite a number of conditions. In the concern we have, at least procedurally, is that Section 380.06, Parent 7, Parent A, states that for any, or stated in 2022, and I don't believe that the language has changed, that for any proposed change to a previously approved development of regional impact, at least one public hearing must be held on the application for change, and any change must be approved by the local governing body. That's the board, not staff.
And was this development order ever challenged?
No, it was not. And
Mr. Tatum, are you asking me to be rendering some sort of opinion about the major development order issued by Walton County in 2022? Because I don't think I have that authority.
I agree with you. You do not have that authority.
Okay.
Wrong forum, wrong parties for that.
Okay, thank you.
And I'm just going back through the backstory to give you some context.
Okay.
And the main reason we were concerned was condition number 3. Because condition 3, the first part of it's fine. The first paragraph just recognizes that that based on the county code and the comprehensive plan, that construction must commence. We thought that language was a little odd because construction had already commenced. It's been going on for decades. So I'm not sure, we looked at it and thought, well, we're not quite sure what it is that we're supposed to be commencing that's different than we've ever done. And we didn't think that really made sense, but we didn't have any concern with it really because we thought that, we could show that development had indeed commenced. So it was really the warning, and it's written in red, and this is a standard warning that you see on staff's development orders, that if the applicant has not obtained a building permit or has not commenced construction within 1 year of issuance of the final development order, the final development order will become null and void and the application for plan approval must be reinitiated. Very concerning. from a developer and landowner's perspective that already has a vested right. And it's particularly concerning because, as I mentioned before, all that the 2022 amendment did with respect to the Echelon site is to allow an option. It didn't create any new vested entitlement. So why we would need to proceed with anything to maintain our entitlement really was puzzling to us, and we don't think is consistent with the law. And then they have the note below that, and this, when I talked to staff about it, I said, well, at least recognize that we have an unexpired development order, and that as long as we continue in good faith, pursuant to the statute and your own comprehensive plan, that our DRI would not terminate, would not expire. So again, from a procedural standpoint, we don't think that staff could impose a condition that wasn't in the Board of County Commissioners' final order that would somehow void the order issued by the board based on a staff condition. Similarly, we didn't think the warning made sense, as I mentioned, because development has already commenced and has continued in good faith. We also feel that the note 3, or the note in condition 3, essentially supersedes the warning. And with all that said, though, we did pull up, our client did pull a permit, the Seascape Town Center 08 LLC, which is was an owner of a portion of the property within the DRI, applied for and obtained a building permit within just a few months after the development order, the 2022 development order amendment was issued, and completed construction just a month later. This is the permit. This is the certificate of completion. So we satisfied note 3, and frankly, the only reason I'm going through this is the opposition has suggested that somehow our DRI has expired, which we disagree with, both from a legal perspective and a factual perspective. So let's focus again on the vested rights, because I think it's important to, back to the earlier conversation that we were having about the distinctions in terms of what's vested and what's not vested. I don't think there's any question that the building height and the density are vested. Where it becomes, I think, a little bit interesting is how we look at some of the other issues.
And I noticed that you're now saying building height and density. You mean the number of stories?
Yes, and thank you for that clarification.
Okay. I just want to make sure that I'm not unaware of some, actual correlation between the number of stories and a particular height. So,
a very good point. It's important to recognize that the Seascape DRI has always been vested from transportation concurrency. The entitlements haven't changed over time. Where they occur on the property has evolved through a number of development orders, but the overall entitlement has been vested for transportation concurrency from the get-go. This project will draw down 246 of the 250 vested units when Parcel A is developed with the Echelon project. Again, it's also important that from our perspective, that the major development approval include a condition limiting the accessory uses to the use for use by only Echelon residents. You heard testimony from Ms. Schultz earlier today, and I don't want to backtrack through a bunch of slides to go back to my my 2022 master plan amendment, but I should have pointed out to you that, and you can look at it in the record, Note 3 essentially said any of the areas that have a 3 identified within the master plan graphically would be able to develop with accessory uses, including a restaurant and club use and spa and those sorts of uses, provided that only seascape residents would be allowed to use the facilities. Our client, H&S, really wanted to restrict the use even more. And this is the only reason this is an important point is I want to make clear for the record, tied back to transportation concurrency, that these accessory uses don't create additional transportation impact. Those trips that are already accounted for the residential would have accounted for any activity supporting those accessory uses. And so that's all built into the trip rate that you would that these analyses are based on the Institute of Traffic Engineers trip generation manual. So lots of condominiums have accessory uses of one sort or another. That's all built in because those sort of uses do, they generate workers, for example, but that's all built into that composite average, if you will, trip rate that's utilized. So that's all part of the transportation concurrency vesting is the point. And I've listed out what those different accessory uses are from the site plan that you see there. And, my understanding is those may be adjusted down, but for now, that's part of the site plan approval that we're seeking.
Okay, yeah, I think you need to advance it one. So, okay, there we go.
So those are the uses, the accessory uses that I mentioned. We're getting close here. Echelon is consistent with the Walton County Comprehensive Plan. I mentioned ISR here because it was on our site plan, but I do agree with Ms. Schultz that it's only applicable to non-residential, so it doesn't, I probably should have just left that off because it's not an applicable standard. But if it were, we're well below 85%. I think we're at 60% or something close to that. So we're consistent with the Walton County Comprehensive Plan, except in regard to our vested subject areas: density, and I'll say building stories, not height, compatibility, and transportation concurrency. Compatibility is an important point from the vesting perspective because number one, it was already determined to be compatible when the Board of County Commissioners found the 2000 and the 2008 amendments consistent with the comprehensive plan. But also, compatibility is one of those issues that, if it were applicable, could potentially impact the ability to do 24 stories. I mean, I would have my view potentially of what would be compatible or not. It's really academic because the determination's already been made and it's part of that vesting package, if you will. But our vested rights aren't without limitations. And I think this is an important point when we talk about setbacks. And just to make a procedural or legal point clear, that under section 380.067, it ties back to the vesting language in chapter 163. And so even to the extent that one might debate whether the 2008 development order should have been approved or not, once it's approved, it's vested. And that's what the statute clearly states. So I don't really understand the opposition's argument in trying to suggest that somehow the 2008 amendment should be questioned. That doesn't ring true to me. I don't understand the argument based on statutory language. That development order was not appealed. It was effective. And our 2022 amendment didn't change that. That's important because they're very much focused on, did somehow the alleged notice issue in some way result in invalidating the 2022 amendment? Well, even if that were true, the 2008 amendment would then still stand and allows the use. So we don't see that as a relevant factor at all. You've already heard from our architect. They did make an effort, notwithstanding our vesting, to try to be good neighbors and set the tower back with a staircased approach. Seascape development order doesn't include a setback standard. I think it's a matter of law, and the lawyers can debate that point about whether somehow the approval of the Seascape DRI development order vested it from all future provisions, all changes to the comprehensive plan and code. My view is I don't think that's the case. I don't think that's how the law reads. But it does vest the development order against any new changes that would prevent us from carrying out our vested development project. Admittedly, when you think about setbacks, that's a difficult evaluation to make because you would have to go through any number of scenarios to figure out if a particular setback standard might prevent you from actually achieving your 24 stories in your 250 dwelling units. I don't think it should matter here, and the reason is that I don't believe that footnote 1 applies, and I'll walk you through my reasoning for that.
And just remind me what footnote 1 says. I mean, I remember, but it's been a little bit.
Footnote 1.
It's the increased setback requirements, right?
That's right. It requires a half a foot.
For each foot over.
Yes, for each foot above 36 feet, it requires a half a foot of additional setback. This chart is from my report that's been, I think, included with the exhibits. As you'll notice in the right-hand column, I have a number by each of those, and the reason is that in my report, I have the footnotes that goes through my more detailed evaluation of each of those items, but I've summarized it here in the PowerPoint. And so when you see a number, when you see a number, it refers back to this chart. So 115 Alamo Street, I feel very strongly that this is a short-term vacation rental unit and not a single-family detached or attached unit. You review LDC section 2.02.20.b. It enumerates the primary uses allowed in the Coastal Center zoning district. It clearly distinguishes between short-term vacation rental units and single-family residential units.
Is this the parcel that Mr. Seyfried's client has a unit that adjoins in the southeast, to the southeast corner? Is that the one we're talking about? Not the one due south, but it's southeast
Correct.
corner. Okay, thank you.
Correct. And again, the footnote 1 applies only if the adjacent existing use is single-family residential use. The LDC includes a definition of short-term vacation rental. It's a public lodging establishment. It's not a single-family detached unit. And the Chapter 509 also includes references to public lodging establishments as well. They're clearly regulated in a different way than single-family, and they have a different function. It's also, I think, really important when you think about some of the arguments that have been made about compatibility. You know, it's one thing to require a special setback because you have a single-family neighborhood that might be adjacent to a tower. I think it's quite another to have a short-term vacation rental where those folks come in for a weekend and they party and they enjoy the beach and everything people do at short-term vacation rentals. And frankly, from a compatibility perspective, they don't warrant the same level of protection. That's my perspective, but that's also why the board made the change. That's why the board changed their setback requirement. And I'm going to also mention, before I leave 115 Alamo, that my position is that the setbacks apply perpendicularly. Every setback I've ever reviewed with a local government code applies perpendicularly to the property line, not at some diagonal angle. So we showed that diagonal on that exhibit for illustration. And we're going to talk a little bit more about that measurement because there's an issue that's important for us to discuss, but I'll hold off on that and let me just finish up this PowerPoint. Sea cabins is the farthest use to the left that you were looking at earlier on the screen. The adjacent use is common area for the sea cabins project.
Let me query you a little bit on this. So the parcel itself, as a planner, if you had to tell me what is the use of that parcel, what would your answer be?
I'm going to ask you to clarify a point, though, because you use the term parcel. And so what I want to get at is
the property, because I don't really know whether it's more than one parcel in terms of, the county's, the tax parcels. So that property that Sea Cabins is developed on, as a planner, what's the use of that property?
Well, I recognize the common open space, the common area, but it's not a distinguishing factor for sea cabins, really, because sea cabins is, I don't think even the opposition would debate this point that sea cabins is a multifamily development. To answer your question more directly, I do view the entire property as a particular use.
What use is that?
Multifamily.
Okay.
But I will point out that the definition of use within the county's code recognizes land and it recognizes buildings. So it does, to a point, make a distinction. And the reason, and it doesn't matter so much for sea cabins, but it does make more of a difference when we talk about Miramar Beach Villas, and I'll get to that.
Well, and maybe this applies then too. So let's just say, for example, that that property, not parcel, that property were residential, multifamily, but the area closest to the northern property line of Sea Cabins, or closest to the southern property line of the project, was for some reason in conservation. And so there were conservation easement there. Would your opinion be that the setback requirement set forth in, I do not know the number of the code section anymore, but we've looked at it a number of times already, would be dependent on the use of that portion of the property for conservation rather than the property being developed for multifamily?
I'm going to answer your question in two ways. From a planning perspective, when we talk about use of land, I think we do look, particularly development use of land, we look at more than just the open space areas. A conservation easement, by definition, wouldn't be a development area. But one of the concerns I have, and this is a definitional issue like often occurs, is there's not a definition of adjacent in the Walton County Code. There's a definition of abutting. The opposition counsel read part of the definition of adjacent, but he didn't read the entire definition in his own exhibit where it refers to a common property line. That's an important distinction.
But you've determined, though, for purposes of your opinion that you're explaining to me now, that the common area for Sea Cabins development is the adjacent use, correct?
It is, what I'm suggesting is because the code is not clear on that point, and because there is a common definition that would recognize that it could be applied as abutting. If it's abutting, then yes, the common open space, the common area would be abutting, would be considered adjacent based on that common dictionary definition. One reason I think it's important to focus on these definitions is goes back to the Rinker case that zoning is in derogation of property rights. And for that reason, I think that case fairly states that an applicant's entitled to some deference in terms of applying interpretations when the code isn't as clear as it should be. I mean, they should have a definition of adjacent in their code, particularly when you have a setback requirement that's this important.
Well, and we don't work in an ideal world, though. We got to work with what we got. But so back to my my scenario where let's say it's the exact same area that is now common area for Sea Cabins. Let's say we're in a conservation easement. So what would your opinion be as to the use adjacent to the project?
Well, in that case, I mean, a conservation easement would be a use. It's an open space use. It's not a development use. And so, I think one argument is, just to be forthright, the setback provision where it requires an additional setback where it's adjacent to an existing single family use, one could read that to suggest or to imply in some way that the comparison maybe is for development. That is it a single family development, or is it a multifamily development, or is it a short-term vacation development? But the words don't say that. It simply asks, is this a short-term, is the adjacent existing use single family? And so that's the problem I have with the language. Is I think it allows for an interpretation that would recognize that common area. As a planner, I don't dismiss the point you're making, which I think is the broader use of the property is beyond just what the open space or common area might be. But then it goes back to that definition of adjacent. And that, so I'm trying to be candid in what the struggle was in evaluating these definitions, looking at the layout of the developments. It's not an easy determination for that reason. Summer Haven, again, this is clearly a multifamily development. Each structure has 5 units. So.
And where is this one in proximity to the project?
It's between it's to the south.
Okay.
And it's between Sea Cabins and Miramar Beach Villas. Footnote 1 doesn't apply. So it doesn't apply to Sea Cabins, doesn't apply to Summer Haven. Now, Miramar Beach Villas is where I think it gets a little more interesting. So again, we have the common area issue, but I'll just be frank about this. I mean, I really focus on the short-term vacation argument. I believe that is the clear use of these properties. It's documented, they're registered. You'll see that in our documentation that we submitted in our exhibits and in my report. I attached the documentation, not just the county's registration, but advertisements for the properties. That's true for Miramar Beach Villas. That's true for 115 Alamo. That these units are not being occupied as single-family units. Now, I know that there was some question or concern by Ms. Davis as to whether the county should evaluate it that way, and I'll just say I think this is the reason that Ms. Schultz didn't agree with me based on direction from her counsel, and they can speak to that. But the reason I was given is because of the statutory limitations that preempt the local government's ability to regulate short-term vacation rentals in a certain way. So if you look at section 509.32, parent 7, parent B, that statutory section, it preempts a local government from prohibiting short-term vacation rentals and from regulating their duration and their frequency. I don't see any problem with recognizing that their own permitting code, their own land development code recognizes it as a distinct permitted use. They're not prohibiting it, just the opposite. They're authorizing it, they're enabling it. They have a registration program.
Let's say though that they, the owner of Miramar Beach Villas decided they no longer wanted to rent as short-term vacation rental units. And so they, surrendered their certificate to the county. I don't know if the county has a limit on those in a lottery or something, but let's say it was valuable and they surrendered it. It sounds like your opinion wouldn't change though, because the fallback is, or the option for you is that they're not single-family attached units, though they are multifamily based on the development order. I don't remember what year that development order is. So these are alternative arguments that you have, right?
That's
Okay.
right.
Okay.
I will say though, I'm more comfortable with the short-term vacation rental position. That's
Your strongest
my
argument.
first
Okay.
and foremost argument. And we talked about the very question. It was a great question as to, well, these uses can change over time, a short-term vacation rental, but I think the response to that is that the code section uses the word existing. Is there an existing single family? And I think in fairness to applicants, that can only mean at the time that you get your development order, is there a single family home there? The answer is no. It's a short-term vacation rental. I struggled a little with Miramar Beach Villas in classifying it and considering it as a multifamily because of the definition of multifamily structure. On the other hand, if you're not multifamily, I don't think the default means you're single family. I think it means that what we have here is a bit of a hybrid that one could argue is multifamily and non-conforming to the definition. One point I would raise, and it's my fourth bullet, is if you look at the parking in Miramar Beach Villas, the parking is not within the single family short-term vacation rental lot. Not within the lot. It's common parking, which is a characteristic of multifamily development. And if you read the definition, not the definition, if you read the parking code there of Walton County, it requires that the parking occur on the same single family lot. And so that's another example where it doesn't comply. If you look at Miramar Beach Villas and you look at the layout, the way that project has been developed is not developed as a standard single-family neighborhood or even a single-family attached neighborhood, because if it were based on the code regulation, it would have parking within each of those lots, but it doesn't. Instead, the parking occurs in a common area, just like apartments, just like multifamily condominiums. That's part of the reason I struggled to suggest that it was clearly multifamily because of the definition, but I got the same problem in trying to call it single family when it doesn't meet the standards in the code for a single-family lot. Having said that, I think really the right proper determination is that it's a short-term vacation rental, and those other issues are somewhat moot. For the reasons I described earlier in going through the limitations of our vesting, my opinion is that LDC section 1.07.02.c does not apply. This is an interesting provision because you have to read the language very carefully, and I've highlighted in yellow, I think the most important language, must meet only the requirements in effect when the DRI was originally approved. I view that as an allowance. That is, even though it uses the word must, it's saying if you're a DRI, you're not required necessarily to meet our new standards. If you're vested, or whatever the scope of your vesting would be as a DRI, you're allowed to rely on those original standards as to those vested attributes, those vested development standards, density, building stories, transportation concurrency. And then the final sentence that I highlighted is, it states if a DRI development order has been amended since May 1, 1991, the changed portions of the DRI only may be required to conform to the requirements of this code. So there the county, I think, has said, okay, if you're making amendments after our code came into effect, then we've got the right to apply the new standards. But a DRI developer that's vested would always have the right to proceed on non-vested, based on reliance on non-vested standards that are in the current code. I've never heard of an argument that somehow because you're vested, you have on the one that you have the right to develop according to all former code standards at the time you were approved and not have to comply with standards that don't affect your ability to carry out your vested rights. I think that's an extreme argument to make, to suggest that somehow we would be governed by a former setback. And even if we were, to the extent, back to our earlier discussion, even if we were, to the extent that that former setback would preclude our ability to carry out our vested rights, it would be a problem. It would not be applicable because of the statutory language and the comprehensive plan language itself in the vesting policy that we went over earlier. So I'm very comfortable with the position that this project would be subject to the current setback standard that was adopted in 2019, particularly considering that Board of County Commissioners essentially doubled down on that in 2022 by approving the amendment, even though, as I mentioned earlier, the amendment just didn't affect our vested rights, just allowed other options. Echelon is consistent with the Walton County Code. I'm not going to go through all those regulations. You've heard about those already. And the last point I want to make just has to do with access. Back in 1991, the development order required that the DRI developer carry out certain improvements, construct a new entrance that they called the US 98 bypass. And the idea was to be able to essentially disperse the DRI traffic through two different points, the north connection, the south connection. Once those improvements were done, they eliminated those access conditions. So my position is the DRI should be vested at this point from any operational requirements related to traffic analysis. because the development order program hasn't changed. It's still the same amount of development that ultimately reaches either the south end or the north end. Having said that, we went ahead and had an operational traffic analysis completed, and that analysis confirmed that the access intersections operate at an acceptable level of service, even though, again, we're vested from transportation concurrency. And it confirmed that the gates operate properly on Seascape Boulevard, where they're not resulting in a queue or adverse impacts to Scenic Gulf Boulevard. And with that, I would just conclude that, based on the presentation and my report that we've entered into the record, that the project's consistent with the Seascape DRI Development Order, the County Comprehensive Plan, and the County Code. And it would be important, though, to include that condition about the accessory uses being limited to Echelon, because I don't want any confusion that somehow those uses should be treated as commercial, because there should be no drawdown against the DRI commercial entitlements for those accessory uses. But to make sure that occurs that way, it's very important that we have a condition in the final development order. Thank you.
Tatum, see if he's got questions for you.
Mr. Metcalf, very recently during preparation for this hearing, did you discover an anomaly about what the property appraiser's website shows in relation to the 115 Allen property?
We did. I have in-house GIS analysts. In reviewing the deeds, we noticed that the property lines were in the deeds for 115 Echelon and for the
115 Alamo.
115 Alamo, thank you. I'm getting a little tired, I guess. We noticed that the northern boundary of 115 Alamo should line up directly with the northern boundary of Miramar Beach Villas and Summerhaven. And the reason we know that they should line up directly is because they're supposed to be on the section lines. In other words, there's a description, and you'll see this also visually on the Miramar plat, that section lines should be uniform. That is, there should not be a jog that occurs when you look at the property line in the southeast corner of the DRI relative to 115 Alamo. I will say, and that's our drawing, the site plan that was submitted shows a 15-foot offset. And that 15-foot offset that's identified on that site plan is because that's how the property appraiser has shown the parcel boundaries, but it's not correct.
So these are the parcel boundaries as shown on the property appraiser's map for taxation purposes.
Right, and
or assessment purposes, let's put it that way. Okay.
And importantly, because that boundary should be uniform and is uniform based on the legal descriptions, that makes 115 Alamo not adjacent. It makes it catty corner to the Echelon property.
And just to tie that up, because this evidence is in the record, to begin with, Exhibit 6, can you identify that exhibit?
Yes, this is the revised plat of Miramar Beach.
And in the upper left-hand corner of that property, where you can see the upper left-hand lot, that would be the northwest lot, is that lot 12, which is the 115 Alamo property? Is that lot number 12, the 115 Alamo property?
Yes.
Okay, and what does it say the corner of that property is?
Section 33 township to
That's okay. The section 33 is what I was getting at. All right. So now let's flip to exhibit.
Well, let me interrupt because I'm going to ask you a very similar question about, my authority in this procedure. So I'm going to ask your witness first. So, Mr. Metcalf, as a planner, when you're, approaching a project for a client, what data is it that you rely upon to determine what the surrounding properties are in terms of zoning or comp plan designation? I mean, what maps do you rely upon reasonably?
We always try to rely on the deeds if we can.
So, are you submitting deeds for me to look at as a part of your exhibits?
I will be putting, it's actually already in the record, it is the deed for the Echelon property, only because the legal description shows that our southern boundary is the section 29 is the southern boundary of section 29, and that is directly adjacent to the Miramar Villa or the Miramar Beach plat that he was just referencing, which is exhibit 6, which shows that in reality that the 15-foot offset that the property appraiser's office shows should not exist, and that actually shifted down. So that does mean that our dimensional analysis is off, but it's off in two ways. It's off because it provides a larger setback in reality, and it's also that particular property is no longer adjacent to us.
So, my follow-up question to you, though, is what gives me the authority in this proceeding to go behind the determination of the Walton County Property Appraiser's Office in determining the boundaries of the properties in these cases?
I'm glad you asked that question. The Walton County Property Appraiser's Office on the website where this information was pulled from, where they have their parcel maps drawn, specifically says they are not surveys and should not be relied upon for such purposes. So your job would be to look at the recorded record evidence, which would be the plats for the subdivisions in question and our deed to determine should these property lines actually align, and if so, determine that at least 115 Alamo is not actually adjacent to us, or that our setback is even more increased.
Okay. Just a note then to all the attorneys to make sure you address that issue in your proposed orders to me, because that's going to be an important legal issue as to the limits of my authority and what my jurisdiction is. Okay.
As we discuss that, this is in the record, at least it's in the county's files for our application, which is the deed for the property. I'm going to go ahead and put it in the record here just for safety reasons, but this is not something that I'm springing on Mr. Seyfried because I did not provide this in my original submittal to him.
So this is not in the record in the staff report anywhere? This is something new that you want to submit?
I don't believe the deed is ever attached to the staff report. It's in their files because we have to turn in a deed whenever we submit an application.
Okay.
But I don't believe it's anything that's been presented as record evidence to you.
All right, so applicant is offering. Let me get to the numbers.
22.
Would be 22. The applicant is offering as exhibit 22. The deed for which property? The Echelon property?
The Echelon property, yes,
Okay.
ma'am.
All right, is there an objection from the county?
As far as the question of whether or not the decision should lie with you on whether this is an adjacent property or not, I mean, if this is not the forum for that decision to be made in the county's opinion. Your job, in the county's opinion, the jurisdiction that has been given over to you is to decide whether or not based on quasi-judicial level of review, if this particular project meets development opportunities for the Board of County Commissioners to grant a development order. Whether or not this property is an adjacent property or not, that would be something that there are other forums that Mr. Tatum can appeal to make that decision. This would not be it.
So, but I have to make that determination by either accepting the county's determination, which in your staff report, it is adjacent at least by 15 feet, or accept the applicant's argument that I have some authority to determine it's not adjacent by 15 feet. So that's why I'm asking, I'm asking all of the attorneys, I want to see that legal issue addressed in your proposed orders. I tend to agree with you that I don't have the authority to do that. It's way outside of the jurisdiction of what even if this were the Board of County Commissioners sitting here, because I'm really just standing in their shoes for purposes of conducting this hearing and rendering a recommendation as to whether or not this proposed project meets the Land Development Code and the comp plan. Again, right now, as I sit here, I tend to agree with you. It's outside of my jurisdiction, but that's why I want y'all to address it in your proposed orders. So let's get to the issue of whether or not you have an objection to the deed coming in.
I don't have an objection to the deed coming in. I have no problem with that. This is just the first time that issue has been thrown out.
Okay.
And so, I've seen nothing requesting a declaratory judgment from a circuit judge. That one just caught me off guard.
If I could, there would be nothing to ask for a declaratory judgment from a judge for until the property appraiser did not adjust their lot lines on their parcel maps. This is not the record evidence is what the record evidence is, not the property appraiser's website.
Okay.
Anyway.
Mr. Seyfried, do you have an objection to the deed for Echelon property?
Yes, Your Honor, we do. We had an agreement at the last continuance that they would provide all of their exhibits for this hearing to us 15 days ahead of time. And they're springing this on us at the very hearing when they called foul, when we sent them our 30-some documents ahead of time. And now to come in with an argument saying, one, that the property's not platted right or the legal description's not platted right, it's not competent substantial evidence because you need a title report or a title boundary survey by somebody authorized to do it. And what you have in the staff report is clear evidence that this property, it's abutting or it's adjacent. It's touches. It's catty corner. They touch each other. So it's really a non-issue as well, and we'll get into that. But yeah, we would vehemently object to this, not based on due process or based on due process grounds, because there's not any rules for this except the ones that we made at the last hearing, which was agreed upon. Thank you.
Okay.
And just in response to that, I would say that it's in the file for the project online already. I did not even have to put it in evidence because it is already in your portal of evidence that you would receive. I was just doing it out of abundance of caution.
Okay. So what I have admitted in evidence is county's Exhibit 1 with inserts is the term that they use. So that's why I was trying to clarify earlier when I asked you, is this a part of the staff report with inserts?
Well, then, no, it is not part of what the inserts were.
So then it is not in evidence. It may be in a portal somewhere, but nobody's moved it into evidence for this proceeding. Mr. Seyfried is correct. I do remember that was one of the issues. He asked for an accommodation since I was, inconveniencing him and his clients by granting that continuance last month, that there be a deadline for the applicant and the county, I guess, but I think it was more directed toward you and your client, of exchanging any proposed exhibits 15 days prior to the hearing. So I am not going to allow it, not going to accept applicant's Exhibit 22.
Before you rule, which is too late now, but I disagree. And the reason I disagree is this is a public record. This is something he could easily have gotten, should have gotten, doing his due diligence on this project. This was also evidence or in the record. I know what record may be the wrong word. It is in the documents that were submitted as part of our application, which I know they requested through public records, a copy of our application, which means they had the deed to begin with.
Okay. The public record is not determinative here. I mean, you could propose 15 exhibits that are all public records. The point is that you put them on notice in advance that you wanted to move it into the record of the quasi-judicial hearing. So I'm not, for the record, I'm not accepting applicant's exhibit 22. And while we're on that issue, you indicated in your exhibits that I have admitted in your binder, it includes a legal memo that is in response to Mr. Seyfried's legal memo.
That's correct.
I'm going to ask, I haven't, looked all the way through the portal, but I don't have a legal memo unless it has been somehow delivered to me. So I want to make sure, Mr. Seyfried, that whatever legal memo it is that you want me to have for purposes of this proceeding, that it is actually in the record of the quasi-judicial proceeding or otherwise somehow submitted to me.
Yes, Your Honor, it's part of one of our exhibits. It'll be in the notebooks that you take
Okay.
with us. There'll actually be two memos in there, and I know they had filed a memo recently too. I don't view memos of law as exhibits. They're within the exhibit package.
Right. I just
But they're not
wasn't sure. And you haven't actually moved your exhibits at this point.
Not
I
yet.
assume you're going to do it in your case in chief, so we'll make sure it gets in. I just, because Mr. Tatum was referencing his legal memo in his exhibit packet in response to something you had submitted, I wanted to verify, how it's being submitted, and let's make sure I don't get away without legal memoranda. Otherwise, you could always attach it as part of your proposed order.
Proposed
too.
order, right, yeah, thank you.
All right. So what's
Ken,
next?
I had a couple more. I
Okay.
had a couple more questions for him before we off track.
He wanted to rest his legs during
I'm sure. He's been up here a while.
standing a while. Okay.
As far as short-term vacation rentals go, do they have additional requirements per county and state
Additional,
as opposed to being a typical single-family residence? Are there additional steps that the owner of a short-term rental is supposed to take at either the county or state level?
there are, certainly at the county level, they're required to register. County has a certification program, and they have an application form. We were able to confirm that these were the Mirabar Beach Villas and the 115 Alamo were indeed short-term vacation rentals that were certified and on the county's registration list.
Okay. And to clarify one other point, this particular parcel, as it exists today, has been vested since 2008 with the 24 stories, 215 dwelling unit entitlement. Is that correct?
That's correct.
And then roughly 2/3 of it has been vested with that same entitlement since 2000.
That's right.
Okay, all right. I believe you covered all the rest of the stuff I had. All right, that's all I have. You can take a seat, and I do believe,
Well, we have,
oh, yeah,
we
you
have
gotta do calls.
cross-examination
That's right.
of him.
That's
He
right.
can't
I've already
sit down
argued with
yet.
Ken. I thought it was,
Let me ask, I'm going to ask Mr. Metcalf a question before we start cross, and Mr. Tatum, if you have a question for him in light of the question I'm going to ask, you can do it then. So on that note about short-term rental units, does the Walton County Code, and I'm going to assume it would be the zoning code, specify which zoning categories short-term rental units are allowed in?
Yes.
Okay.
And in the coastal center zoning district that applies to these properties, it differentiates single-family attached and single-family detached from short-term vacation rental detached and short-term vacation rental attached. Four different distinct permitting categories.
Okay. All right, Mr. Tatum, anything in light of the question I asked your witness?
No, Your Honor.
All right, Ms. Davis, are you ready do you have questions for Mr. Metcalf? Do you remember where we are and what we're doing? We're gonna have to take, how much do you have for him? Let me just ask that.
I really only have one subject, but if it,
No, let's do that. Let's go through your one subject, and then, Mr. Seyfried, I assume your examination will be a little more lengthy. Okay, so we're gonna take another comfort break before that. Okay, thank you. You may proceed.
Mr. Metcalf, I think I have the same concerns as far as this idea of the use. Is your testimony that the use affects the setbacks as far as if a residence is short-term rental versus some other?
Absolutely.
So if a short-term rental, is your testimony that a short-term rental that the owners then decide, I don't care about making money anymore, I want to live here, then that would then change the setbacks next door?
At the time that an application comes forward, because it uses the word, the code uses the word existing. And so that can only be evaluated in terms of the timing of when an application is filed and a development order would be issued. So as we speak today, the existing use is a short-term vacation rental as a category recognized in the Walton County Code.
And as a planner, how do you know that that's a short-term rental? You have a basis for that?
Those particular properties?
Right.
Yes, because I did a public records request and obtained the documentation from the county's registration office. And
But do you have a basis
let me
as a
finish.
planner to establish what that use is?
well, let me finish my first point. And we documented their advertisements for these units as short-term vacation rentals. So
where is that?
It's in my report as an attachment. All the documentation is attached to my report that's been submitted for the record.
Okay.
And so as a planner, to answer your other question, as a planner, I base my determination of what the use is based on what the code says the use is. That's the only way to do it. Doesn't matter what some extraneous document might call a use. It depends on what the code says, and if there's a development order that's been issued on a property, I think that's relevant to the use.
Does the Walton County Land Development Code, does it distinctly say the setbacks are, we'll say 20 feet for a residence that is for somebody to live there versus it's 25 feet for a short-term rental?
The base setbacks don't change by the adjacent use. The footnote 1 is clearly requires the additional setback only for single-family residential use, existing single-family use.
Footnote 1 of?
Table 5-1 in section 5.00.03.
Of the Walton County, because I think we talked about footnotes.
Walton County Code.
Okay, because we talked about footnotes with the maps, and then so I want to make sure that we're clear.
Yes, the footnote 1 to the setback table. Let's just describe it that way.
I don't have any other questions.
Thank you. All right, let's take as quickly as possible a comfort break. Maybe, let's
Kelly, let me ask you a question. Y'all, before y'all, and our time. Look at all this stuff for the county and for us before we go. Their interpretation is different. I don't get to go to, I don't get to go.
I heard you say that. I heard that. You walked in there.
Thank the Lord I don't have to go to this stuff.
No, I know. It's
But what it is, there's gotta be some stuff. Height of hypocrisy.
100%.
Yeah.
Get your surveyor hat back on. Huh? Get your surveyor hat back on. I'm no surveyor.
All right, let's try to get everyone back. Do you need a chair? Okay, we need Ms. Davis. And I think the clerk said she was going to try to find another person to sit in with for her for a few minutes. Yeah, I thought you were too. Oh, okay.
Mind if I help you here a little bit?
Okay, let's go back on the record. Mr. Seifert, you may proceed.
All right, thank you, Your Honor. All right, Mr. Metcalf, let's talk about the Alamo property that we were just speaking about with respect to adjoining and abutting. I'm showing you what's marked as Exhibit 24, which is Section 5.0003, which is the setback requirements that I believe you testified apply in this case, correct?
Correct.
Okay. I think it's your assertion that footnote 1 of the table does not apply, correct?
Doesn't apply to these adjacent properties.
Correct. Okay. In footnote 1, the county uses the word abutting and adjacent in footnote 1, do they not?
They do.
Okay, they state within the South Walton planning area, increase the abutting setback line, correct?
That's right.
And then they go on to say, and single-use multi-residential uses adjacent to existing single-family residential uses, correct?
That's correct.
Mr. Seifert, can you give me the exhibit number again so I
Yes,
can follow?
2024, Your Honor,
Thank you,
and it's on bait stamp page 5.
thank you.
So the county obviously had to mean something different by this word adjacent because it didn't use the same abutting word that it used in the prior sentence, correct?
I understand that legal sort of a statutory construction argument, and I normally apply that as well. I think the difference in this case, though, is they don't have a definition of adjacent. I think they're referring to abutting to be able to refer to the setback line itself, where they have a specific point they can reference. Could they, they could have written it differently, certainly.
Because a setback line will abut the property line, right? They've got to abut.
Well, a setback line doesn't actually abut the property line.
Right, a setback line is set back from a property line that abuts an adjoining property.
Right, the reference to abutting is for a reference point, I think.
Okay, to a common property boundary line.
In this case, just to this, I wouldn't call it a common property boundary. I think it's to the setback with reference to the multifamily development on the subject development parcel.
And it would be consistent to interpret this provision in the sense that the county knew that adjacent uses for single family may not be directly abutting the parcel's boundaries, correct?
An argument.
All right, even taking into account, let's take a look at Exhibit 31 here, which is the property appraiser's map. 31, tab 31 there. Okay, even assuming or taking into account this new argument that you're saying that the property boundary line is 15 feet off and it should line up with Miramar Villas, the Alamo property, I believe you testified earlier, would catty corner Echelon, right?
It would be if this were a straight line.
Okay. And so the corner of the Alamo property would abut the corner of the Echelon property, correct?
The corner point of the lot would abut the corner point of the Echelon.
And the corner point of Miramar Village would abut the county's field, property for their field lot, correct?
Correct.
So all
I'm
four,
going to ask members of the audience to keep your opinions to yourself, please.
so all four of those lots would abut one another at that corner, correct?
Yes.
And abutting is touching, correct?
That's correct.
All right. And abutting is also adjacent in your mind, correct?
Adjacent, based on a common dictionary definition, can include abutting.
It can include abutting and something that might not abut, right?
It could.
But at a minimum, adjacent includes abutting, right?
Yes.
Yep.
Certainly, if it's abutting, it's adjacent.
Yeah, that's exactly what I was trying to say. Thank you, Mr. Metcalf. All right, with respect to the, let's start with the Alamo property, if you will. You had indicated that it's your opinion that this should be classified for purposes of the setback as short-term vacation rental detached, is that correct?
I'm saying it is classified that way.
Well, if the county doesn't agree with that, does it?
Apparently not.
Okay, so it's your opinion here today that it should be classified as short-term vacation rental detached for purposes of calculating the setbacks, correct?
I'm saying it is classified.
Okay.
as such.
Is it a single-family residence? Is the structure on the Alamo property, are those single-family structures?
No,
What are they?
they're short-term vacation rental structures.
Were they built specifically for short-term vacation rentals?
I don't know the answer to that question, but it's a moot issue.
Okay, well, let's take a look at Exhibit 47. That you don't have it yet. Okay, we're Exhibit 47. And let me get the page number here. Turn to the second purple tab. Is there two in there? Go to that one. All right, there you go. All right, it's the purple tab, Your Honor, and yours. It's section 2.03.00 of the Land Development Code titled Categories of Primary Uses. Have you seen this before?
I'm sure I have.
Did
'Cause
you
I've read their whole code.
okay, did you
over
review it
time.
in anticipation of your testimony today?
No, I did not.
Okay. It says defined primary uses, and you had referred to short-term vacation rental units as a primary use, right? That's what you're referring to?
Yeah.
Okay. This land development code defines a short-term vacation rental as any single-family attached residential in nature structure, such as a furnished house, then goes on use for purposes of renting out, etc. You see that definition?
Yes, I do.
Okay, so a short-term vacation rental is a single-family attached residential structure in nature, correct?
Yeah.
Used to rent for some period of time, right?
This refers to the structure as a single-family residential structure. The use is short-term vacation rental. And then, by the way, this is not the definition of short-term vacation rental. The definition's in the glossary.
Yeah, we're gonna get to that, but I think you just testified earlier that the Alamo House is a short-term vacation rental structure, not a single-family residential structure.
I said the use is short-term
Okay.
vacation.
So you
because
agree-
That's what the code refers to. It doesn't, footnote 1 doesn't refer to a structure, it refers to a use.
I understand, and we're gonna get to that. So you agree with me that the two buildings on the Alamo property are single-family residential structures?
Based on this reference, yes.
Okay. And then while we're on that note, with respect to the Miramar properties, Miramar Villas properties, those 16 buildings have 2 units in them, correct?
Yes,
And those meet the definition of single-family residential detached as defined in the Land Development Code, correct?
let me look at that definition.
That'll be 24. It's in your other notebook.
I'm sorry, can you repeat your question, please?
Yes, the units, the 16 unit, or 16 structures in Miramar Villas that contain 2 units each meet the definition of single-family attached dwelling in the Land Development Code, correct?
Yes, the structures do.
All right, so now let's shift gears here and talk a little bit about use. And while we're in Exhibit 24, let's turn to the definition of use. On page 52, base stamp 52.
Okay,
Yeah, I don't have a, did you say we're in 24?
Yes, yes, Your Honor.
I don't have a bait stamp 52.
52.
52?
Wait, I thought the bait stamps was the ones that in red at the bottom.
They are on the left-hand side. Approach.
Mm-hmm. Oh, thank you. I think I needed to take more than a 5-minute break. Okay, thank you.
No worries. And the definition of use is the purpose or activity for which land or any single building thereon is designed, arranged, or intended, or for which it is occupied or maintained, correct?
Well, you interjected the word single, but for buildings.
Where did I say that?
You said, or any single building. It
Oh,
doesn't
any
say
building,
that.
I'm sorry. Okay. All right,
But the definition refers to, also says, for which it is occupied or maintained.
maintained, okay. And how many days is the Alamo property rented, do you know?
At any single point, I'm not sure.
Well, last year, how many days was it rented?
Oh, total number of days? I don't know.
Don't know, okay. Just because somebody has a short-term rental certificate doesn't mean they're renting it for short-term vacation rentals, does it?
Well, the answer is no. It doesn't necessarily mean they are. In this case, we documented that they did,
You documented what, that they had a short-term vacation rental certificate?
and that they were renting online.
Well, okay, how many days online did it say the property was rented?
Just held it out for advertisement, which,
Okay.
by the way, is part of the definition of a public lodging establishment.
So just because somebody might rent their house out for more than 3 times a year, well, let me ask it a little bit differently. Let's go to that definition. And you had it in your PowerPoint. It's in chapter 24 here. You said it was a public lodging establishment? Short-term vacation rental. There it is, on page base stamp 47 of Exhibit 24. Yeah, my Exhibit 24. sorry, Tatum.
Wait, so are we looking at the definition of public lodging establishment
Or
or
actually,
short-term vacation?
Short-term
rental?
vacation rental,
Okay,
which
okay.
is described as a public lodging establishment.
Okay, thank you.
And if you're a short-term vacation rental unit, you have to sign up for a certificate, you gotta pay taxes, you gotta meet different kind of safety standards, correct?
That's correct.
Among other regulations.
Yes.
So if you're renting, which is preempted by state law, right? I think you mentioned that earlier.
Local government's preempted from prohibiting
Correct.
short-term vacation rentals.
Correct. But they could regulate it in the sense of you gotta register, pay taxes,
Correct.
fees, et cetera. Okay. So if you wanna rent your house, you've gotta sign up to be a short-term vacation rental and get a certificate, right?
To do that lawfully, yes.
Right. Okay, so in this definition, it says, public lodge establishment consisting of any unit, group of units, dwelling, building, or group of buildings within a single complex of buildings, which is rented to guests more than 3 times in a calendar year for periods of less than 30 days, or 1 calendar month, whichever is less. So if property owner was to rent out their house 4 times a year for 1 day each, they would be a short-term vacation rental such that they would have to get certified and a certificate, correct?
Yes, or if they're holding out their unit through an advertisement as a public place, as a place regularly rented to guests.
And so in that situation, if a landowner rents their house 4 days a year for 1 day each, they are public, or they are a short-term vacation rental, and they're not worthy of the additional setbacks, in your opinion, correct?
That's correct.
Okay. Now, if they rent their house out for 3 days, or 3 times a year, 1 day each, then they're worthy of the setbacks, the additional setbacks, correct?
No,
Because they're a short-term vacation rental, or they're not a short-term vacation rental.
sorry, I lost you.
Okay.
I lost your thread there, but I'll just say this. I think there's a presumption when a unit is registered and they obtain a certification that their intent is to rent it as a short-term vacation rental. I don't think it's reasonable to expect that one has to monitor every unit out there in order to determine if they're 3 or 4 days a year.
Well, I think it's very reasonable if you're going to be basing setbacks for adjacent uses on the use of a property, because from a planning standpoint, if that property is rented 4 days a year, or at 4 different times, it makes it a short-term vacation rental, and under your opinion, they're not entitled to the additional setbacks, correct?
That's right.
But if that same property is rented 3 times for 3 days a year, it's not a short-term vacation rental, it's a single-family residential unit, and it's entitled to the additional setbacks, correct?
Yeah, if it's a single-family use, it's entitled to the additional setback. Let's make sure we're using the term that the code uses.
That's fine. So for 3 days out of the year, it's not used for single-family residential use. It's entitled to the setbacks, the additional setbacks, because it's not a vacation rental, correct?
If it's not a vacation rental by definition, and if it's by definition an existing single-family residential use, then yes.
Okay. And so in that scenario, from a planning standpoint, additional setbacks are allowed for a property that's used 4 days for rental and not for property that's 3 days, right?
You've made that point a couple times, but you got to draw the line somewhere. They have a definition.
Well, what planning basis is there to draw the line at 3 days versus 4 days versus it's rented out 60 days a year, 300 days a year?
What's the relevance of that question? I'm not getting an objection from the parties, but so that's the line that's drawn. That's what the code says. You're asking him to go behind the rationale of the 3 days for 3 times? I mean,
What is the planning rationale that says a setback for a short-term vacation rental that is used at least 4 days a year minimum? Why should that property not be entitled to the additional setback when a property over here that's only rented 3 days out of the year is entitled to it? I'm asking the planning rationale behind why that makes sense.
Well, if you want to talk about a planning rationale, let's talk about the typical factual scenario, the situation that normally occurs. I've worked in a lot of tourist areas. Short-term vacation rentals, people don't go through all that expense to rent them out 3 or 4 times a year. They rent them out all the time.
And are you aware of people using their properties half of the year and renting it out half of the year?
I'm not sure.
Like the people that own these second homes?
I mean, like a seasonal situation?
Sure.
Yeah, I mean, anyone that owns a short-term vacation rental can stay there themselves as much as they care to stay
Right.
there.
And when they're staying there, they're using it for single-family residential uses, correct?
No,
What are they, are they renting themselves?
no. Once they obtain the classification and their short-term vacation rental use, that's what the use is.
Just because they have a business certificate, but they're not renting it out, you're saying it's still used by the owner of that property for a vacation use and not a residential use?
That's right. And
Okay.
in my practice, that's what I see regularly.
Okay, I'm just trying to focus on the use. So if I own a house, I rent it out 6 months, those vacationers come in, they use it for a vacation use, correct?
Yes?
Okay. I go down and stay for 6 months, I'm using it as a single-family residential use, correct?
No.
How am I using it as a vacation use? I'm not paying rent to myself to rent it out.
Because you've obtained the you've obtained the certification based on the definition, based on the county's program. You made a commitment as a property owner. Once you make that commitment, you can't say, oh, I've gone through the program, but now I'm not going to be considered a short-term vacation rental.
Well, do I have to pay taxes for the time that I stayed in my own house?
No.
Well, if I'm a short-term
You
vacation.
mean a tax as though you were renting it out regularly?
Correct. If I'm a vacation rental unit, you said earlier, it comes with obligations where you gotta pay taxes on the income. And while my vacationers are there, I'm paying taxes on it because they're using it for vacation purposes. When I'm there, I'm not paying any taxes.
Okay,
Correct.
okay. I'm gonna ask you to move along. I mean, and I understand what your argument is, and I've heard his answer to the question numerous times. I think it's been asked and answered. Plus,
All right,
there's a whole category of bed taxes, tourist there's all different kinds of taxes we could be talking about here. So let's move along.
Thank you. Going back to 47, I think Your Honor asked you a few questions earlier about the zoning districts wherein the category of short-term vacation rental unit was.
Book, you're right.
Yeah.
Okay.
And I believe, let's go to coastal use, page 39 of 79, coastal center.
30 what of 79?
39 of 79.
Thank you.
Okay.
All right, and there, it identifies primary uses allowed within the coastal center zoning district, and it, I think in your report, you list the first 4 or either first 5.
First 5.
And then it goes on to list additional primary uses allowed. With respect to all of the zoning districts within the land development code, and I don't want to walk through them one by one, I want to ask a general question. Anywhere that single-family residential use is allowed, short-term vacation rental unit use is also allowed, correct?
I'd have to look at each one.
Are you aware of any, turn 2 pages over to 2.02.21. Under coastal center mixed use, it again allows single-family residential, short-term vacation rental unit, both attached, single-family residential, short-term vacation rental detached. Are you aware of any zoning district where short-term vacation rental unit is allowed and single-family residential is not?
I haven't studied all the other districts to make that determination. It could be. I'm not sure. I was more interested in focusing on at least seeing if there were multiple districts that started with those same 4 categories. And there are many that do.
Okay, yeah. And let's look at page 11 of 79 of that same exhibit. This might summarize it for us. All right, number 2 there on page 11, it says, new construction and converted neighborhood scale short-term vacation rental unit uses are permissible in every zoning district allowing single-family residential detached, single-family residential attached, and multifamily residential land uses, including some others, correct?
Yes.
So wouldn't it be accurate to say that the county in its zoning code treats short-term vacation rental units and single-family residential units synonymously?
No.
All right, let's look at the Miramar Villas. I think you made an argument there about the common area or the common use. And let's turn to 42, exhibit 42, please.
I'm sorry, what page number?
It would be 42, and we're going to just past the purple tab, 2 pages past the purple tab to the Miramar Beach Villas plat.
Okay.
And I believe you talked a little bit earlier in your report, this hatched area is common space, correct?
Correct.
Okay. And what is it common space for?
I believe it's common space for the entire shops of Miramar/Miramar Beach Villas. Descriptive, but common open space for this overall development.
And that overall development is a single-family attached subdivision development, correct?
Well, as I testified to earlier, I find it difficult to classify this property discretely in either category because there are elements of the project that don't conform to multifamily definition, don't conform to single-family parking requirements.
Well, it's got to either be a single-family dwelling or a multifamily dwelling under the definitions of the Land Development Code, correct?
Another way to look at it is it could be deemed to be non-conforming multifamily development.
Think the county issued a DO for non-conforming development?
I think it was conforming at the time.
All right, so the common area would be utilized by the residents of this development, correct?
Presumably,
That would be the use of the common area.
yes.
These residents that live in this subdivision would use the common area. Presumably, somebody outside the subdivision doesn't have the right to use that common area, correct?
Agree.
Do you know what these residents use that common area for?
I haven't gone out there and watched them. Out there, I don't know. I will say, I mean, typically, common open space like this is partly specified the way it is in order to address open space requirements.
And I believe in your report, you identified 2 lot owners within Miramar that I believe you provided certificates of vacation rentals for. Is that correct?
Yes.
Okay. Did you do analysis of all 32 lot owners in this subdivision to determine whether they have vacation certificates?
I did not personally. I know that Mr. Eubank's firm evaluated that.
So you don't, as you stand here today, you don't know if all 32 units in here are vacation rentals or if some of them are single-family units?
I don't know that all of them are. I think the majority are based on what they determined. They didn't look up all of them. The ones that they looked up were short-term vacation rentals.
All right, with respect to the map that you showed earlier on the 2000 DRI, I believe it's going to be exhibit number 3.
Got a different book?
Yes. Right here, this is yours. Not sure what, I have to put this copy.
We're going to 3.
Yeah, yes, Your Honor, number 3. And you had this better marked on your PowerPoint. The little corner part of the Echelon lot there, I believe you said is about a third of the lot, is your estimate. It's like a light purple color.
Right.
Would you agree, purple? We'll call it purple?
That's right.
Somewhere in between. And it has, and you had this blown up earlier, it has an A on it that corresponded to a parcel height of 3 stories, correct? To your
Yes.
legend? So when this property was originally vested, that little corner property was vested for 48 units at 3 stories high, correct?
That's correct.
And then this whole blue area that exists within this whole development, anywhere in there, the 24-story buildings could go, correct?
Anywhere that has a C denoted,
I'm sorry, does the blue not have Cs?
there might be some other designations in there.
Would you agree with me that the vast majority of this blue area is C? Yeah, okay, that's fine. All right, so in those C areas, a 24-story building could be built, but in that little corner, only a 3-story building was authorized, correct?
Correct.
All right, have you reviewed the Sterling Palms site plan?
No.
Are you familiar with the Sterling Palms, which was a prior high-rise development in the vicinity of the Echelon property?
I've heard the reference to it.
All right, I have no further questions at this time, Your Honor. Thank you.
Okay, thank you. Mr. Tatum, redirect. Okay. Ms. Davis, do you have any redirect? Okay, all right. Now you can sit down, Mr. Metcalf. Rest your legs. All right, Mr. Tatum, want to call your next witness?
All right, this time we're going to rest but reserving the ability to recall witnesses and to call additional witnesses in rebuttal.
Rebuttal, okay.
Thank you.
All right, Mr. Metcalf, are you ready to proceed? I'm sorry, Mr. Metcalf. Mr. Seyfried, are you ready to proceed?
One day I will be like Mr. Metcalf, I hope.
If you
Yes, we're
need
ready to proceed.
do you need to clean up anything, or you want to keep them
No.
there? Okay.
Oh, Mr. Toffig? Toffig. T-A-F.
It's all right, I'll get him to do all that when I swear him in.
T-A-W-F-I-G.
Okay. Welcome. Please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And please state and spell your name for the record.
Kamal Tawfiq, K-A-M-A-L-T-A-W-F-I-Q.
Welcome, Mr. Tawfiq.
Thank you.
You may proceed.
All right, Your Honor, just to maybe cut to the chase a little bit, we would introduce Mr. Toffig as an expert an engineer and geotechnical engineering.
Okay, he is being offered as an expert in engineering and geotechnical engineering. Is that what you said?
Well, geotechnical engineering is a subdiscipline in civil engineering.
So civil engineering and geotechnical.
Yeah.
All right. Is there any opposition from? I was going to ask the county first.
I'm trying to, I'm not obviously as smart as he is, so I'm not really sure what geotechnical engineering even describes.
Okay.
We can explain.
Shall I explain it?
If you can concisely, that would be great.
I have no objection to him being qualified.
Okay. I clarified civil engineering and geotechnical. Do you have an opposition to that? Okay. All right. So let me hear geotechnical engineering explained as succinctly as possible, and then I'll make a ruling on that.
Absolutely. Geotechnical engineering is part of civil engineering, and we can consider it as a relatively new subdiscipline in civil engineering, and it deals with everything from the ground and below.
Okay.
So anything that deals with the ground surface and below the ground surface, including water tables and everything, that's geotechnical engineering.
Okay.
So that actually includes loads, excavations, fill materials, the building on the ground, of course, you don't build it in the air, pavements, dams, everything that deals with the ground and below it.
Okay. So, Ms. Davis, having heard that explanation, do you have an objection?
I would at this point I would state civil engineering would encompass that. I don't know that it needs to be further qualified to drill down to specifically this subdiscipline, but either way, I don't have an issue.
Well, I would imagine not every civil engineer might consider himself or herself also an expert in that subspecialty, though. So obviously he does. If you would prefer, Ms. Davis, we can. I don't know how much background you're planning to elicit from him anyway. Why don't we get that?
I was trying
Let's get a little of that.
Yeah, I was trying to
Maybe that'll
cut to the chase on
Yeah.
that a little bit, but we will. Dr. Toffig, can you please explain your background, your education, and your professional employment and your background, please?
Yeah, I graduated in 1978, and I worked in Dubai for 2 years. Then I came to United States and continued my master's at Ohio State University. Then I continued my PhD at University of Maryland. And I worked, as I said, 2 years as professional engineer, as a structural engineer. But then when I came here, I specialized in geotechnical engineering and specifically in foundations. Because foundations, we consider it as substructure. That means from the ground and below. Anything above the ground, we call it superstructure. So that's my PhD actually is in vibrations. So it's very much relative.
He is in what?
Vibrations.
In vibrations.
So it's related actually to the subject matter that I'm here about, and that's construction vibration. And 1988 or 1986, I worked in industry in Maryland as a geotechnical engineer. Then I joined FAMU FSU College of Engineering, 1988. That's when the college established. And I served as a professor since then. And I was associate chair for 5 years and a chairman for 14 years for that department. And I'm back teaching as usual, doing research as a professor.
What are
In
you
the
teaching
meanwhile,
now?
I teach geotechnical engineering.
Okay. All right. I'm going to accept Mr. Tawfiq as an expert in civil engineering and geotechnical engineering. You may proceed.
Thank you, Your Honor. And his CV and his report are within our exhibits, which will be introduced as well, part of the record a little later. Dr. Tawfiq, can you explain to me, well, first of all, have you reviewed the proposed project in this case?
Sure.
Okay. And did you develop some opinions with respect to this proposed project?
Absolutely.
Okay. And can you explain or to the ALJ what your opinions and or concerns are with respect to this proposed project?
Absolutely. Yeah, the proposed project, Echelon, is a huge building. It's a large structure, very heavy structure. And this would require certain types of foundations. In addition to the type of constructions that we do for the foundations and so on. And when I looked at whatever the information that were provided to me, like this one here, for example, I could see that this project is going to be very close to an existing subdivisions. Consists of houses. And the first thing that comes to me as a civil engineer and as a geotechnical engineer, that this structure, huge structure, may affect the integrity of the existing structures. And I started from here. Yeah, I'm sorry. Yeah, that the proposed project, because of its size and extension, so I thought this is going to be, it's going to have a negative impact on the existing structures.
All right, and can you, let's take a look at Exhibit 13 in front of you there. In his report, Your Honor, is Exhibit 13. Okay, and you say this project is going to have a negative impact on adjacent properties. Can you kind of walk through your report there and explain a little more what the specific concerns that you have with this project and how it will have that negative impact on adjacent properties?
Sure. The project is very close to the existing structures, as you can see here in the figure, and I have these figures actually in my report.
That's on page 9 is the figure he's looking at, Your Honor, just for the record.
Thank you.
And on figure 3 on my report, it shows actually the possibilities of the foundations for this type of structures. And I explained in general, it could be deep foundations, it could be shallow foundations, or it could be the combination of shallow foundation and deep foundation. These are all the possibilities that it can, actually we could use one of these choices to be the foundation for this structure. And when I started the analysis, I assumed that this is going to be a deep foundation and is going to be driven piles. That's usually the option that we have for deep foundation. Another options that I mentioned in my report would be auger cast piles. The third option would be drill shafts. So these are considered as deep foundations. Now, the shallow foundation, as you could see here in figure 3 in my report, it shows that we have very large, thick mat foundation, and where all the building is resting on that huge foundation. The last one is raft foundation, which is the combination of piles and mat foundation. Each of them has a negative effect, maybe different negative effect on the buildings. For example, if we're gonna go with deep foundations will induce vibrations. And they range from severe vibration that comes from impact loads applied on driven piles. It goes all the way to less negative impact from drill shafts. Shallow foundation, if it's the choice of shallow foundation, then we always fear the settlement of the building that may affect the settlement of the existing buildings. The same thing with the raft foundation. It has actually the effect of vibration coming from construction, and settlement will be less in type 3, on figure 3. Then we have the method of construction. Sometimes when you have a shallow water table like we have in our site, Echelon, it may require what we call it dewatering the site, to go and lower the water table in order to allow the construction of foundations. And that lowering the water table, it's going to cause what we call it drawdown in the surface water that is going to extend to, and that's a possibility, to underneath the existing houses. And then actually this may cause additional settlement for the existing houses. So that's also another negative impact. We have vibration, we have settlement, we have dewatering that's going to cause settlement, and then last thing is the noise.
And can I interrupt for a second?
Yeah.
So, you're obviously way more familiar with all this than I am, so sometimes I have to interrupt and ask questions. If they go with the deep foundation option, you're concerned about the vibrations. If they use shallow foundation, you're concerned about affecting settlement of the adjoining structures. Which one is associated with dewatering, or was
Dewatering, it would be with the number 2, that is the
with
shallow
the shallow?
foundation.
Okay, thank you.
And sometimes also with number 3, where we have pile foundation and we have caps on top of them. And that's what it came in the geotechnical report that I received on October 23rd.
And do you know what type of construction is going to be used for this project?
Honestly, nothing has been provided whether this structure is going to be concrete structure or steel structure. Nothing has been provided what kind of foundation. There were some suggestions that because of the driven piles, we're going to go, it's going to produce a lot of vibration, we're going to go with auger cast piles. And this is something that I need to correct in the record because what I have received, I don't know who said that, but mistakenly, they mentioned that they're going to use auger-driven piles. That's wrong.
Are you saying auger driven?
Auger cast pile.
Auger
So
cast
in the
piles,
report that
okay.
whoever wrote this,
Thank you.
I don't know who wrote this one.
Yeah.
So this actually, it says mistakenly that they're going to do auger-driven piles. There is nothing called auger-driven piles. It's called overcast pile.
So they're proposing some kind of technology to drive auger piles that you've never heard of? Is that your understanding?
No, it's just probably a typo. So I'm going to tolerate this.
And are you familiar with any conditions within the development order that would alleviate any of the concerns that you've raised here today and in your report?
Sure. So since they already decided, I'm not sure if they already decided, I haven't seen any plans. It's just a suggestion that they're going to use auger cast pile. Auger cast piles will produce less vibration than driven piles. All right, but that's not the lowest vibration. So the vibration that actually produced by auger cast in terms of the magnitude, we call it part per what they call peak particle velocity, PPV. So it goes all the way to 0.1 inch per second, and sometimes it goes to 0.15 inch per second, which is low. But if we look at some of the codes, and I'm going to actually.
And while he's looking for that, Mr. Seyfried, what document is it that he's looking at that led him to believe that the proposal will use auger cast piles? Is that in the staff report, or what is that from?
It is in, no. Yeah, that one.
Sure.
I believe it is the applicant's exhibit. Geotechnical thing.
Oh, the geotechnical, I don't have it.
Applicant's exhibit 15.
Okay,
Is
thank
the one
you.
he was referring to as. auger-driven pile.
Okay, thank you.
And what did,
While we're at a short break, I'm going to object to this line of questioning.
Okay.
It's not relevant to what we're here for today. The type of design for the slab, how the auger or how the piles arrive in the ground, what kind of slab we've got. General construction is not what we're here to consider today. This is a application. So I understand that there are concerns, and those concerns will be handled at the permitting stage for building permit purposes, as you're familiar with. Also, I'm definitely going to object to any testimony about noise, as he was about to start on a little while ago. That is well outside his realm of expertise.
It's vibrations. That's my PhD.
You said noise.
Noise is
Okay,
vibration.
hold on. I mean, vibrations in the air are noise,
Yeah.
but if he's geotechnical,
There we
then
go.
I don't know. Okay, so first, Mr. Seyfried, would you respond to the issue on the objection on relevance? And tell me how it's relevant to a determination of whether the proposal meets the land use requirements of the code and the comp plan.
Would you like me to help you?
Sure, Mr.
No, I want to hear. I want to hear
Okay,
from the
sure.
attorney. This is his job. Okay, thank you.
It goes to compatibility, Your Honor, and it goes to impacts to the adjacent properties, which are very, very close to where these piles are going to be driven. These houses were built in the 80s, some of them perhaps even earlier. So just any kind of vibrations or impacts will damage their houses, and so it goes to compatibility.
But aren't the determinations as to what building techniques, including horizontal construction, as I call it, pre-development, aren't all of those determinations to be made pursuant to the building codes, and thus are issues that will be determined at that stage of the construction process, not in this land use determination?
Well, I think they can obviously be addressed in that arena too, Your Honor. But here, before we get to the point, the question is, can they be addressed, or should they even be addressed when we get to that point? As you saw from Exhibit 17, the massing of this building is it's huge, and it's 50 feet away, 40 feet away from these houses. And so it goes to the point of
Right, and mass and scale are appropriate in a discussion of whether
Right.
land use is compatible, but not necessarily
well,
what type of foundation, how it'll be drilled in the ground, and what the
Well-
environmental impacts might be.
well, I think it does. Can this thing be built here in this location safely, such that it is compatible with the adjacent uses? I mean, if they can't construct it safely in a way that doesn't destroy and impact the adjacent properties, it's not compatible. I mean, then all my clients are going to be in lawsuits over construction damage from the drilling of pilings or whatever. But I think that's all part of the overall, is this huge building appropriate jammed into this little area 30 feet from my client's property? So yes, if they do get approval and you believe it to be compatible, which I don't believe it is, maybe they can set up some conditions to say, if you're going to do this drilling, then you got to monitor this and you got to monitor that. But we're saying right now with Dr. Toffee, this building can't be built here without having negative impacts, and thus it's not compatible in this area with adjacent uses.
Mr. Tatum.
I would argue that it's exactly the opposite of what he's saying. The building permit process.
I can figure it out from there.
The building permit process is entirely set up for this exact reason. We have a development order process. We have a building permit process. If the building permit or the building official wants to place conditions on his building permit that monitoring occur, so be it. I'm not even saying we wouldn't, because in all honesty, we would monitor. We don't want to cause adverse impacts to neighboring properties. However, that's not what we're here to discuss today.
Okay. Ms. Davis, do you have anything to add?
Your Honor, just that as far as compatibility, I mean, that's looking at the definition of compatibility is something over time, not a point in time of just construction. So So I don't know that I would agree with Mr. Seifert's characterization of this goes to compatibility necessarily.
All right. So, Mr. Seifert, I tend to agree with the applicant and the county here. If you have testimony from a planner regarding how the scale and mass of this building in proximity to adjoining or adjacent or abutting, whatever, uses, the impacts on them, it's would be relevant. And I say that with a question mark because I'm also mindful that it seems like with the DRI development order, they may be, exempt from compatibility analysis to the extent that that would interfere with the entitlements from the DRI development order that's in place. So I'm going to sustain the objection. Do you have anything else from this witness that would be relevant in light of that ruling?
I don't think so, Your Honor, but we would, again, proffer his testimony and his report
Okay.
and everything
Okay.
so that it's in the record,
Okay.
understanding, again, it's a QJ hearing, everything comes in, I think, from under state law, and then you get to weigh the credibility of it. If you think it's irrelevant, fine.
Okay.
But it doesn't necessarily get excluded, but I understand your ruling.
So do you, in terms of a proffer, do you want to summarize the rest of the testimony, what you would have expected to glean from him, just so we can move it along?
Well, I would like for Mr. Toffig to explain that, because I'm not sure I have the technical expertise to explain what the rest of his objections were to the project.
Mr. Tatum?
And of course, I'm going to object to that. In fact,
Shocker.
his report's going to be in the record. I don't disagree with Mr. Seifert that it all comes in a QJ. I don't disagree with that. What your responsibility is to apply the correct amount of weight to that evidence that's in and determine whether or not it's competent, substantial evidence relevant to what you're here to make the determination
Okay.
on. So his report's in. I think that's the end of that discussion. Personally.
Okay. And I don't mean to be disrespectful to the engineer and Mr. Topic, but I believe you actually have an expert planner that you're planning to offer. And given, it's 3:30, I think it might be a better use of our time to try to get to that witness. And you may have others. I don't know how many witnesses you have. So if you would like for Mr. Topic to summarize what the other opinions that he has, if you can do it quickly, and let's get through it as in the form of a proffer.
All right. Well, we have been talking since morning about the setback. The conclusion, actually, for my study is that there is a need for setback so that there will be no negative impact on the. It's not because of the ordinance that you have to have it based on the height. It's actually based on technical things that's going to happen during construction and lawsuits that may come later on from damages to the existing structures.
Okay. Thank you so much.
Thank you, Dr. Toffig. Sure. All right, we'll next call Louis Cerna.
No, I think that's good.
All right, Your Honor, I know you're very familiar. Mr. Cerna has appeared before you numerous times over here in Walton County, and I think everybody else is familiar with him. So we would be offering him as an expert in
All right.
planning.
Let me swear him in.
Oh,
That's
sorry.
okay. All right, raise your right hand, please. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, and please state and spell your name for the record.
It's Luis Cerna, Luisserna.
Thank you. Okay, you're tendering him as an expert in?
Yeah, in planning and the Walton County Land Development Code and Walton County Comp Plan consistency.
All right, any objection from the county?
No objection from the county, Your Honor.
Okay, any objection from the applicant?
Applicant objects, but only because he keeps showing up in opposition to just my projects.
All right. So accepted, Mr. Cerna, in the field of planning as well as the Walton County Plan and Land Development Code.
All right, just to save time, I won't have you go through your background. I think the ALJ is familiar with your background. And your CV is going to be in the exhibits as well as your expert planning report. So with that, Mr. Cerna, can you explain what you were asked to do in this case and what you did, please?
Yes, I was asked to review the major development application that was submitted on this project and review it for compliance with the Walton County Comprehensive Plan and Land Development Code.
And did you review any materials in your effort?
Yes, I reviewed the applicant's submittal, the county staff reports and other analyses that were done, the DRI records, and yeah, that there was a lot.
Okay, yeah, and so if you can, just in a summary fashion, kind of explain what your opinions are with respect to if this project is consistent with the LDC and the comp plan.
Yes, I cite.
And if you could direct me to his report, which exhibit it is.
Absolutely, Your Honor. It is.
Oh, I see, 22.
22.
I was trying to find it in your list there.
22.
Okay, thank you. You may proceed.
All right, yeah, so I cite in my analysis some concerns about inconsistency with the code and the comp plan, as well as Florida statutes. The first is the question of setbacks, which we've discussed, section 5.00.3.1. I won't read that, but because we've gone through it, but in my opinion, those setbacks have been incorrectly applied. Those are, in my opinion, single-family residences adjacent to it, as defined by the code and as.
Let me stop you there. When you say those, can you specifically identify the single-family residences in your opinion?
Yes, per the definition of in the Land Development Code, Miramar Beach villas that contain 2 units attached are single-family, as well as what's referred to as the Alamo property, which is a single-family residence.
All right, and do you have an opinion? I know you heard Mr. Metcalf earlier talk about the use of the property next door controlling under section 5.0003, and he's mentioning short-term vacation rentals as, quote, the use as governing the requirement for setbacks or no setbacks. Do you have an opinion with respect to how those setbacks should be applied?
Yes, from a planning perspective, there's no logic to calling those single family or calling them anything else other than single family residences. You would not apply, in a common sense fashion, a planner would not look at who owns the property adjacent to the house. And, of course, we've already established that the Alamo property is adjacent, even if it's just on a corner. And despite it being used for vacation rentals, that is a use that's, I think, the Walton County Code customarily allows in single-family neighborhoods. I noted during the discussion that the Land Development Code also lists artisanal uses in the coastal center in the coastal center zoning district, which is as a permitted use, and that is defined in the code as the making of crafts, such as by hand, such as stone, wood, ceramic, and food products. So I don't think the intent is that if you're doing that in your single-family residence, that you're no longer a single-family residence. I don't think it's the intent that if you're a vacation rental, that you're no longer a single-family residence.
So your opinion that it doesn't make sense from a planning perspective, I understand, but I've accepted you as an expert in the Land Development Code of Walton County, and I've certainly seen through witness testimony thus far that, that short-term vacation rental use is pretty narrowly defined and heavily regulated by the Land Development Code. So I'd like to hear what your opinion is under the land development code itself, not generally from a planning perspective. I believe you just gave me a little taste of that. Can you expand on that a little bit for me? I'm just not quite following you.
Yeah, in the land development code, short-term vacation rentals is listed as an allowed use in a residential district. You can do it in a single-family house, attached or detached. And when you refer to the zoning setbacks, it talks about single-family residential uses, which are defined as the use. So I think you have to take a literal reading of that the structure itself is single-family residential. If it's being used for vacation rentals is not relevant. If it's being used for, as I indicate, artisanal sort of uses in that residence, it's still a single-family residence, and the setbacks apply. Because what we're looking at is the impacts to the property, the impacts and the compatibility. And just because it's rented occasionally, which does not mean that there would be different impacts associated with that use.
Let me ask you this, Mr. Cerna. Do the people that rent the property, say the Alamo property, do they use that property in the same manner and form that an owner residing there that would use it?
Yes, it's a single-family home, so they use it in that manner.
They don't use it for commercial purposes or anything?
No.
They use it to sleep at night and to traverse back and forth to the beach?
Correct.
All right. What about so the use of a single family dwelling unit that is rented to people is the same use that a single family that would either lease it long term or own it? They would use it for the same purposes?
Correct.
The only difference, one paying rent to stay there for a short term versus somebody paying a mortgage to stay there long term?
Correct, yes.
All right, what are your other opinions?
Yeah, and to that, just following up on that, I think, based on the fact that in the August 29th county report, that was never cited as setbacks. It was just something that I think was incorrectly applied. It was just never brought up as an issue until later. So my other findings...
What's important about that? Why does it matter when it was brought up in this process, in the reviewing process?
Because I think it was sort of, I think it was after the fact in order to justify the setbacks that were applied.
Your Honor, can I address that?
Well, I mean, it forms the basis of his opinion, so I want to know why he thought it was important. I think I know why you think it's important. Okay, go ahead.
Oh, yeah, okay. So my other findings are based on review of this for compatibility with Florida statutes, section 163, 3164, paragraph 9, the definition of compatibility means a condition in which land uses can coexist in relative proximity to each other in a stable fashion over time, such that no use or condition is unduly negatively impacted directly or indirectly by another use or condition. So, the first thing that struck me in reviewing this is just the scale of this property, 314 feet, 124 stories. 24 stories, I'm sorry. I knew that didn't sound right as soon as I said it. Yeah. Okay. And just looking at the site plan and the renderings of this, in my opinion, this would definitely have adverse impacts to the adjoining properties, which are, most of them are two stories or less, or 2 stories, regarding adverse light, open space, noise, privacy concerns. Looking at the plans, it does include an outdoor pool and terrace that are on the 5th floor, directly overlooking the parcels to the south. And the setbacks for this portion of the tower are located approximately 22 feet from the south property line, which is being considered the side setback boundary of the DRI. So yeah, I think there is a concern about compatibility. And I think for that reason, that's why the code itself establishes those additional setbacks based on the height of a structure. My next finding is consistency with the Walton County's comprehensive plan. Objective L 1.15, compatibility of adjacent land uses. Policy L 1.15.4 under this objective states, compatibility shall be established between uses and within and adjacent to the mixed-use future land use category. It is the intent of mixed use. The intent of mixed use is to promote an integration of land uses, not require separation. Mixed-use projects shall submit a detailed plan to demonstrate effective, contextual-sensitive alternatives to buffering and/or separation of uses such as street alignment, building orientation, screening, pedestrian continuity, building articulation, building bulk, facade, design, lighting, signage, merchandising, landscaping, parking, and access design, building heights at the edge of the project, and controlled window views and location. So in my review of the Echelon site plan and in reviewing the staff report, I did not see any such consideration of these factors for compatibility. And again, I'm not stating that the development could not be built or you could not get the height or the density, but there needs to be a consideration of the orientation, bulk, and the height. And again, the height issue is something that has not been addressed, in my opinion. That's basically the summary of my analysis. So, again, my recommendation on this would be to deny the project or require that you increase the setbacks or lower the height or a combination of both.
All right, Mr. Cerny, you talked about a little bit earlier of impacts by having, I guess, this large structure directly adjacent to some single-family residences. Turn to Exhibit 17, if you will, here. Just to give a visual of, what that is going to look like.
You said 17?
17.
Oh, sorry.
And have you reviewed these renderings that are in Exhibit 17?
Yes, I did. That was part of my analysis.
And is it typical for planners to, prepare such renderings to analyze compatibility, building mass, et cetera?
Yeah, I mean, it's typically part of the review to get a 3D visualization of the height and the bulk of the building and impacts to adjacent properties.
And applicant did not, or the county did not require any in this case, did they?
No.
All right, if you turn, let's see, 1, 2, 3, 4, 5, 6, maybe the 7th page is R7 at the bottom right.
Okay.
The next to the last photograph so we're looking, which direction are we looking at this building from?
That would be looking from the west, looking east.
And then to the right of the building structure would be sea cabins, villas at Miramar?
Correct.
Okay. And I think you said on the 5th floor earlier is where this, at the top of this parking deck or 5th floor is a pool. Is that what you said?
Correct. There's a pool and an open terrace.
And so this open terrace and pool area right there on top of the 5th floor, those people would be looking directly over, or would they be looking directly over the edge down into the backyards of the people that own village or the common area, or even the people that own these other units?
Correct. Yeah, the rendering shows the impacts of that very well.
All right. And with respect to the villages at Miramar, you heard well, first of all, let me get your opinion. Let's see, I think it's in, I think we can go to 27 will be the quickest way to get there. All right, go to about the 5th page. One that says has Echelon lot and the outlines of the 16 units in Miramar Villas.
Yes.
I'm sorry, what number?
It's Exhibit 27.
Thank you.
The last page in 27, Your Honor. Is it your opinion that those dwelling units within the villas of Miramar are single-family dwelling units?
Yes, as defined by the Walton County Code.
Is it your opinion that that subdivision is a single-family unit, or single-family dwelling unit subdivision?
Yes,
And the common area located within that subdivision is utilized by the owners of the single-family dwelling units for single-family purposes?
yes.
I'm not hearing an objection, but it really helps me to hear a lot more narrative testimony from the expert witness than yes and no answers to leading questions.
Mr. Cerner, can you give us your opinion with respect to the type of subdivision that Villas at Miramar Beach is, in your planning opinion?
Yeah, those are single-family units within a single-family subdivision.
And and how would you heard testimony earlier that the adjacent use to the Echelon lot is common area. Do you agree with that opinion?
The use, technically, the adjacent use is common area. I don't think that's the intent of the section 5.00.03 regarding the setbacks. From a planning perspective, those are single-family residences. It doesn't matter where the lot lines lay. It's because you're looking at the impacts from the adjacent high-rise development. So in that case, you have to consider what the use of the building is.
Would the entire common area of the subdivision be an adjacent use?
It would be, yes.
Is adjacent and abutting, do they have two different definitions in your mind as a planner?
Yes.
So explain what those are, please.
Yeah, abutting is directly touching. Adjacent can include abutting, but not necessarily. It can include nearby. So, in my opinion, those single-family homes are adjacent.
And the use of the single-family homes and common area, are they adjacent to the Echelon property?
Yes.
All right. Any other opinions that you have, Mr. Cerner,
No.
that we did not cover?
No.
All right. That's all I have for now, Your Honor. Thank you.
All right, Ms. Davis?
I don't have anything at this time, Your Honor.
Thank you. Mr. Tatum?
Hello, Mr. Cerna, how you doing?
Hey, good. A little tired.
Good to see you again. Just have a few questions for you here. I have a few already planned out, a few I want to ask based on your current testimony, or most recent testimony. I've seen you at a couple of these magistrate hearings before. Was wondering, have you ever appeared before the magistrate in support of a project?
No, not before the magistrate.
Have you appeared before the Walton County Board of County Commissioners in support of a project?
I have appeared in support of neighborhood plans that I developed on behalf of neighborhoods.
They're not individual developments.
Correct.
Okay, all right. So you prepared your analysis for the Echelon project, and in doing that, did you review the civil and architectural and landscaping plans that were provided in the package?
Yes.
And your report is based on those plans?
Yes,
In
my
part.
report, yes, is based on those plans, correct.
So you're aware that the design for this building includes what's called step-down massing adjacent to the residential uses that are outside the DRI to the south?
Correct, correct,
Okay,
yes.
all right. And you're also aware that the project includes landscape buffering along the southern boundary line in excess of what's required by the code?
Yes.
All right. So did you consider those factors in your compatibility analysis?
I did. And again, the setbacks, the landscaping doesn't even approach anything that would be enough to buffer the building, just based on its height and its setbacks. So I consider the setbacks to be, of primary concern.
And just for certainty, you are not a landscape architect, correct?
No, I'm not a landscape architect.
So you make the statement that the project does not comply with comp plan policy L-1.15.4, correct?
Correct.
And you say that because, well, tell me why you say that.
Yeah, because I don't think an analysis was ever done to determine or make this building more compatible with the adjacent uses. Building orientation is a big is a factor under that policy. The building directly faces the beach, which is adjacent to these single-family homes. There could be efforts made to orient the building in a different manner so there would not be the impacts to the adjacent properties. So yeah, I think there's all sorts of things that can be done in regard to building orientation, building bulk as well. That would include the parking garage, and then building heights at the edge of the project. Again, the garage, which is the part of the main building, they're one and the same, is 5 stories, 22 feet from the property line. So, in my opinion, that did not meet the policy.
And does policy L-1.15.4A include building heights at the edge of the project as one of the potential things that can be changed? I believe you just testified to that, to show compatibility?
Yes.
And you just testified that you're aware that our project incorporates step-down heights at that southern boundary line. So isn't that in compliance with L-1.15.4?
No, I mean, I think I stated earlier about the fifth floor terrace located directly next to the single family properties to the south, and just the impacts to those properties from lack of privacy and noise impacts, et cetera.
Isn't screening also one of the potential avenues that can be pursued by the developer in ensuring compatibility?
Yes, screening can, but again, when you can only screen so much when you're not complying with the setbacks, in my opinion.
Let me ask you this question. What's the maximum building height ordinarily in South Walton County?
In South Walton County, without the DRI, it's limited to 50 feet.
Okay, and are you aware of how tall the parking garage is next door, or that will be next door if it's built?
Yes, I've seen it on the plans. But yeah, it's 5 stories.
Does 60 feet sound?
Yes,
right?
that
Okay.
sounds about right.
So the developments to our south could build up to 50 feet in height, and our parking garage is 60 feet in height, and yet you still find it's not compatible because the development to our south chose to limit its height to a lesser 2 stories.
Yes, I mean, I think it does not meet the additional setback requirements, and yeah, just the bare face of the wall adjacent, that close to the property line, yeah, that does not meet the definition of compatible.
But playing the hypothetical that we've heard today, in a way, about short-term rentals changing, well, what happens if, say, Miramar Villas gets torn down and they come in and build 50-foot tall residences right next door? Is it then not compatible?
Again, I would have to do a thorough review of that, but the 50-foot height is permitted under the current zoning and land use. So, if that's being proposed as an option, I think that would be something that the county could consider.
Okay. Are you, I'm sure you are, but are you familiar with Florida's Development's regional impact?
Yes.
And have you represented or worked on a project within a DRI before?
I've never I've never represented a client for a new DRI or a substantial change to a DRI, just developments within DRIs. And I've reviewed plans on behalf of a local government for that were within a DRI.
So you would agree that unless the DRI development order provides for specific development standards, then the project must comply with the current development standards in place, as long as those current development standards do not preclude the construction of the entitled development?
Correct, yes.
Okay. Does L-1.15.4 address the need for a finding of compatibility with adjacent development when the project is located within a DRI and is vested for the use?
No, it does not. But I mean, if the intent was that within a DRI you're not subject to the compatibility requirements, in my opinion, that it wouldn't even require a major development review.
Okay, we'll move on from that. Mr. Seyfried included an Exhibit 41 that he brought in today. That is I can't even tell, Merriam-Webster's 9th New Collegiate Dictionary definition for adjacent. Hard to read, but I'm going to ask you to read the definition all the way through the highlighted, including what's in the parentheticals.
Slowly, please.
All right. Yeah. Okay, not distance, nearby, having a common endpoint or border, immediately preceding or following two angles, having the vertex and one side in common.
Okay, and you left out, in parentheticals, may be hard to see, but after the B definition.
Oh yeah, I'm sorry.
What does it say there? Having
a common endpoint or border, adjacent lots, I guess, adjacent sides of a triangle.
That's enough. So the definition supplied by the opposition for adjacent has a definition included in it that discusses shared lot lines.
Yes.
Okay.
Common border, yeah.
Okay, that's all I've got for you.
Okay. All right, Mr. Seyfried.
Thank you. A few follow-ups. Mr. Cerna, the example council just gave you about a 50-foot building on properties adjacent to ours, not on the Echelon property. Would that 50-foot building have to comply with the additional setbacks in 5.00.03 for height above 36 feet?
Yes, it would.
And that's what you're applying in this case to the Echelon property over 36 feet, correct?
Correct, yes.
All right, and speaking of setbacks, what is your opinion, and I know it's in your report, but what is your opinion with respect to the proper setback on the eastern property line boundary? From,
Oh, yeah, because that is, the Alamo parcel is single-family, that the additional setback would apply, so, and that would be a 159-foot setback.
and what was your opinion with respect to what the proper setback is from the southern boundary line?
Again, the additional setback would apply, which would make it a 154-foot setback.
And when you measure that setback, you measure it from the do you measure it from the property line to the first part of the structure that you encounter?
Yes.
So the fact that the tower is sitting on top of the garage set back, does that have any impact on where you measure the setback to?
No, that's not how the code directs.
Explain how you would measure that setback.
You would measure it to the nearest vertical wall of that building.
And what about on the eastern boundary? Would you measure it as a diagonal, as you heard the county testified to earlier today?
You would measure it, yeah, from the nearest vertical wall to the closest point of that property, which it would include, it would include all points closest to the property, which would be a diagonal in some cases.
All right, and with respect to, I think you were asked a few other questions about the 60 feet of the parking garage. And you testified earlier about a pool deck. Is the pool deck on top of that 60-foot parking garage?
Yes.
So it's way more than just a parking garage 25 feet from the adjacent properties?
Correct, yes.
And does that additional use with respect to a pool deck and lounging deck factor into your compatibility analysis of the impacts that the neighbor is going to have, as opposed to it just being a parking deck?
Yes, it would. It's an outdoor activity center, which would be a gathering point and, would have noise impacts.
All right, I don't have any further questions. Thank you, Mr. Cerna.
Thank you. No, sir. We are done. I guess I should say, unless you had a legitimate argument that his redirect went beyond the scope of cross,
He did raise discussions about setbacks.
Thank you.
He did raise additional discussions about setbacks being at diagonals, and do you measure to the garage or do you measure to the tower, and how that is, and that's what I would wish to address.
All right, I'll allow it. Sorry. All right, what's happening? We're just playing back the recording by accident? Okay, thank you.
All right. So, Mr. Cerna, I'm really just wanting some clarity on your opinion on something. Mr. Seyfried asked you a question that sounded like he was saying that you wouldn't measure for the height of the tower to the tower. You would measure for the height of the tower, a setback based on the height of the tower, but to the garage. Is that what was that your opinion?
To the nearest point of the building, which in this case is the garage.
So is it your opinion that if the tower was separated from the garage by 6 inches and was a different structure on a different slab, then you would measure 2 different measurements for setback?
If they were separate structures, you would have different setbacks, correct?
Interesting, okay. You testified that it had been your experience that you measure in a diagonal from the closest point of the structure in question to the property line. Is that correct?
Yes,
I heard you say.
and hopefully I'm being clear on that, but it's the closest point of the building to the closest point of the property line. So you don't measure setbacks completely parallel. You have to include where there's corners. You have to measure from that corner point.
So the closest point of our development to our eastern property line is adjacent to the regional utilities facility, correct?
I'm sorry, could you repeat that?
The closest point from our structure to our eastern property line is where it's adjacent to the regional utilities, we'll call it Sprayfield area, to our east. Is that correct? That's the closest point?
Correct. But you have to meet the setbacks for single-family structures as well.
Even though in that area we're not adjacent to a single-family structure?
You have to meet the setbacks from the lot line of the single-family structure.
Okay. I think I'm going to need you to explain that again.
Okay. Yeah, well, I mean, actually, literally reading the code, it says the setbacks are this based on what's adjacent to it. So if you wanted to take the position that the setback does not apply to the spray field, I mean, you could, but, you know, literally reading the code, the setback is your rear setback, in this case, the east side, should be the adjacent, should be the larger number, because you have an adjacent use that's single-family residential.
All right, so I don't want to beat a dead horse, but I'm trying, but my brain's not wrapping around what you're saying. What I'm hearing you tell me is that this project would need to meet a 154-foot setback adjacent to the regional utility spray field, because down in the southeast corner, we may or may not be adjacent to what may or may not be a single-family home?
Yes, I mean, that is what is established as the rear setback. So yes, correct, unless you wanted to apply two different setbacks, which I don't see that that's permitted.
And then your other setback argument on the side, on the south side, would be 154 feet from the property line?
Let's see. Yes.
Okay, so we would have to set back 154 feet from the southern property line, 159 feet from the eastern property line.
Yeah.
Does that not make it impossible to carry out the entitlements?
No, I don't. I can't state that definitively. And that's not.
That's right.
That's not my call.
Your expertise. I agree. That was a bad question. My apologies. That's all I've got. Thank you.
Thank you.
Your Honor, Jared Young, also on behalf of the opposition.
Okay. Could you state your name for me? I don't think you made an appearance earlier, did you?
Can't mention my name, Jared. Can't say your name, Jared Young.
Okay. Okay.
Did you spell my name?
Did you get their spellings? You did? Okay. You did? You did not. Let's make sure the county gets it. All right. So on behalf of the opposition, you are?
Jared Young. That's JARED YOUNG.
Thank you. All right. You have another witness to call?
Yes, Your Honor. We're calling John Owens.
All right, Mr. Owens. If you would, please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. If you would state and spell your name for the record, even though it might be an easy one.
John Owens, JOHNOWENS.
Thank you. You may proceed, Mr. Young.
Thank you. Mr. Owens, can you state your address for the record?
My homestead address is Tallahassee, Florida, 3086 O'Brien Drive.
And your address here?
Yes, 1096 Scenic Gulf Drive, Unit 1511, which is Surfside Resort.
And are you here representing anyone besides yourself today?
I have been authorized by the Surfside Board to represent the board.
Your Honor, I would like to point to Exhibit 1 of our book, which is his authorization letter from the board.
Okay.
Mr. Owens.
Your Honor, I'm sorry. I just want to. This has not been discussed, so I need to go ahead and say this on the record now. While I do not object to the individual property owners being parties to these proceedings, I do reserve an objection to the HOA or the COA being a party for a myriad of reasons. I'm not going, it makes no difference for today's purposes, but I just want to reserve it on the record.
Okay, so we have two adjacent property owners that are being represented by your firm, and as parties, which we've just been calling the opposition collectively. So you are also, Mr. Young, you're representing to me that you are you are representing the Surfside Board of Directors as a party in opposition.
Yes,
That's
so
what you're
the
doing. Okay.
Mr. Owens, in his personal capacity as an owner in Surfside, which is a nearby development, it's 100, we'll get into it, but it's 110 feet or so. And then the Surfside Owners Association, as well as Robert Paternoga and Lynn Kajanik, who are the two other properties, Miramar and Alamo, that we've been discussing.
So there's an objection from the applicants to grant party status. So let me hear from the county.
I think that the property that he owns is sufficiently adjacent to demonstrate party status. So I don't think the county has an objection on that regard.
Okay. All right. Mr. Tatum, it's rare that you're not, your client in this case is not aligned with the county, but so what is your reading of the law on the issue?
That was not my intent by hopping up here and saying what I said for you to take this up. I just wanted it on the record that I was reserving my objection to their party status for the condominium association itself. May or may not ever have to come up again, but I just wanted it in the record in case I needed to bring it up on some potential future litigation. So, making an argument as to whether or not this is
Don't
something
want a
that,
determination from me as to
No,
whether they
because
can
it's,
obtain party status?
I mean, if you would like to make a determination, absolutely fine. I don't have an argument today besides other than this is a derivative action. They would need to be represented by a separate attorney from, I'm sorry, I forgot your name, but from this particular individual, but that would be my only objection at the moment.
Okay.
Or only grounds for my
I
objection.
mean, if you're not seeking a ruling from me on it, you're just trying to lay the foundation for maybe an appeal should you decide to take one, then I don't need, I mean, it's 4:15.
That's really all I was doing.
Okay. Mr. Safert, did you want to say something?
Yeah, thank you. I just want to note that when all of this began, the county attorney, Mr. Atkinson, granted us party status, Surfside HOA, and the Owens individually, before it even got transmitted over here. So he recognized that in the BCC meeting. Just
Okay.
so the record's clear.
All right. If somebody could assure, Ms. Davis, can you ensure that that action, whatever form it's memorialized in, gets into the record for this, probably if it's just minutes of that meeting in which it occurred? Okay, thank you. All right, Mr. Young, you may proceed.
Thank you, Your Honor. Mr. Owens, what's your occupation?
I am a healthcare consultant that mainly focuses on hospital reimbursement in the state of Florida.
And during your preparation for this hearing, did you gather and review documents?
Yes, we've gone into the county's intergovernmental portal, pulled out a tremendous amount of documents, the county staff reports. We've gone into the DCA archives in Tallahassee electronically and pulled down a tranche of documents from there, as well as several public records requests made to the county of Walton Planning Department.
And from this list of documents, and we'll get more into it as we go, that you pulled through, what were the big things that emerged as significant from what you reviewed?
I mean, one of our largest things was the fact that we never even knew or were noticed on 2022 when that amendment went through. That final order DRI amendment was going on. We also found out what was in there regarding 32 options for 32 homes, the options to continue with the, at the same time, either option to do the 24-story tower, 250 units rather, and then also looking back at the history, the 2008, we never received a notice of knowing what was going on at that point in time, and trying to figure out, basically we just realized what the scope of everything that had gone on, that we'd never received any idea of notice that was occurring.
And did the association receive notice any of those years you mentioned?
2008, they did.
Not in 2022?
Okay, so the first part of your testimony was that you personally as a homeowner didn't receive notice, and the second part is that the HOA.
I'm sorry.
Okay,
Yes,
I'm gonna need Mr. Young for you to make those distinctions for me, okay?
So did you personally receive notice those years?
No.
Did the association receive notice in 2008 or 2022?
Based on the documentation we got from the county that was submitted to the county from the applicant as to, at that point in time, the applicant doing the DRI amendment as to who they mailed notices to. We reviewed those documentation and all the addresses of individuals receiving it. I did not receive one. The HOA association did receive one.
And how far is your unit? And
I'm going to object again.
Okay.
This also is beyond the purview of your powers. This is outside the scope. I know where it's going. They're wanting to, negate based on lack of notice, which if it were for our particular project and it was lack of notice, absolutely. If he had not received notice for this hearing, then
Right,
absolutely.
right, okay.
But that's not what we're talking about. We're talking about previous approvals that are already vested and set in stone. So I would rather we just move on from this.
All right, so Mr. Young, by what authority how do I have any authority to determine whether the DRI development orders issued in 2008 or 2022 were invalid?
Your Honor, this goes specifically to the underlying potential, what is available to the applicant in this process here. So if there are fundamental flaws with the 2022 or 2008 ordinances that would invalidate them, that would impact specifically on the ability of their application here to meet the qualifications of the development order and compatibility and to move forward. Moreover, it establishes, for the purposes of the record, is we are here standing for any potential future legal challenges to a court that can address this more fulsomely, because as the Renard case for special injury dictates, standing and special injury has to be demonstrated at this level if it can be appealed to the court. And so not allowing special injury to get on the record fully could implicate the due process rights of Mr. Owens and the other client.
Okay, but I agree that if there was some problem with the 2008 or the 2022 development order amendments, not if there were a problem, if they were invalid, that it absolutely affects the amount of development available to the applicant. What I don't agree is that I have any jurisdiction to make those determinations. I believe Mr. Tatum said it earlier in response to my concern about something I thought he was trying to get me to do, that it's the wrong forum. I mean, certainly an administrative or quasi-judicial proceeding is not the appropriate forum to take up the validity of prior development orders. And even if it was, I don't know, I would imagine, the window for challenge that is probably well beyond, but that's not for me to determine. So if you would like to very quickly tell me what testimony you wanted to elicit from this witness as a proffer, could do that, because if that's what you're concerned about, laying a foundation for a subsequent proceeding or an appeal of this, although I just don't, I think that an appellate court would say I had no authority to make that determination. Anything else from me? I saw Ms. Davis jumped up there, so.
I would tend to agree at this point. The best operating procedure would be to proffer what testimony was intended, because I'm concerned of a potential hearsay issue, that also the lack of expert qualifications on some of these things, that from what it sounds like the path that we were going down. So I think a proffer would be the most appropriate at this time.
So we have thus far, Mr. Tatum, anything else?
I would just add that the Renard standard is special injury as a result of the approval itself or of the proposed project itself, not of previous
Errors in
correct.
prior decisions. Yeah, I agree. Okay, so we have some factual testimony thus far. Didn't receive notice personally, and that the association didn't receive notice of the 2022, but did of the 2008. So if you would care to make a proffer of what other testimony you would have expected to elicit from this witness.
Yes, Your Honor. So testimony related to the notice requirements of the county, specifically a mandatory requirement of 300-foot mailed notice be delivered to property owners who own property within that 300 feet, as well as exhibits related to that, sections of the Land Development Code related to notice, as well as the lists which are marked as Exhibit 11, 43, and 44, which are lists procured through public records request and through publicly available data of the notices that were sent, demonstrating that Mr. Owens, as well as Ms. Kajanik and the Owners Association did not receive notice in 2022. We also, Exhibit 16, which is a grid which demonstrates what we think is the error of how notice was delivered, which is they're measuring 300 feet on a grid on the property appraiser's website, and their unit is outside of what the straight measurement would say is 300 feet, but it doesn't represent accurately what is actually 300 feet. In addition, exhibit, sorry, let me grab it here. Comprehensive or composite exhibit 6, which is the development orders that have been passed historically, as well as composite exhibit 14, which are the notices of proposed changes. These again relate to the issue Mr. Metcalf addressed of previous development orders and vesting rights. And those would all, we expected to get in relation to these previous development orders. Testimony relating to the fact that the density on that corner parcel, that subparcel A, the what they call it, the southern corner of the Echelon property, that the density was moved off for a parking lot, and that it was the density on that specific section of the property was never moved back. So it was, while the whole parcel is vested for development, that corner does not have any density for dwelling units purposes.
Before you summarize, let me make sure I have the exhibits you're proffering. You are proffering exhibits 11, 44, 16, 6, 14, and I know I missed one in there.
6, 14, 43, 44.
3, okay. Thank you.
And Your Honor, there are a couple questions here about notice related to this specific development order, which I will be asking if.
Okay, the development order we're here about today?
Yes.
Okay.
Mr. Owens, do you own your Surfside property?
I'm sorry. No, yes, I own it.
How long have you owned it?
We purchased in June of 2002.
And is that your homestead?
No.
Do you use it as a rental property?
No.
And are there any outdoor facilities at your complex?
Yes, we have a two-story north, what we call the north garage, which borders the Seascape property, about 110 feet from the Echelon property line. And on top of that is our sports stack, which contains a couple basketball courts, tennis courts, pickleball courts, shuffleboard, and just a general area to kick around in for kids.
And what is the approximate proximity of your unit to the development site?
Probably somewhere between 250, 280 feet.
And the association's property?
Probably 80 feet where the corner is where our dog run is outside. Next to our north garage, we have a dog run that runs to the back of the property. And that back corner is probably about 80 feet approximately from the corner lot line.
And Mr. Owens, did you, during this process, procure any architectural renderings related to this project?
Yes, we did.
Your Honor, those are what have already been introduced as Composite Exhibit 17, the Titan renderings. We would also ask that note Exhibit 30, which is an affidavit from the architect who developed these, demonstrating the technique he used. Mr. Owens, if you can turn to Exhibit 17 in your book right there. 17 should be back there. Yeah, that's him. And Mr. Owens, from your review of those renderings, what was your reaction when you got those?
It was shocking as to the how enormous this building was and its location to the surrounding us 100 feet, but to the other buildings, Sea Cabins, Summer Place, Mirabar Villas, and the fact that how close it was to the property lines and would be, the height would be on top of us.
And what impact do you expect the project will have in both the building itself and the 60-foot wall parking garage have being that close to your property?
Well, I mean, the most immediate thing is just we're concerned with the construction, the piles, however they drive them, affecting our north garage. It's concrete, affecting the footers and the substructure there, as well as during construction. We're concerned about our sports deck, which is, like I said, it's about 110, 120 feet from there, with construction dust, debris. Will people be able to utilize that during construction, the kids? And then also our dog run, which is in between our garage and the next property, which is Sea Cabins, but it runs back, is open to the back, close, about 80 feet from the property line. Will that be able to be utilized as well?
And does the association have any concerns?
Association, yeah, has the same concern with the obviously the sports deck for our guests and owners, safety there. The dog run as well. We also have a grilling area there. They're concerned about that. And then the vibrations, the garage. They're also concerned considerably about that there was no real operational safety study done, because right now the traffic in Scenic Gulf Drive is a nightmare. Sorry, if you live down there, and no one's really come to, I mean, even though I know they're vested for their trips, everything has changed in that world, and the traffic is just to the point where it backs up constantly trying to get into the property.
And does anyone any member of the association rent their property?
Yes, quite a few people in our building do rent, and that was the other concern, was the loss of rental value during construction, but also too on our entire east side of the building, there's going to be some reduced because of the size and the way this building lays out on the property from east side, completely from the east to the west side of the property. It's going to diminish the bay's current views of the bay, which will diminish some of the property values for the east side.
And during the development process, did the developer ever talk to you about building the tower or the 60-foot wall in that location?
Your Honor, I'm back. He's delving into property values, noise, potential noise issues, potential vibration issues. I understand that his association is concerned about these matters, but as far as him offering testimony on those, he is no expert, has not been qualified as an expert in any of this, is not an expert in any of this discussion. So I would object to that line of questioning testimony about anything that has to do with a particular expertise that requires an expert opinion to be rendered.
Okay. I haven't yet heard any opinion testimony. I've heard what his concerns are based on his observations, really, and I assume it all goes to standing.
Yes,
or whatever foundation you're trying to lay here. So I'm not overruling your objection. I'll sustain that I'm not going to accept opinion testimony from him, but I think we haven't gotten there yet. You may proceed.
Mr. Owens, during the development process, has the developer ever talked to you prior to these hearings and such about building the tower or the 60-foot parking structure in that location?
After we found out by happenstance what was happening with the technical review committee, I believe they did come in, and it was the developer, I think Mr. Griffith, I believe Mr. Eubanks was on the Zoom, they were on Zoom calls, and I believe a Realtor had come in and talked to our board briefly on it, but only on the detail of what they were doing, and no specifics.
And did you receive notice of the planning commission meeting on this development application?
Not original, no.
Did the association?
Yes.
And
yeah, I did not receive notice, and that's what kind of triggered this was our association did, and about 9 other individuals within the building received notices, and we were trying to figure out what was going on. And then that's when we went behind our building and noticed that there was a sign about the planning commission meeting, because it wasn't posted on the right-of-way. It was posted on the private property with the entrance. And so we began trying to figure out what was going on and figured out why we didn't get notice. And then we were attending that next planning commission meeting to relay our concerns about about the error that went on in the notification process, and that the majority of our owners and other owners didn't receive notice as to the planning commission meeting and couldn't actually be there to express their opinion or thoughts.
And did you receive notice for the Board of County Commission meetings related to this project?
Yes, we did, because after our initial meeting at the planning commission that got continued, we had the planning commission was continued to the following months or whatever next scheduled commission, and they sent out a supplementary notice to everyone in our condo building at that point in time. And since that time, they've sent notices out as far as to everyone in the building on the Board of County Commission meeting.
And did that notice you received provide any architectural renderings similar to the ones you procured?
No, it just had the site plan, which I call a linear type plan, where it's just laid out on paper and shows kind of the diagram on the lot if you're looking down on it. And then the other document was just where the map of the area.
So then how did you first learn about the building and its size and orientation?
Once we got that, we started delving into the county's intergovernmental portal, pulling down the staffing reports where we got and could look at the documents that had been filed by the applicant in there with the building, which had the site plan. And then there were various architectural drawings, and one I think has been shown as an exhibit today. I don't recall. It showed the each floor and how high that floor would be to the total height of the building of 314 feet. And that's where we realized that the first 5 floors of the building, the first floor all the way under the building were the parking area. And then on the 5th floor was the open lanai with the swimming pool. I believe there's spas and maybe a restaurant up there too.
Mr. Owens, did you own your unit in Surfside when the 24-story Sterling Palms Tower site that we have heard mentioned here today was submitted its first application?
Yes.
And Your Honor, at this point, I'd like to point to Exhibits 4 and 5, which are the application and the site plans, which have been mentioned previously, I believe. Did you review those? And you can turn to 4 and 5 in your notebook if you would.
This one?
Oh. Should be this one right here.
Okay.
No,
Maybe
nope.
I think it's this one.
Here, this one.
Oh.
There we are. Third time. Okay. And did you review these site plans during your research for this hearing?
Yes, part of the public records request, we pulled these out and we started looking them over and reviewing them.
And is the orientation of that plan different or similar to the plan here?
It's different, much different.
What are the major differences you've noticed?
Well, one of the biggest...
Again, objection.
Yes, sir.
One, not relevant at all. Prior development approvals don't matter at this point for our particular parcel. And also, he's not qualified to testify as to what is different about the plans from a planning perspective. But mostly, this is a relevance issue, and prior approvals not relevant.
Mr. Young, what's the relevance?
Your Honor, this goes to a little bit of what we've talked about here of the previous developments and what's been going on and the compatibility of the building and the visual demonstration of where the building sits on the property doesn't require planning expertise to know that it's further north than south. And it goes to generally his concern that the Echelon project now is far closer to their building and poses more concerns than the previous projects proposed in this.
So is Sterling Palms the one that was proposed but never finalized, and the owner never signed it, no development order was ever issued?
That was the 2023 subdivision application, I believe. Sterling Palms also was not finalized, but or didn't go through to completion, but it was in a slightly different procedural posture.
All right, I still don't. Yeah, I still don't see the relevance. I'm going to sustain the objection. You can move on.
Mr. Owens, were you aware of the developer's previous option here from the 2022 development order to build either a 24-story tower or a 32-unit subdivision?
Once, again, by happenstance, I'm walking my dog behind our property on next to Ariel Dunes parking lot next to the Echelon property, and we saw the sign notifying us of the technical review committee meeting, and at that point in time, we went and looked at delved into the records of the county and noticed they were seeking approval for the 32 homes, and that's the first time we'd ever heard of that. And we didn't really know why they were doing it at the time, other than they were doing it.
And would you have the same concerns with a subdivision, single-family residential subdivision, as you have with the tower?
No.
In addition to those concerns that you've raised here thus far, do you have any other concerns based on your research of this project?
Well, like I mentioned, our concerns are mainly the potential damages to our building, the use of our recreational areas, the privacy issue, as I think Mr. Cerner had mentioned too, given the fact that the 5th floor is going to be open to pool areas. And then also, we're very concerned about the operational safety standard, traffic flow coming into Scenic Gulf Drive, that no one had looked at that whatsoever recently, I think since '07. And what impact that was going to be just in traffic backing up on old Scenic Gulf Drive.
Thank you. Your Honor, at this time, I'm sorry, for the proffer of the notice issue and the density issue that we discussed earlier, I just looked at my notes and I forgot to mention Exhibits 18, which is a summary chart of the notice, because the notice documents, as you see in your folder, are like hundreds and hundreds of pages. And Exhibit 37 is just the notice that was sent in 2022. So I wanted to make sure those are noted as well.
Okay, so the opposition has proffered exhibit, I'm going to say them all, okay? 11, 44, 43, 16, 6, 14, 18, and 37. Okay.
And this time I don't think I have any other questions for Mr. Owens.
Ms. Davis, do you have questions for this witness?
I do not, Your Honor. I do want to, our clerk informed me that at 4:45, we will have to take a break to restart the recording system. Our recording only lasts for an 8-hour period, and then the system has to be restarted. So we will have to break at that point.
And when do we have to end while we're on that? I mean, what are the rules about, the county's rules about the use of the building, or, you know, personnel after 5 o'clock? I mean, I'm not in charge of this. This is not my building.
That's to a large regard, that would be your discretion. There's nothing for it. Typically, there's another meeting that comes after this. That meeting is not occurring tonight. That meeting happened earlier this week. So the room is available, and as long as
I don't have the authority to order Walton County employees to stay here after 5 o'clock, or the sheriff's department to stay here after 5 o'clock. That's really what I'm getting at. So I would feel uncomfortable saying we're just going to continue and the employees for Walton County have to stay here. That's, I mean, the attorneys can stay, right? So do you want to take that quick reset break, and maybe the 3 of you can talk? How about that? Let's do that. All right, let's take that reset break. Thank you.